Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. A cupcake sweet and sassy. Not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Good morning, my friends. Thanks so much for coming and hanging out with me. Today is Wednesday, April 9th, 2025, and we're in the second coming of winter here on the East Coast. It's like 30 degrees out today. And I just would, at least the sun is out, right? So there's that. Good morning. Good morning. The jury wasn't coming in until 10:30, so I pushed this to 10:30. I had linked an interesting Boston Magazine article in the chat. For those of you who hadn't seen it, we had read it during the pretrial stuff that we went over in this case, in the Tuerk case. And it has a little bit more backstory in it, other than the stuff that the jury was allowed to hear about. So I found it interesting. I thought you might find it interesting as well. 2 inches of snow on the ground in upstate New York. Trooper Paul's pirouette. My goodness. The volume also seems to be a little bit better today on Law and Crime. So we got that going for us. Also, so what's going to happen today is Harry Tuerk is back on the stand. He's still under cross-examination. After that, they're going to do closings. They had a little chit-chat with the judge earlier I was watching. And closing arguments are only going to be 40 minutes in total. The state, the Commonwealth is going to have 25 minutes. And the defense says their closing is only going to be 15 minutes. So it doesn't seem like it's going to be a very long day, except that they will take a lunch. They'll have jury instructions, and maybe the jury will come back today with a verdict. It'll be interesting. So I thought what we would do before court starts, let me just put the fan up because I know people get anxious. First of all, I think I'm losing faith in humanity, because I was in the Law and Crime and just watching the chat, and I'm just horrified by some of the things that people are saying in the chat. I don't know what to say. I don't know what to say. Based on, if these people are the mere jury, the average people that would sit on a jury, I am frightened for humanity. I really, really am. If you've seen it, but it's disturbing. It's really disturbing, in my opinion. All right, so I thought what we would do is we would talk about the jury instruction on first-degree murder, because Harry Tuerk is charged with first-degree murder, which carries the life sentence, I believe, in Massachusetts. There is no death penalty. I saw some people saying that he should get the chair, but there is no death penalty in Massachusetts. And understand this too. What a good attorney does is they take the jury instructions and they prep their client according to the jury instructions, right? It's kind of like working backwards when you're prepping for trial. So here's the jury instruction in Massachusetts for murder in the first degree. And we're going to read through it, and you can tell me what you think, if they've proven it or not. There's no question that he committed this crime because he confessed. He confessed. It was a recorded audio, 3-hour statement that Trooper Kukowski did when Harry was in the hospital. I'm looking at the ceiling in the court and I'm like, somebody needs to spackle and paint that ceiling. It's a mess. Look at that. It's really upsetting me. All right. Uh, I'm going to make it bigger for you so you can see what I'm talking about. What is happening with this ceiling? Look around the ceiling fan. Ugh. Come on, Norfolk County. You seem to have lots of money for false persecutions. The least you could do is spackle up that ceiling. My goodness. Okay, here's the charge on first-degree murder. Murder in the first degree. There are two different degrees of murder: murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories, and then they list the theories that are applicable to the case. And I think in this case, it is going to be either murder with deliberate premeditation or murder with extreme atrocity or cruelty. To find the defendant guilty on this theory of murder, you must be unanimous, that is, all the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory on which you agree unanimously. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. So we'll see what the specific jury instructions are here. And then if they don't charge second-degree murder, then they go on to say, and if you don't find them, if you don't find him guilty of second-degree murder, you move on to manslaughter. So we're going to see what the lesser includeds are here, what they have agreed to, or what the judge has agreed to charge when we get to jury instructions. I will begin by instructing you on the elements for each of these theories of murder in the first degree. I will instruct you on murder in second degree. Okay, and then it depends on the case. So it's case specific. Okay. So this is what murder with deliberate premeditation. This is the jury instruction on that. I will first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1, the defendant caused the death of Katie McLean. Well, we've got that because he admitted to it, right? 2, the defendant intended to kill Katie McLean. That is, the defendant consciously and purposefully intended to cause Katie McLean's death. That may be where the jury has a split, or they're going to be like, no, he was a doctor. He knew exactly what he's doing. He grabbed her around the throat. And in fact, somebody pointed this out in the comments, and you guys have eagle eyes. Remember yesterday when he demonstrated and he just put out the one hand in front of him and he said, I went like this. And yet the Commonwealth wanted you to believe that he took both hands and strangled her with both hands. But he did, when he went to demonstrate, and use just the one hand. Number 3, the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Number 4, the defendant did not act in proper self-defense or in the proper defense of another. Number 5, in addition to these elements, the Commonwealth must also prove that there were no mitigating circumstances. And then it goes on to say, I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Katie McLean. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. And this is just an example of what the jury instructions are going to sound something like. They may have tweaked them a bit. The second element is that the defendant intended to kill Katie McLean. That is, the defendant consciously and purposefully intended to cause Katie McLean's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill, second, the decision to kill, and third, the killing arising from the decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. And then there's another interesting instruction here. In deciding whether the defendant intended to kill the victim and whether he formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by his consumption of alcohol or drugs. A defendant may form the required intent and act with deliberate premeditation, even if he suffered from a mental impairment or consumed alcohol or drugs, but you may consider such evidence in determining whether the Commonwealth has proved these elements. So you remember, Kevin Reddington is a pretty seasoned attorney. It's not his first rodeo, right? Did you intend to kill Katie, Harry? No, I didn't. I didn't intend to kill her. And then he also had him talk a lot about how much he drank, how he blacked out, how he didn't remember anything. And it's going to be up to a jury to decide. The jury is the finder of fact. 12 people are going to have to be unanimous on it. Narcissism isn't a mental defect, says Harry Potter's beard. So premeditation doesn't mean that he had to take days or hours or, months while he was sitting in Florida in that luxury trailer park that had a pool, by the way. He could have decided in a couple of seconds. I think my personal opinion is that after that testimony yesterday, I'd be like, yeah, lock him up. Lock him up. When he was asked by the ADA, Kitty was a devoted mother, wasn't she? And he just looked at her and said, most of the time. I lost it. You heard me lose it. Drop the F-bomb. I don't do it often, but when I do, I do. He couldn't even give it to her in death. He couldn't even say she was a devoted mother. What does that have to do with whether or not you killed her? You killed her. You admitted to killing her. Could you at least throw her a bone after murdering her? At least say, yes, she was a devoted mother. That just really upset me to the point where I'm a mother. Many of you in the chat are mothers. I think my audience is something like 75% women. I would personally be offended by that. Really? You killed her. You can't even say she was a devoted. It was just repulsive to me. And a lot of people saying, yeah, I think he snapped. But can't you say that for everyone who commits murder? They snapped. Remember Carly Gregg? We covered the trial of Carly Gregg. She was, I think, 15 years old or 14 years old. She was on antidepressants. She had a really rough life. Same thing, the panty, all that stuff. She snapped. She snapped, in my opinion. It may have been because she was being weaned off these antidepressants at 14 years old. She had an abusive father. It was like a whole horrible story. She went into the bedroom, got a gun, and shot her mother. Couldn't you argue that she too snapped? She's 14 years old. She was tried as an adult in Mississippi, and she is sitting in prison for life without ever having the opportunity for parole. That is shocking to me. And when I see people out there in the law and crime world defending this 58-year-old man, doctor, surgeon, oh, he just snapped. She pissed him off. She deserved it. She was trying to take his money. She tried to take his house. She's done this before. She's done this to a lot of other guys. It's disturbing. Yeah, Christina, it's disturbing. But here's the thing. It's like, is this just the people that are, this is the victim blaming going around as gross period. Is this what the average person thinks? Or is this just the average troll on YouTube who thinks this way? I honestly don't know the answer to that. And that's frightening to me. It's frightening to me that there's 12 people on the jury that could be thinking that way. Admittedly, I come into these cases with my own life experiences, just like we all do. And for decades, I represented victims and survivors of clergy SA, DV, sexual harassment, and all kinds of other horrific things. And I was, the advocate or the attorney for, on the civil side, the plaintiffs, the victims, the survivors. And so I've heard all the stories. And I've heard and worked with, have had the privilege of representing many a victim / survivor. And there's a pattern, there's a pattern. There was somebody that called into Turtle Boy's show last night. Many of you were talking about it. Many of you wrote to me about it. I listened to it a little bit. It was disturbing.
For the jury?
Yes, Your Honor.
Yes, Your Honor. Okay.
I'm never going to always side. I don't always side with the woman. That's not true. That is absolutely 100% not true. So I'm not sure why you think that. I don't know how long you've been watching my channel, but that is 100% not true. So I don't know where you're coming from with that. I pick cases that I'm interested in, that I think are interesting. Karen Reed did not hit John O'Keefe with a car. I don't pick the side of Karen Reed because she's a woman. Don't start with me this morning. It's too early. We haven't even seen Harry take the stand yet, for Christ's sakes. You haven't seen it any other way yet? Okay, then move along if you don't like it. You don't need to stay here. Nobody's keeping you here, big old dog. Nobody's keeping you here. Nobody's forcing you to watch. Exactly, Peggy. He doesn't act remorseful. I think he shot himself and he chopped his whole foot off yesterday. That's my opinion. Depends on who the jury is. You know, Aiden looks at things from a different lens because he's been falsely accused, right? So if you have people on the jury who have been falsely accused, they're going to, you know, I am cold. I know it's cold. They're going to look at things through their own lens. I mean, everybody comes into a case with you don't leave your common sense at the door and your personal experiences at the door, right? But that woman who called into the show.
Hear ye, hear ye, hear ye.
Hold on.
All
God save the
persons having
Commonwealth.
anything to do before the Honorable Judge Hallal, Justice of the Norfolk Superior Court, now sitting in Dedham, within and for the County of Norfolk, for the transaction of criminal business. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts and this honorable court. This court is now open. You may be seated.
God
For
save the
record,
Commonwealth.
before the court is Commonwealth versus Ingolf Tuerk, 20 CR 138. The parties are present. Our 16 jurors are present. The matter is on for trial.
Okay. All right. Good morning, jurors. Good morning, jurors. Thank you for being prompt again.
Yay, Judge
Was everybody
Hallal.
able to follow the instructions that I gave you at the end of the day yesterday? Yes. All right. Anybody who was not able, please raise your hand. Okay. No hands are being raised. We'll continue on with the trial. Does Mr. Tuerk want to come back up?
Okay, so the woman who called into Aiden's show last night, this is what tipped me off.
Good morning, Mr. Tuerk.
Hold on, I'm just going to pause this for a second because I got to get this off my chest. And is my volume okay and your volume okay? The woman who called into Aiden's show last night, apparently he met her in court yesterday. First of all, she didn't show her face on camera, number one. Second of all, she called in and she said, and she mentioned, oh yes, you know, I reached out to you a couple of years ago or however long ago about another story. Okay, like she wanted to be involved in this. And then it turns out, allegedly, that the woman who called in is the ex-wife of Katie McLean's second husband. Okay? She has children with Katie McLean's second husband. So first she was married to Steve Rocca, Katie, whom she has her 3 children with, who may be watching, and my prayers go out to you today and Katie's entire family. Then she was married to this other guy, and I forget his name, but it was the ex-wife of that guy who called into Turtle Boy and seemed to take glee in trashing Katie McLean. Seemed to take a certain amount of glee in trashing her and saying all kinds of horrible things about her. And after I heard that she had already called Turtle Boy a couple of years ago about another story, as if she wanted maybe him to write a hit piece on somebody else, it was very obvious to me what her motivation was in doing this. And I found it to be repulsive and gross. And so that's my story on that. And he, you know, he runs his channel a different way and I run my channel a different way. And we both, you know, respect each other's way of doing things. I would not have given that woman a platform. He did. That's his choice. But I found that woman to have an ulterior motive. And so it made me think, yeah, women throwing other women under the bus like that. Like, I don't understand why she wanted to get on there and just spill all kinds of alleged tea about a woman whose children are watching her murder trial right now. Like, it just didn't seem to me like an honest or smart, or like she just wanted to be involved in it somehow. It was like salacious. It was kind of, I don't know. Oh, no, there is no such thing as a perfect victim. There's no such thing as a perfect victim. But like, I don't understand why a person would do that and feel the need to do that. But that's just me. All right, Harry's getting back on the stand. Here we go. And so I take it with a grain of salt.
Could you just raise your right hand again?
Oh, sorry.
Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Her children are now 16, I think 20 and 21. No, wait. 23. Okay, wait. At the time, they were 13, 17, and 18, and that was 5 years ago. Do the math. Thank you.
All right, yesterday when you testified on direct examination, did you testify that Katie initiated the reconciliation of your marriage?
No, I did not.
Okay, so you initiated the reconciliation of your marriage, right?
I formulated the letter after I was informed that there is interest on the other side to come back home.
You were informed by whom?
I believe by Kurt Funensteel.
All right, and did you say yesterday that there was a text message?
No, I said it was a phone call.
Out of the blue, a phone call, Kurt texted you out of the blue?
Well, I don't know about out of the blue. He called me.
He called you and you weren't expecting the phone call?
He was my friend, so I'm not sure if I'd expected or not. He called me at some point in time and mentioned that she is missing the family. She's missing you. And
And that's what made you write the letter?
that was one part. There was certainly another part in there involved.
When did Kurt call you?
I believe on the same day or the day before. I'm not 100% sure.
Same day or day before when?
When I wrote that instruction to Attorney Hoffman to reach out to the other side.
All right, but you're aware that Kurt sent you text messages in March that you didn't answer, correct?
I do not recall that.
You recall Kurt sending you a text message on March 19th, Harry, where are you? I hope you're doing well.
Again, I do not remember specifically the message. I know that we were in touch from time to time.
Okay, Kurt would check on you while you were at your various locations after you left 29 Valley Road.
Occasionally he would check on me, yes.
Okay. And then on April 17th, he texted, Harry, please let me know that you're okay / alive, right?
Again, I do not recall specifically all that messages, but we connected in April, as I mentioned, and I started the process of reconciliation.
You may.
All right, so handing you your communications with Kurt, I'd ask you just to look at page 15, or we can look at all the pages at once.
Okay, this is the last thing I'm going to say. Jay Haig says, look at us attacking a woman we don't know. We don't even know who this woman is. She called in anonymously. She didn't show her face on camera. So we're not attacking her. I'm just saying, why would someone feel the need to do that? We don't even know who it is. She didn't say her name. She didn't show her face. We have no idea. All we know is that she claims to be the ex of Katie's, I guess, second husband. And then she said maybe they weren't even really married. I have no idea.
Text messages?
I do.
So I just take those back. So you texted Kurt on the 18th.
I texted Kurt on the 18th at 8:14 a.m., correct?
Can I show that back? And that was in response to his text message to you on the 7th.
Yes.
And on the 18th, you expressed to Kurt that you were having a hard time finding places to stay and the situation was stressful, right?
Yeah, I said I am barely alive. I'm extremely concerned and worry about a safe place to stay because I had to leave the camper in 2 weeks.
All right, but you had already had your attorney send a letter to Katie, right? At that point in time.
Not sure what exact time frame that was or day.
The letter that Attorney Hoffman sent to Katie's lawyer
If you would show me that letter, please, I would recall better. Again, I don't recall exact dates. It was somewhere in the middle of April.
His demeanor has certainly shifted, hasn't it? Harry's.
Could we have a minute, please?
Yes.
They were whispering about something not being in evidence. Let me just fast forward a little bit.
Yes.
You see the date on that?
Yes, Friday, April 17th, 2020.
And you resumed texting Katie at the end of April, is that fair to say?
She started texting me. And then we started texting back and forth, but she initiated.
She initiated.
Yes, ma'am.
And you texted about situations in terms of the pandemic and kinds of shopping deficits there were, right?
Well, to understand the context, we had a phone call before initiated by Kurt Fenstiel.
I'm not talking about who initiated what, all right? I'm just talking about the topic of conversation that you and Katie covered in your text messages. So you texted about how you couldn't find toilet paper, right?
I believe so, yes.
Couldn't find bleach.
Yes,
There were bars you wanted that she was gonna help try and find in Massachusetts. There were a lot of different topics that were covered, right?
correct.
And contained in those also were topics including expressions of love, right?
Correct,
By you and by her,
correct.
all right? And in fact, at the end of April, Katie thanked you for wanting to get back together. Thank you for reaching out and repairing this, right?
Correct.
What just happened to the feed? Hello. What just happened to the law and crime feed? Anyone? Hold on a second. Well, Twilight Zone 913 is here. Thanks for your 20. So I started this late, not a troll, but definitely think she snapped and definitely think that she wanted money. Definitely no. Above all, she didn't deserve to die. And to be honest, I was more on manslaughter before he started talking. He is gross. I felt the same way. I felt that, let me just see if I can, I don't know, law and crime just quit on us. It just says it's unavailable. Something went wrong. Okay. Video unavailable. This video is private. Why are they kicking us out? Let's go to law and crime and see if they had to start another feed. Oh,
Let's talk for a little
okay, it's back.
about what happened in the bedroom.
Thank you, Twilight Zone, for your super chat. And also, Josh, I'll put that back up in a sec.
When you grabbed Katie's neck with one hand, you were on the floor, right? That's what you're saying?
At the time that she struck me, I was kneeling on the floor and begging her to stop.
So I'm asking about the point in time when you put your hand on her neck. Were you still on the ground at that point in time?
I was coming up from my kneeling, grabbed her with one hand and used the other hand to protect or to check on my bleeding. Yes, I came up from my kneeling position, reacted to the threat of being struck.
So you were standing at that point in time?
I would say it was half standing toward the standing, probably. I don't really recall all that. I was pretty drunk.
All right, we'll talk about.
He's pretty
I'll talk
drunk.
to her later, but I'm just trying to understand what you
Remember the jury instruction on being drunk. He's gonna milk that for all it's worth.
remember now about her position.
Well, I
You
could.
were half standing, half kneeling. Katie was on the bed. How was she positioned?
She was sitting on the bed edge, as far as I remember.
And what was happening with her hands?
She had, as far as I remember, a phone in one hand and a glass on the other hand.
And she continued to hold the phone and the glass?
At what time?
As you were strangling her, she continued to hold those items?
No, she struck me with the glass.
Well, she struck you with the glass first, and then you reacted to that, right?
Correct.
So that had already happened.
Sorry, what?
That had already happened. So the glass wasn't in her head and in her hand anymore, right?
That's what I was trying to say, but you said she had her glass in her hand. That wasn't the case at that time anymore.
Dude, your attitude is not helping you. Your attitude is not helping you. Dolph Lundgren, your attitude is not helping you. I mean, is anybody picking up misogynist here? Do you think he's being disrespectful to this ADA because she's a female? Because that's what I'm getting from him. As a woman who's, been around a couple of men in my life like that. Anybody else? Wow.
Her, what was happening with her hands?
I don't know what I was trying to say, but you said she had her glass in her hand. That wasn't the case at that time anymore.
So as you were strangling her, what was happening with her hands?
I don't know if I strangled her. I said I think I choked her.
Are you distinguishing between choking and strangling?
All I'm saying is that I really don't know what I exactly did because I was drunk and I was in a fight and flight reflex. So I really don't recall much extra that I really grabbed and tried to protect myself and defend myself.
Do you remember putting your hand?
Now he's using his own expert witnesses theory, right? The fight or flight response. He's tossing that in there too. And also, I'm going to generalize now. Guys like him with the word salad semantics, choking, strangling, very specific in the word choice for a reason. I bet he's a Virgo. I'm just saying. Hold on. Yeah, he's quoting his expert. Yep. Hold on.
Reflex. So I really don't recall much extra that I really grabbed and tried to protect myself and defend myself.
Do you remember putting your hand, at least one hand, around her neck, right?
I said I think I grabbed her.
I'm
Defend
asking
myself.
What you're saying right now, not what you said in the past. I'm asking right now.
And I blacked out from the struck. I was assaulted at this point in time and
Assaulted.
I reacted and I believe I grabbed her.
When you blacked out, are you saying you passed out?
No, blacking out means that I didn't really recall what I was doing. I reacted to a threat.
So
I snapped.
Oh, he snapped. He didn't faint. Blackout, faint. Blackout as in drunk blackout? Blackout as in I snapped. I don't remember anything because I blacked out. I'm glad that she asked him that question because we're getting a little more into his state of mind. And I know I'm annoying by rewinding, but I need to hear that again. And I think we all should because 12 people are going to decide whether he's going to be convicted of first-degree murder. And I really don't think he's helping himself here at all.
Believe I grabbed her.
when you blacked out, are you saying you passed out?
No, blacking out means that I didn't really recall what I was doing. I reacted to a threat.
So
I snapped.
okay, so the glass hit your head. You snapped. You had a flight or flight reaction.
Correct.
And you just reacted. I'm sorry, you said something else that I just forgotten. You blacked out.
I snapped.
You snapped. What else are you attributing to the glass hitting your head?
Fight and flight reaction. I was afraid.
And you said yesterday you were afraid of having to leave 29 Valley, right?
I was afraid of Katie too,
You didn't say that yesterday.
because you compared that to
One
physical,
at a time, one at a time.
sorry, to phy-
Yesterday you said you weren't afraid. You said you
Because-
were afraid of 29 Valley, of having to leave 29 Valley.
I was afraid of Katie too, but not in the physical sense that you try to explain, but it's not about being bigger or stronger sometimes, it's about who has the power. And she had all the power after I signed everything over I had to her, and I was very afraid of her, with her intentions and her reactions. I was very afraid of Katie.
That was a shift in your relationship, right?
There was a massive shift.
I'm sorry, does anybody believe him? This is no shade to Virgos. Virgos are meticulous in their word choice. Am I wrong? He was really afraid of her. Does anybody buy that? Is anybody buying that?
In the relationship that she had massive leverage over me, yes. But yes.
All right. So at the point that she hit the glass in your head, she didn't have the glass in her hand anymore, right?
I don't think so.
So she had a phone in one hand.
At the time when she struck me, I don't remember or I don't recall what happened with the phone later or the glass, because it was all one blurred reaction to being hit.
Did you get on top of her?
As far as I remember, when I came out of my blackout, she passed out very quickly. There was no fighting, really, as far as I recall. But when I came back out of what the hell happened, we were both on the floor.
She passed out very quickly. Yeah, she was dead. You're looking at a man trying to save his own ass and doing a really horrible job of it, in my opinion.
Because we kind of slid off the bed and fell on the floor.
Were you on top of her?
I don't recall that.
Where were your hands when you were both on the floor?
I don't remember.
Were they around her neck?
Not sure.
Is it possible that you were slamming her head on the ground and that's how she got the injuries to the back of her head and her brain?
Well, we heard yesterday that wasn't trauma related.
I'm not asking about Dr.
Wow.
Posada's opinion. I'm asking about your testimony about what happened. And you have some gaps in your memory. So I'm trying to make sure that we understand exactly what you know happened and what you don't know happened. So is it possible that you were on top of her with your hands around her neck, slamming her head on the ground?
I do not recall.
She also just got him because did you have your hands around her neck, slamming her head on the wall, on the floor? He doesn't recall. So he could have been choking her or strangling her, whichever word he prefers to use, as if either one is better than the other, with both hands, because he doesn't recall, right? Picking up what I'm laying down. Paralegal says, I buy it in the desperation sense. He was losing everything. Doesn't excuse it, though. But doesn't that go to premeditation even more? The way that he testified, well, the only way for me to get back into my house was to sign the deed over to her. Doesn't that show more premeditation? Because he knew that if she was gone, the house would revert back to him. How he thought he wasn't going to get caught, I have no idea. But I think some people might think that, yeah, he was desperate. Therefore, he's been thinking about this for long. He's been ruminating in that luxury trailer park in Florida with the pool that wasn't open. The victim was a Reiki master, but according to him, she didn't do real Reiki. She was a medium, he says.
Is it possible that she put her hands on your hands in an effort to remove them from her neck?
There were no defensive wounds on Katie and no defensive wounds on me, so no.
Wow.
I'm asking what you know about what happened.
Not that I recall. There was no struggle, no fight as far as I remember. I reacted to the hit. I felt threatened. I defended myself. And once I kind of recalled that I kind of came somewhat back, but I was still very intoxicated, we were both on the floor. And she was unresponsive.
Ms. Gilman, can we please have exhibit number 57?
Yes. He keeps saying self-defense, self-defense. I was afraid of her.
Dr. Tuerk, I'm going to put exhibit 57 in front of you.
Please.
Yes.
Do you see this mark right here on your hand? On your finger?
On the middle finger, you mean?
Yep.
I see that mark, yes.
Isn't it possible that that's from Katie's fingernails?
No. Because there were no skin cells under her nails in the
I'm asking
forensics.
about your memory, sir, not about the forensic evidence.
It's not possible.
You turn to 59, please.
59. I have it.
Please. Do you see these injuries right above your thumb?
Yes,
Isn't that possible? That's from Katie's fingernails?
they were from the bushes I walked through, not from Katie.
How does he remember that part? Taz, I'm gonna direct you to. I pinned a link in the chat to a Boston Magazine article that gives a lot of backstory on why she got the restraining order. They weren't allowed to bring it up at this trial, but I think it's going to help you understand. Summer Fridays, I said that. I said if I was the
And those were
prosecutor,
documented by the police, right?
I believe so.
And that cut on your head, the police took efforts to document that, right?
Correct.
You have the lights back on. All right, let's talk about what you did after you killed Katie. You carried her out of the house, right?
More direct after? No.
Didn't say direct. Just said after you killed Katie, you carried her out of the house.
After a while, I carried her out of the house. Correct.
how does he remember that part?
Past the children in the bedrooms, right?
I carried her on my hands in the hallway, downstairs, into the garage.
And the children were home.
Past the children in their bedrooms.
They were in the bedrooms. Correct.
Down the stairs,
Yes.
into the kitchen,
Yes.
into the mudroom,
Yes.
into the garage.
Yes.
And you put her in the Jeep.
I put her on the passenger seat of the Jeep.
Ranger Joe, I love men. He says, I understand why men don't enjoy your channel. You hate men in general. Just my opinion. Not true. Not true at all. I hate narcissistic assholes. But the true crime audience is typically more than 80% women. So I have more men on my channel than most true crime channels. Just saying.
And then you drove to the pond at 1 Francis Street.
Correct.
We have exhibit 133. You drove her there, right?
I don't think I drove with the Jeep exactly there. That's right on the water. There were bushes. You couldn't drive there.
There was too much brush, but that's the pond that you drove her to, right? In that photograph in 133?
I put her in the pond on 1 Francis Street, yes.
You had been there previously.
Excuse me?
You had been there previously.
I was there 2 years before, looking at the house because Katie asked me to, because she wanted to possibly buy another house.
It's Katie's fault that you know about the pond?
Excuse me?
It's Katie's house that you know about the pond. It's Katie's fault.
It's Katie's fault that you knew about the pond because she took you there to try to get you to buy her a house. Kit Kat says, didn't she have restraining orders on all three of her husbands? I don't know. It didn't come into evidence. I'm not aware of that. What I can tell you from my decades of working with victims of domestic violence is that they often choose partners who abuse them because that's what they're familiar with. And that is a pattern that repeats itself. And so even if she did have restraining orders against all of her three husbands, does that mean that they were not abusive? Right? I mean, there's two ways of looking at that. Either if you think she was gaming the system on the one hand, for what purpose, I don't know. Because I don't know anything about the financial situation of both her ex-husbands. But I think the first one, was he paying child support? Did he say that he wasn't paying child support? I don't remember. So, I mean, women who find themselves, and men, because men are abused too, seem to repeat that pattern and find themselves time after time in abusive relationships. So I'm not sure that goes to one side or the other, but that stuff was not allowed into evidence.
Fault that you know about this pond?
That Katie what?
It's Katie's fault that you know about this pond?
I didn't say that, no.
My question was that you had been to 1 Francis Street previously.
Correct.
Ask the people in the chat. The chances are pretty good.
You knew that it was for sale. Could we have exhibit 309, please?
Yes.
JK Sneakers 22 says, what's the chances of that happening, though, that all three were abusive? Well,
So you knew it was unoccupied.
Yes.
if anybody watched, I hate even to bring up the movie, It Ends With Us, but it's a pattern. I will just tell you from my decades of experience of working with women who find themselves in these situations time and time again, is that they may have grown up in homes where one parent was abusive to the other and that was their normal, and they grew up thinking that that is normal and that's comforting to them. And unfortunately, very sadly, there's a very high chance of that. And I think people in the chat will tell you that. It's disturbing. And if you are not aware of those statistics, then consider yourself lucky because unfortunately, it happens, Why didn't she just leave? That can be a whole other show for another time. But the chances are pretty good because abusers know who to target, We can talk about that another time, but unfortunately, I just want to tell you that chances are pretty good.
Pulled all the way up.
Sorry?
You pulled all the way up next to the house?
I do not remember exactly how far I drove into that property. I don't know.
You told the police in the interview that you pulled all the way up, right?
I was struggling with memory when I gave that interview.
All right, should we get the transcript?
Doesn't bother me. But some people don't be mamas. Some people just need to understand because a lot of people do not understand the cycle of abuse and why women just don't leave or men just don't leave.
Thank you.
It's not always easy for these people to leave. But now he doesn't remember what he said during the statement because, he was out of it still. This is the defendant, Shay. This is the defendant, Dr. husband, yes. You know what? I'll put Doctor on the banner. Thanks for reminding me.
Can I just a minute, please, Your Honor?
Thank you, Norman. Welcome, be our best, Jess. Welcome. Thank you on top. Tracy Fagan says, from personal experience, my nephew was falsely accused. She admitted she lied. From that moment on, I've become, show me the evidence. Sorry, no, don't be sorry. That's your personal experience. And if you were sitting on that jury, that would be in the back of your mind. Thanks for your super chat. Josh says that he heard the interview. She was just slandering Katie. Everything she said was irrelevant to what Dr. Tuerk did to her. Thanks, Josh. The sober hipster has become a member. Welcome. Welcome. Alcohol played a big role in this too. Speaking of sober, congratulations. One day at a time. We're a little tiny bit behind, so we'll FF while the ADA gets her act together.
One more minute, please.
Yes.
Certainly you'd agree that you didn't want to be seen putting Katie's body into the pond, right?
That wasn't a concern of mine, I believe.
That wasn't a concern of yours?
I didn't think about all that, no.
Well, he was only in his boxers,
You thought
remember?
about where to put her, right?
I was thinking about not having her being found in the house by her children, yes.
And you decided that the pond was the place to put her.
It took me a while. I was in panic. I couldn't really remember much of anything that happened, and I tried to figure out, where to go.
Or if it was premeditated, he knew he was going to put her in the pond because he remembered, because they looked at that house to buy it. That's how he knew there was a pond, and he knew it was not
Look at page 75.
sold yet. It was still vacant.
That's where you're talking about the garage, right?
Yes,
Did you park up by the garage or did you park down closer to the pond?
here I'm saying right there, and then that's the garage. I don't know what I mean with that,
Okay,
because I was confused.
you were confused. Perfect. But you were able to give accurate directions to the pond, to the police, right?
I had no recollection of the street names at that time, again, showing that I was confused. I just told them right, left, because I couldn't remember the street names.
But you knew the names of the street ordinarily?
I did, used to, but not at that time. I was completely out and confused.
You were completely confused when you were speaking to the police?
Well, there was a lot of confusion, a lot of shock, a lot of grief. I just went through a trauma myself. I mean, it was a very traumatic event. I just was in shock.
Oh, it was really traumatic for me. Really traumatic for me. I had just been through a really traumatic event. What about her children who are sitting here watching this trial? How traumatic do you think it is for them that 5 years ago you took their mother's lives? That her two daughters will not have their mother at their weddings. And neither will her son. But you know what, Harry? It's all about you. All about you and your trauma. I'm horrified by this guy's testimony. Wow. I don't know that he seems well prepped for cross. He thinks he's the smartest guy in the room, and I would have him show some emotion if you were my client, but even on cross, this is revolting.
A lot of shock, a lot of grief, but not
Listen.
at that time. I was completely out and confused.
You were completely confused when you were speaking to the police?
Well, there was a lot of confusion, a lot of shock, a lot of grief. I just went through a trauma myself. I mean, it was a very traumatic event. I just was in shock.
The event was
Murdering.
traumatic to you.
Yeah, I didn't like to cause death of another human being. I spent all my life to save lives. So I was pretty much in shock myself of what happened. Yes, I was extremely sorry and guilty and shameful about what happened. Yes, I struggled with that throughout the whole interview. That's why you see all this, I don't know, I'm sorry, I don't know. I was struggling.
Let's go back to what happened on the, after you killed Katie, all right? You took her out of the car regardless of where you parked. And you traveled through all of the brush and the greenery around the pond, right? We have
I do not recall the botanical stuff, but I walked through brush to the pond, yes.
Well, you just said the marks on your hands were from the brush.
Yes, yes.
Talking about this in 315, right?
No, there were also bushes a little higher. I remember that there was a lot of resistance as I walked through.
And certainly the police documented that in their pictures as well, right?
That's where my scratches likely came from, yes.
And you had boxer shorts on.
Yes, we had sex, and I put the boxer short on. Is all I had on at the time of the event, the tragic event, and later on, correct?
All right. And you're saying that you didn't take Katie's shirt off.
I do not recall, no, I didn't take it off. I don't even remember that it was off.
Did you put her pants back on after you had alleged sex?
So I mean, showing you what's been marked as Exhibit 308. Is this her tank top?
I believe so.
Is this what she was wearing when you killed her?
I think so, yes.
And I understand that you weren't able to look at the picture in Exhibit 146, but you're aware that there's a picture of that shirt on a tree branch, right?
I was told that that was on the tree branch, yes.
Okay. And certainly you didn't want a shirt ballooning up and helping Katie float, right?
I had no intention to think any of that. I just wanted to put her away.
Well, you said yesterday that you were concerned about her floating.
I just wanted to put her
I did
away.
not say that.
I just wanted to put her away. Hold on.
Ballooning up. And certainly you didn't want a shirt ballooning up and helping Katie float, right?
I had no intention to think any of that. I just wanted to put her away.
Well, you said yesterday
Put her away.
that you were concerned about her floating, right?
No, I did not say that.
So you said yesterday that you put the rocks in her after you noticed that she was floating, right?
I put her in the water as far as I recall. Again, remember that I had a lot of intoxication and I was struggling with the whole situation that I was extremely upset about myself. And as far as I remember, I put her in the water and I was kind of surprised she was floating.
Okay, so you were upset about yourself and you were intoxicated, I understand that. But when you put her in the water, did you push her out?
No, I was very careful with her. I just walked into the pond. I walked into the pond and put her gently down.
You walked into the pond and you put her gently down. And then did you turn around and walk back out to the shore?
No, I was looking and seeing she did not go underwater. As far as, again, I remember, and I was kind of, well, why isn't she going down?
Why isn't she going down?
You didn't want her to be discovered, right?
It wasn't really a concern of mine. I was going to kill myself.
But then why did it matter whether or not she wasn't going down?
Again, I was not really capable of rational thinking at that time. Sorry.
Well, if you didn't want someone floating, putting rocks in them would be a good idea. You'd agree with me about that, sir. right?
bought rocks. I stumbled over them by accident looking for something to wear her down.
But you were looking for something to weigh them down, and you didn't put leaves in there, right?
Again, my rational thinking was massively impaired. I didn't think about any leaves or anything that you're suggesting. I just looked for something.
Well, I'm
that would wear her
suggesting
down.
it's rational. If you want to weigh something down, you use rocks. You agree with me about that?
Again, you are assuming that I was fully capable of cognitive behavior, which I was not.
I'm not making assumptions, sir.
You see how the jury instructions we read, see how he was prepped on the jury instructions, right? He keeps repeating he was drunk. I was not able to think clearly. I snapped. Heat of passion. Like he's going for exactly what the jury's going to hear about. And that's the way that a good attorney preps their client. Not to lie, but here's what the jury's going to be instructed about. He just wanted to put her away. He just wanted to put her away or do away with her. And he stumbled on some rocks. Okay.
I'm asking you a question about whether or not it's rational if you want to weigh somebody down to use something heavy like 2 large rocks.
Again, I wouldn't call that, I would use the word rational. I wasn't rationally thinking because I was completely drunk.
Agreed.
Just reacted. I reacted to what I saw.
There's
Oh,
not,
dude, don't keep going. The more you talk, the worse it gets for you, in my opinion. But there are people in the chat who say, there's no excuse for murder, but some women play a game with them. Yeah, agreed. Agreed. That's what he's trying to show here. He's trying to show she was playing games with me. I only signed half my house over to her because that's the only way I could get in my house. But then I choked her to death, but I strangled her. I didn't choke her. But then I weighed her body. I just wanted to do away with her or put her away, he said. So he put her in the pond. He drove there in his flip-flops and his boxer shorts. And then he stumbled on some rocks. So I think the fact that, yes, if people think she played games with him, doesn't that go more towards premeditation, though? Because he's stewing in Florida in the luxury trailer park, thinking about this for a long time. And he's getting angrier and angrier and angrier until it culminates in this alleged evening of fun and games and board games and drinking and Sons of Anarchy and sex. And then she smashed him with a glass in the head, allegedly, and looked at his phone and got mad that he was texting Katie Kelly. And then he was so afraid of her that he just choked her, and then she passed out and he blacked out, and then he took her body to the pond. I don't know. I feel like it could work against him, right? In my opinion. But it depends on who's sitting on the jury. Depends on what those 12 people think. And he's had 5 years to practice his story with a good attorney, as
Just
Christopher points
reacted.
out.
I reacted to what I saw.
there's not a question before you, sir.
So I just wanted to, sorry.
I just wanted to keep talking.
You got the rocks. Where was Katie when you got the rocks?
She was still in the pond.
Did you go get her and bring her back to the shore? Or did you bring the rocks to her and stick the rocks in her pants while she was in the water?
I believe I brought the rocks to her.
And then she went down a bit, right?
Correct.
So then you walked back to the Jeep
Yes.
and you drove back to 29 Valley Road.
No,
You didn't drive back to 29 Valley Road?
not at that time.
Where'd you go?
I drove to the hotel first, or on the way to the hotel.
You drove to the hotel all the way?
No,
Partway.
partway.
How far'd you get?
I have no recollection again. I was completely out.
All right, you never
'Cause he
been back
forgot his
before,
phone.
have you?
I believe I said that I was on my way to the hotel, and I recognized that I didn't have my phone because I wanted to say goodbye to some friends.
Okay. So you realized that if you wanted to accomplish the task of saying goodbye, you would need to have your phone, right?
Again, subjecting what you're assuming I had a lot of rational thinking going on. That wasn't the case. I just saw I didn't have any communication device, and I thought, let's go back and get my phone.
Because you understood that you could use the phone to communicate with people.
I'm not sure if I understood that, but I wanted to say goodbye, and I didn't have any tool for it.
Okay. And you understood that your phone was at your house.
I assumed.
Right? It seemed like a logical place to look.
That's correct.
And you changed into your jeans, right?
Well, I didn't change. I didn't have much clothes on except my boxers.
You put your jeans on.
Correct.
Because that made sense. When you were walking into the hotel, it would make sense to wear jeans.
I didn't think about that.
Okay. And you also picked up your wallet, right?
Was coincidentally that I walked by it and grabbed it as well, yes?
Okay. And you picked up a bottle of whiskey.
I don't recall that.
Well, when you were in the Jeep, you had a bottle of whiskey next to you, right?
I don't know how often I have to repeat that. I wasn't really thinking clear.
Oh, now he's annoyed at her. Now he's annoyed at her for asking him the question too many times. I don't know how many times I have to repeat that I was not thinking clearly. Somebody said, if he was completely drunk, Joanna, how did he drive there? Well, I don't know if you saw the testimony about the wedding, the drive-through wedding at the drive-through Elvis Chapel. He was so drunk when he drove through the wedding chapel in Vegas with Katie that he doesn't even remember getting married. So to this guy, drunk driving is like no big whoop. He does it all the time. Take that back. He's annoyed. He's annoyed at the prosecutor. What do you think the jury is thinking at this point?
And you also picked up your wallet, right?
Was coincidentally that I walked by it and grabbed it as well, yes?
Okay. And you picked up a bottle of whiskey.
I don't recall that.
Well, when you were in the Jeep, you had a bottle of whiskey next to you, right?
I don't know how often I have to repeat that. I wasn't really thinking clear.
I'm asking whether or not you had a bottle of whiskey. I'm sorry my questions seem repetitive, but if you listen to the question, you'll understand that they're
Ooh,
different questions.
she's schooling
Was
him.
there a bottle of whiskey next to you in the Jeep?
I don't know.
Do you want to see a picture?
If you have one, please.
Yes, the Jennifer McCabe School of Testimony. Jean-Paul says the guy didn't intend to kill her, and English is his third language, so he comes off as rude. Wait, are you sure English is his third language? Because I heard Broken Baker say that the other day, that English is his third language. But do you know Harry? Do you know that it's his third language? Or did he say that? Because maybe I missed that in his testimony. Do you have something you could show me? I'd like to see the picture of the bottle of Glenfiddich on my passenger seat.
That's a bottle of whiskey in the Jeep, right?
That's what the picture shows, yes.
All right. Was there always or routinely a bottle of whiskey in the Jeep?
No,
And the knife that's there, you said that was typically in the glove compartment?
or let's say, there was typically a knife somewhere in the car, mostly in the box, in the glove box, correct?
Did you take the knife out of the glove box?
I don't think that I did, or I don't recollect or recall any of that.
All right. When you were driving, were you drinking from that bottle of whiskey?
I have no idea.
I have no idea. But see, you testified earlier that you carried her body out of the house, even though her children were sleeping. They could have walked out at any moment, and put her in the passenger seat. Did you fasten her seatbelt around her dead body? Did you seat her on top of the knife and the bottle of whiskey? Just wondering.
I don't know.
Wait.
Whiskey?
Or any of that.
All right. When you were driving, were you drinking from that bottle of whiskey?
I have no idea. I don't know.
All right. But you left it in the car. You didn't bring it into the hotel with you.
The picture shows it was in the car, so must have left it there.
All right, and you drove back to Dedham.
I drove to the hotel to take my own life.
On some windy roads, right, sir?
I do not recall what kind of roads I was driving. I don't remember.
You didn't crash though, right?
That was a miracle, I think.
I'm sorry, I didn't hear that.
It was a miracle.
That was a miracle, I think,
Okay,
that I
thank you.
didn't crash, given the fact that I was completely intoxicated.
Well, why didn't, if you wanted to kill yourself, why didn't you just drive your car into a tree? Why take the trouble of going all the way back to that shitty, by the way, residence inn in Dedham, and getting a steak knife out of the residence inn cutlery drawer? And despite the fact that you are an actual surgeon, you made some half-assed little scrapes on your wrist. Tried to kill yourself apparently by alcohol poisoning, because when they picked him up, he was like in a coma. He was so drunk, and he thinks it was a miracle. Not to make fun of his accent, but just I can't with this man. I just can't.
Suicidal, right?
And suicidal.
Can you say it again?
That was a miracle, I think,
Okay,
that I
thank you.
didn't crash, given the fact that I was completely intoxicated.
Judge Stanley Tucci, don't you forget that he's here sometimes, and don't you forget that this is the case. This is the courtroom that Karen Reed was tried in the first time, and that is, for those of you just joining, that is Judge Mark Hallal. He's amazing. He sits in Norfolk Superior. This case had been assigned to Judge Beverly Canone, but it was taken from her and reassigned to Judge Hallal. He looks like Stanley Tucci. He's an amazing judge. Karen Reed's trial would have been very different had she had this judge.
And suicidal, right?
And suicidal.
But you didn't crash into anything.
I don't think so.
You drove to the correct hotel
Yes.
and you parked the Jeep in front of the hotel
I don't know where I parked it.
in a parking lot.
I do not know.
And it was between the lines, albeit close to the curb. We have exhibit 118.
Is my mic too loud?
That's the Jeep parked in front of the hotel, right?
It appears that way, yes.
When you say it,
All right, I'm going to turn it down a little bit. But Kelly, you're the only one who's complained, so usually there's a lot of complaints if it's bad for everyone. But let me just. I'm going to put it down to like 35%. See if that's better.
it appears that way. Are you uncertain?
I don't see the hotel really. I see a couple windows and a wall. I don't know if that's the hotel.
And so let's have the video exhibit. Ms. Gilman, do we have the second video from the residence in, please?
Okay, much better. Is it better? I'm here for you. Okay, I'm here for you. It depends on what you're listening on. Earbuds, TV. We have not heard a lot of sirens during this trial at all. You're right.
Can you pause it, please? That's you, right?
Yes.
You have something on your face?
I don't know.
Go back a little.
Liberty and justice for all.
Are you wearing a mask?
I have no recollection of that.
Were there rules that you had to wear a mask in the hotel during this time period?
In May 2020, I believe there was a rule.
And that's you coming in, right?
I don't know. It looks that way that I walk in, yes.
You have your jeans.
Remember we saw surveillance video when they had the residence inn manager or general manager on the stand? So there's video of him walking into the hotel. Why they're not showing it to us now, I'm not quite sure. Julie, Katie had Harry's phone in her hand because she grabbed his phone, and that's when she saw these text messages from this other woman that he says was just a friend. Oh, he said that she's just a friend. Oh, baby, you. Bismarck has entered the chat.
On your shirt, right?
Yep.
That's the jeans and the shirt that were introduced into evidence, right?
Yes.
Your belt?
I don't see a belt.
Press play. Were you able to see a belt in the video?
No,
Would it make sense you had a belt on?
probably.
Did it appear like your shirt was tucked in?
Yes,
You went through the front doors of the hotel, and you had to use your key card to get in?
I don't remember if that was necessary. I don't know.
And you went to the correct room, right?
I went to my room, yes.
It was at the end of that long hallway?
I have no recollection where it exactly was.
All right. And you took a knife to one of your wrists?
Sorry?
You took a knife to one of your wrists?
That's what, again, I do not remember that act exactly, but I have a scar on my left wrist.
You have a scar?
I have a scar here on my left wrist, yes.
All right. And the hospital characterized those marks as superficial. You aware of that?
No,
You didn't have any stitches or anything, right?
I do not know.
Were there any marks on your wrists that you were trying to cover up?
No, I wanted to kill myself.
No marks from Katie on your wrist?
Katie had no skin cells under her nails, so no.
Because you killed her so
Katie
quickly
had
she
her
couldn't fight back.
DNA on her nails, right?
I lived with her for 4 days, 24/7. It's natural to have some DNA on your hand.
Sure, sure. But she did have her DNA, your DNA under her nails.
I was all day with her, very much intimate. Yes,
All right. And certainly, Dr. Tuerk, you're aware that there are effective ways of slicing your wrists to initiate self-harm that results in death, right?
yes.
And you got back to the hotel, into your room, and you started drinking again, right?
I have no recollection of that. I do not remember how I got to the hotel or what I did in the hotel. I was drunk, really drunk,
And isn't it possible that you drank more in the hotel room?
certainly.
There was a bottle of whiskey also in the hotel room, right?
I drank basically all day, or not all day, but I started at 4 or 5 the night before and continued because I was really scared about what Katie was trying to do.
Well, you weren't scared when you first started drinking, right?
No,
That was just fun drinking.
sorry, what?
That was just fun drinking, right?
Yeah, she made martinis on the Cosmo and we sat on the back deck and had a couple drinks, correct?
And then you weren't scared when you were drinking after you killed her, right?
I was in panic. I was definitely scared. My anxiety?
Katie.
No, but I was scared.
Okay. And you woke up in the hospital, right?
Yes.
They had pumped you full of IV fluids.
I don't know what they pumped into me.
All right. And you woke up in the early morning hours, right? On Saturday?
Thank you.
All I know is I woke up and I was in the ICU. I don't know what the time exactly or what day. I actually asked the gentleman what day it is.
But it wasn't until later in the day that you spoke with the police, right?
I think it was somewhere around 5.
So it was 30 hours after you had been taken to the hospital by the ambulance that you spoke with the police, right?
I do not know when I was taken to the hospital.
All right. Does it make sense to you that it was around 11 in the morning?
I really don't know. I think I was passed out.
All right, let's look at the medical records. May I approach?
Thank you, Sharon, for your super chat.
All right. May I approach? Yes. So, if we look at your medical records, you agree that by noon, you're getting results from testing, right?
Results or
Texting?
orders
What is it, texting?
Results from testing
Test, I'm sorry, thanks.
by noon.
was on May 15, 2020 at 12 noon.
Okay.
Actually, it says 12, it doesn't say AM or PM.
Well, but usually hospitals take, document things in military time, right?
Well, they're doing tests 24/7. So it could be AM
It could be AM or it could be PM.
because there is no specification of afternoon or morning.
Do hospitals normally do test results in military time?
You better know
I
the
don't
answer to
think
this.
so,
You don't think so?
no.
Okay. Well, certainly you're aware that the police arrived.
Plot twist pending. Thanks for your super chat. I'm not sure if you sent another one because one of the mods told me that it was deleted by accident. Hopefully it wasn't, but if it was, just put another question in the chat and I'll get to it. The first super chat said, Melanie, men can wear flip-flops if we want. Equality for all men. I'm not a foot person. I don't like to look at people's toes. But I mean, sure, if you want to. Oh, and here's another one. The victim was crazy as reported by Turtle Boy. Yeah, right. Through an ex-wife of her second husband. We listened to it. It's not victim shaming to tell the truth. How do you know that that woman is telling the truth? That's my question. That woman called into the show. How do we know that she's telling the truth? And why was she so eager to get on there and say mean things about a dead woman that maybe she's got a personal agenda? I have no idea. She didn't deserve to die, but she was evil? Okay. And you're believing a person who called into Aiden Carney's show that he met in court. I'm not even, you know what, I'm not even going to address it. Like, thanks for paying me $10 to read it, but no, I'm not going there. We already discussed that at the beginning of the show. So, you know, thanks so much for your $15.
At sometime after 10 in the morning. Are you aware of that?
I think it was the afternoon when they arrived.
Where are my nurses in the chat or anybody who works in a hospital? Yeah. Don't they use military time for testing? Yeah. Or hospital records in general. Thank you. Be kinder than necessary. He literally was a surgeon in Massachusetts hospital. He should know it's military time, right? Right? Yeah. That's what I was thinking too.
You think it was the afternoon when they arrived?
I believe so.
Okay. Let's just do
Of-
one thing at a time. First of all, just so we're on military time, you see this test indication on the 16th at 16:25.
Yes,
All right, so Norwood Hospital is using military time, right?
to that, yes.
Yeah, okay.
I mean, Scott, if people want to keep, paying me money
May.
to talk about it, I'm not going to read the super chats though.
If you could just look and see,
Ridiculous.
that refreshes your memory about what time the Dedham police were called.
I don't know if that refreshing my memory is appropriate. I was unconscious. I was, I think, unresponsive, I was described. So that says here, what does it say here?
If it's not helpful, I'll take it back.
I don't know, what was the question?
If it's not helpful, I'll take it back.
Oh, my freeze game is on point. Thank you, What the Duck, for gifting 5 memberships. You're amazing.
But you agree at least that you were speaking to the police after 5 o'clock
I think it was around 5 o'clock, yes.
on Saturday.
Excuse me, so the tragic events happened on the 15th, I believe. The next day, yeah, 16, Saturday.
You killed her in the early morning hours, right?
I didn't intend to cause that.
Then you went back to the hotel. You were transported to the hospital sometime late morning on that
I don't know.
Friday.
I don't know what time. Again, I wasn't conscious at that time.
You agree you were transported to the hospital on Friday? You're not challenging that, are you?
If you're asking me what I remember is that I woke up in the hospital, so I must have been transported to the hospital, yes?
On Friday.
Yes,
And then you're speaking to the police after 5 o'clock on Saturday.
that's what it appears to be. Again, I asked them even what day it was.
And certainly you felt better after you told the police what you've done, right?
No,
You
I
didn't
felt-
feel better after you told the police
no,
what you've done?
I feel today terrible, never really changed. I'm so sorry about all that shit, sorry.
So sorry
I'm
about all
not
that
feeling
shit.
better, I never felt better about what happened.
I'm so sorry about all that shit. What shit? You mean murdering a woman?
Well, you asked me if I felt better. I did not feel better. I feel guilty and ashamed from day one, and I wish I could make it all go away. I mean, in terms of having a return.
That would be better if you could bring her back to life,
I would love to bring her back,
but you can't.
fortunately not.
And certainly you understood that one of the reasons that the police wanted to find her body was so that she could have a decent burial with her family, right?
Yes,
And you wanted to provide that as well, right?
yes.
And the police were right about that.
Well, I think I was right about that.
No further questions.
Wait a second. She said, so the police were right about that. He said, no, I was right about that. I mean, wow. Listen,
Certainly you understood that one of the reasons that the police wanted to find her body was so that she could have a decent burial with her family, right?
Yes,
And you wanted to provide that as well, right?
yes.
And the police were right about that.
Well, I think I was right about that.
wow.
No further questions.
Well done to you, sir.
Just a few.
Somebody said I gotta get the mute button ready for this.
Counsel was asking you about the circumstances of the blow to your head, the crashing glass on your skin, and then your reaction with your hand. You recall those questions?
Yes,
Question as to any statements or whether or not there's any conversations. Did she say anything to you at that point?
yes.
What did she say?
So get the fuck out of my house.
This is after the deed was signed, right?
Correct.
Did she say anything else about the car or the hotel?
Yes, she said a lot of things. She was yelling at me for
What did she
over
say
an
about
hour.
the car in the hotel?
About the car in the hotel. She said, get the fuck out of my house. And
Okay, hold on.
you can walk to the hotel because the car is
She was yelling at him for over an hour. I thought he had no idea about time, but now he knows she was yelling at him for an hour. Okay.
mine. The judge said so.
Now, I'm going to approach you with the phone dump that was performed of your phone and Ms. McLean's phone. Your phone, if I am correct, was 617-594-8962.
I have a hard time remembering after 5 years. I think it sounds right.
And you were obviously carrying the phone as Ingolf Tuerk, right?
Correct.
And Ms. McLean's phone was 339-222-9407, correct?
Correct.
And the two of you were texting back and forth, right?
Correct.
Now, have in mind the time frame council was going over would be, obviously, you met and the two of you lived together for 2 years, right?
Correct.
Then you got married for about 5 weeks, maybe 5.5 weeks, and then the divorce, right? Was implemented?
Yeah, I wanted the
Yes.
divorce because
Yes.
I wanted to move on.
Just answer my question.
Yes.
Reddington is like,
During
shut
the
up. Just answer my question. You're already tanking my case. You're already tanking my case, dude. Just answer my question.
Period of time you already detailed, and council asked about the trailers and all that. you stayed at a lot of places, right?
Yes,
And you were concerned about the pandemic and dying bluntly.
I was scared to death, yes.
During the April month, is that when Kurt reached out to you, your friend Kurt reached out to you on a FaceTime and had you speak to Ms. McLean?
That is correct.
And was that the time that, tell us what was said at that point?
I do not recall the exact conversation. It was a pretty lengthy conversation, but the essence is, Harry, I still love you. Come home. But there are conditions. You have to,
So you ultimately adhered to those conditions, correct?
I had to.
And you signed the deed,
I had to.
and you signed the post-nup,
I had to, yes.
and you heard the attorney and you saw the letters. You know, the attorney, your own attorney, advised against this, correct?
Yes, he said that's, you shouldn't do that.
But you did it anyway.
I was so desperate for a safe place to be that I did it, yes.
Did you really think during this period of time, April into May, that the two of you were going to be reconciling? Did you feel that things were going to be good, you guys were going to love each other again?
I kind of was hoping for it because I didn't see much other choice than going back home. I didn't have a place to stay. I
Now,
wanted to go back in my home.
counsel had asked you about the sex and the frequency and things of that nature, correct?
Yes,
Would you agree with me, sir, that there were a number of text messages where she would text you?
Objection is to form.
She didn't get the house. He signed it over to her in a post-nup, John
Just
Miller.
rephrase it, Mr. Reddington.
He's the
please.
idiot.
Sorry, Judge?
Just rephrase it.
Yes, thank you. I'm going to approach you with, this would be on May 5, 2020. This is a text from, let's abbreviate it, 9407 to Ingolf Tuerk, 8962. So that would be,
Can I just have a minute, please?
Yes.
John Miller, it's his house, yes, but he was reconciling with her. She wanted a post-nup. He signed it over to her. Again, that's what happened here. He signed it over to her. His attorneys told him not to, but he says he was so afraid that he had nowhere to live that he signed her over half the house so he could get back in the house. Make it make sense. Make it make sense. He could have gotten an annulment and his house would have been his. She had a restraining order against him. He wasn't allowed back in the house. I mean, there's a lot of things at play here.
that would be on page 1501, please. So I'm approaching you, sir, and handing you what appears to be a list of text messages from the Celebrate phone dump. Does that appear to be text between you and Ms. McLean?
yes.
All right, and what's the date of the text messages? Representative, just read that.
Here on this page, May 5,
So this is May 5.
correct.
Now, on May 5, had you actually started living back with her again? Are you still in the hotel, but you were
And May 5, I was in Florida still.
still in Florida?
Yes, sir.
Okay. At that point, you're telling the jury that she had indicated that she wanted you home, right?
Correct.
You guys are going to love each other again, right? Yes?
We tried.
Look on that text and see.
This one here?
There's an indication. May 5, 2020. You're on with the foundation of text from Reddington. Can that be brought up on the screen?
Could we approach?
Yes.
We're gonna FF. We're gonna FF a bit.
On May 5, 2020, there was a discussion between you and Ms. McLean telling you to come home. And then the next box says, and come home and have sex with your wife. Is that indicative of the type of text that you received from her?
Yes.
Now, in reference to counsel's questioning about the menstrual period and the blood that was on the bed, you heard the testimony from the DNA person and the crime guy talking about there was a round spot of blood on the bed, right?
Yes.
You were asked questions on cross-examination from the district attorney as it relates to the nature. No, didn't anybody wash the bedclothes and things of that nature, and showed you photographs of your washer and dryer, right?
Right.
On May 6th of 2020, page 1526, it would be text number 4074 through 4077, please. Do you recall receiving, let's write that, do you recall sending her texts referring to you to her? I will like you for the rest of my life. And the two of you are making arrangements for you to go over there and meet up with her on May 6th. Do you recall those texts?
Meeting up with her?
Yeah, over at the house, yep.
May 6th, I was still in Florida.
Okay. Do you recall her telling you to come home? When did you come home?
I drove back from Florida to
When?
Florida.
7, and then 8 I arrived in Massachusetts, and we went to the hotel and had sex.
Okay.
First thing, twice. She wanted it. And
recall-
then I
She
went home
wanted
on May
sex.
10th, sorry.
She wanted it.
May 10th, that's the answer. Do you recall on May 7th, that'd be page 1529, and she sent you a text, "Good morning, I am excited to have you come home safe." Do you recall that text?
Yes,
On May 6th, do you recall discussing between the two of you, your coming home and being with her?
yes,
You recall on May 6th would be 1526, discussing coming back together. You asked, what if you don't like me anymore? Strike that, I apologize. That was a text from Katie to you. What if you don't like me anymore? Your response, I love you, Katie, you are my wife. I will like you for the rest of my life. And then she responded, okay, well, I have my period now and most likely will still Friday, so not sure about sex. That was on May 6th in the afternoon.
I recall that.
It's a little TMI. Thanks,
And
John
one
Miller.
of the,
John Miller, just curious, and you don't have to answer this, but I'm just wondering if somebody screwed you over at one point in your life, if you got screwed over in a similar type of way, because we all come into, these cases with our own personal experiences. There's like major construction going on, like somewhere outside my window. So if I'm going to stay muted.
addressing May 9th, which should be right after the 6th. Do you recall her sending you texts, page 1541, was she texted you, "I love you, Harry Tuerk," last night was the very best lovemaking I ever felt. I felt so safe and connected to you, with you, thank you. I love you, etc. You blew me away, Harry, both times, but that second time you were all there, all in.
I recall that text messages, yes.
And in between the text messages and your feelings, state of mind that the two of you were going to be husband and wife, get back together again, did you have any knowledge whatsoever that Kurt, your friend, was having practically daily conversations with her, including asking to show him her boobs?
Objection beyond the scope.
Okay, overall, just a yes or a no.
I did not know.
Okay. Here comes Kurt back into the conversation again, including that Kurt asked her to show him her boobs. Let's take that back.
You were going to be, between the text messages and your feelings, state of mind that the two of you were going to be husband and wife, get back together again, did you have any knowledge whatsoever that Kurt, your friend, was having practically daily conversations with her, including asking to show him her boobs?
Objection beyond the scope.
Okay, overall, just a yes or a no.
I did not know.
He didn't
But
know.
nevertheless, one of the issues that
Here was the thing. I was saying from the beginning of this case, if that night he had just found out that she was texting his buddy, Kurt, and these text messages were going back and forth about show me your boobs, and then if she did send a picture, then I could see him snapping, right? Because it was like in the moment he saw that, and that I could see. But he says he didn't know.
was of import was the signing of the deed, correct?
That was very important to her.
You recall that she berated you about the fact that you sent the deed to your lawyer instead of sending it directly to David.
Objection.
No, overall.
Yes, she was angry with me that I delayed the arrival of the deed.
And ultimately, it was recorded, correct?
It was recorded actually on the day when the tragic events happened. It was one of her things. She yelled at me.
That's all I got, Ron, thank you.
Nothing further.
Okay, you may step down.
I'm sorry, John Miller.
See counsel, please.
I'm sorry. See, we all come into this with our own personal experiences, our work life experiences, the people that we've represented or we've worked with, or family members, or
Marijuana, he then,
growing up. All right, let's see what they're talking about now. We are a little bit behind.
on involuntary manslaughter, the court entertained. Court entertained the instruction on involuntary manslaughter as it dovetails into intoxication, citing, as I did yesterday, the Santa case. I know that Your Honor had responded about the Garabedian case, and I just would like to just point out, maybe Your Honor would reconsider that. I think it's absolutely totally different set of facts on the cases. Garabedian, and this is back in '87. I remember it like it was yesterday. The guy was intoxicated involuntarily because of pesticides that he was applying to this poor woman's lawn.
I mean, 87 was a really good year. 87 was a really good year for the Grateful Dead, too. He remembers it like it was yesterday. Don't age yourself, Kev.
She caught him urinating, and he was berated by her for urinating on her lawn, and he then, according to the opinion, strangled her, and then went far beyond the needs needed to inflict death. Her body is then on the ground, and he then proceeds to smash her head with rocks and boulders so hard that her head actually made an indentation into the ground, bleeding into the ground. He then picked up like a string from her sweatshirt and strangled her again. And of course, the SJC indicated that in that set of facts, the issue of voluntary intoxication, would not justify the doing of an act in a sudden sense that carries with it, unfortunately, the death of the person as a result, but where the defendant is intoxicated and his judgment is significantly impaired in that very brief act, that I go back to Santa, and I think that there should be an instruction on involuntary intoxication, so I just wanted to put that on the record.
Involuntary manslaughter.
I'm sorry, yes, involuntary manslaughter, thank you.
All right, the Commonwealth want to respond?
The Commonwealth maintains its objection from earlier.
Do you want to put anything else on the record with respect to Garabedian or Santa?
The Commonwealth would put on the record Commonwealth v. Linton, 456, Mass 534. That's a more recent case on manual strangulation, where the evidence, I would suggest, especially the medical examiner's evidence, was similar to this case. And again, the defendant's testimony and statements made yesterday that he, even in an intoxicated state, would know that cutting off someone's air supply via choking or strangulation would lead to death, Your Honor, would be the points the Commonwealth puts on the record.
All
Who
right,
sounds like
Mr.
George
Reddington, Your
Costanza?
objection is noted. I'm not prepared to give it based on the
Kinzer?
record and based on the arguments that both you made and the Commonwealth made earlier today and then just now.
And I think I have to renew the Rule 25 as well.
Okay, do you want to be heard on that again?
Waive argument.
All right, does Commonwealth want to respond?
No, thank you.
Okay, so I'm going to deny it for the same reasons that I did earlier. There's certainly enough evidence for a reasonable jury to find guilt beyond a reasonable doubt, and that's viewing the evidence in the light most favorable to the Commonwealth. All right, anything else?
No.
No, thank you.
Okay, I'll have copies for you when you come back.
Rule 25 motion in Massachusetts is a motion for a directed verdict, requiring a finding of not guilty based upon the evidence that the Commonwealth couldn't prove a case. It's made in every single criminal case. And he renewed his motion, it was denied. And so now, what are we doing now? Did they say? Well, we have time for some questions. Maybe they were taking their morning break. Next thing to happen is going to be closings. So let's go to some questions. Tracy, does the jury have to determine state of mind for first degree? I read the jury instruction earlier in the stream, so if you didn't see it, you may want to rewind. And we're going to listen to jury instructions again soon. There are several elements of first degree, but I don't want to take the time to go over them all again right now. But if you rewind, I went through it right at the beginning of the stream. Thanks, Tracy. Karen, thanks for the 10 to me. He was totally pissed. He had got himself into this position. He wanted her out of his life and he wanted his stuff back. He wanted to sell the house and then move to Germany. Sad. Yes, very sad. Yes, very sad. But was murder the answer? I don't think so. Thank you for your 10. GV, question here has been whether it was premeditated or if heat of passion defense applies. We all agree it wasn't justified, except maybe the doctor himself. That's right, GV. Hi, Lady Zelda. Me Googling his birthday and can't find it. Somebody said it's September, that he actually is a Virgo. And there was no shade to Virgos. Just saying that Virgos choose their words very carefully, as do narcissists. So, it was one or the other. Also heard Katie's a medium and helped many people. That's what I heard too. Because when they said yesterday, when they were on, I guess it was Cross, Katie was a Reiki master, right? And he said, well, no, not really. She said it was Reiki, but it really wasn't. She was a medium. And then he was asked, but she helped a lot of people, right? And he said, yeah, no. So, yeah, it's conflicting. But apparently she called herself a Reiki master. Thanks, Lady Zelda. And Megan Law Simple, what are your thoughts on the tone of the prosecutor? I do not like her tone. I think it's putting me off. Thoughts? Oh, I've seen much, much worse. Much worse. I don't know if you watched the Ashley Benefield trial, but those two prosecutors, they were like the evil stepsisters from Cinderella. Like, they were horrific. This one, nah, she's nothing compared to some other stuff that we've seen. So no, I didn't find her off-putting at all. But that's just me. You can see what the other people in the chat think. Kansas Sofa Jura, thanks for the 10. So drunk he was able to squeeze her into yoga pants, carry her, drive a car. Maybe she dressed herself. We're not sure about that. But yes, he carried her out, put her in the passenger seat, drive a car, dump her, and then notice she needs some rocks to weigh her down. Okay, got it. Yep. Yes, that's what he wants you, or at least the jury, to believe. Liberty and justice for all. I may be overthinking, but with anger and narcissism, I think he put her in the pond to make a last statement. Here, Katie, your new house. In my opinion, he toast. Possibly. Meatball Marcy Spaghetti Stain, thanks for your 5. I know this is morbid, but I missed the part that showed his wrist injuries. What direction were they? Down the street or across the road? They were down the street. A couple of little shallow cuts. They showed a photo of it, but we really don't know. The medical records, I don't think, were read into evidence. They were noted during the police. They took photos. You know, the police actually took photos in this case. Even like Trooper Kakowski, who was also involved in the Karen Reed case. I think he took some photos. Crime scene services came and they took photos. But I submit to you, he's a surgeon. Even though he was doing robotics recently, he still was trained as a surgeon. If he wanted to do it, he could have. Hi, Critical Conversations, HR. Any possibility of covering the Robert Brooks case in Oneida County? Correction officers brutally beat handcuffed inmate on camera. When is that trial? I'm gonna be I'm gonna be full up with Karen Reed for the next however long, unless by some miracle SCOTUS grants a stay of her trial, but I don't think that's gonna happen. It depends on when that is happening. I do not know. Plot twist pending. Thanks for the hunch. I'm a physician. Depends on the medical record system. Epic does, but not sure about other systems like Cerner, etc. Happy to support your channel. Well, thank you. Thank you very much. You're a physician, so you're smarter than the average bear. So I'm kind of wondering why you would believe it, an anonymous caller who calls into a show who blatantly said, oh, I called you a couple of years ago about another thing I wanted you to report on, and then continued to trash the murder victim. So that makes me even more curious. Thank you. But thank you for your 100. I'll allow it. Farty Marty, thanks. Do you think Reddington would have been a good attorney for Karen? I think Karen's got a great team. And I think Yannetti as her local counsel is the better choice. The better choice. Better-o. I would have liked to see Better-o on the team too. I know it's a conflict for Reddington because he represents Jennifer McCabe, so it can never happen. Thank you. What do you think? What do you guys think? It's a Michigas, and it really is. Isn't it a Michigas? Thank you, Kim, for tuning in from, looks like a Canadian flag, but it's American money, so I'm confused. If Katie were on the stand telling the same story, would we believe her? DV happens to men too. Not all physical, can be emotional. Just my thought, 100%. Happens to men, 100%. What if Katie shot and killed Harry during this event? What then? Would Katie be on trial for murder? Would Katie have a self-defense argument? I don't know. Remember, all the guns were taken out of the house because of the 209A order. He had a number of guns. They were taken out of the house. The firearms were gone. So, yeah, I don't know. Dan says, do they have any proof of the actual head wound? The picture he showed yesterday did not really show a wound. Yeah, it was like, well, here's my first thought, right? They never got into whether Katie was right-handed or left-handed, right? But he claims that during this altercation that they had in the bedroom, he was on his knees and he was looking up at her and she was sitting on the bed. If she's got the glass in her right hand and she goes to smash him in the head with it, she would have hit the left side of his head. The wound was on the right side of his head and it was a little wound up here by his scalp. It wasn't like a gash. It wasn't like she smashed him over the head with a bottle and he had like so I have questions about that. He said she had the phone in one hand, his phone, the glass in the other. I have questions. So we did see a little picture of what looked like a little cut to his head, but I don't know. Jeevy says Reddington is good, whoever he represents. However, I don't think big team is the best for his style. Oh yeah, like he prefers to work alone. I could see that. Chicky sort of says, I think those wounds were her trying to breathe desperately. Maybe. Bev, they met on Bumble or Fumble because some people think it's always a miss. But don't worry, I'm here all week. Trisha says she would have stood up. She would have been stood up and in his face, in my opinion. And Monj says it was a Band-Aid cut, big baby. I don't think they went to lunch, right? I think they're coming back after their morning break and we're going to go into closings. Jay, this did cross my mind a little while ago. Jay says, do you think he self-inflicted those wounds to work the self-defense angle? Maybe. Because remember, the police didn't speak to him. Okay, if he took her life on the 14th, right? I guess it was after midnight. Then he put her in the pond. They find him on the 15th. He's taken to the hospital in a near coma. They didn't interview him on the 16th, which is when he finally told them where her body was. So we had plenty of time to think about it. Although, he says he doesn't remember much because he was so drunk. Carrie says he had no stitches on his wrist. Patty, they said there was blood on the sheets because they had done the deed and because she had her period. That's what he says. So he says scalp injuries are known for bleeding fast, but also clotting fast. CK Bell said maybe the photo of his head wound was inverted. Oh, that could be. That could be. So I was watching Karen Reed's jury selection this morning before we came on, and there was a discussion at sidebar, which was very interesting to me, because they came up to sidebar, and Eliza Little had something in her hand that she was showing the judge. Everybody was up there, and they were up there for a little while, and then the judge said, okay, well, we don't need to talk about this now. We can talk about this later. It's not something urgent, so we're going to talk about it later. And so I don't know what that was. And I don't know if it's come out what that was or if they're going to talk about it later and, turn the cameras back on. We'll see. Let's see what Ted Daniel had to say about it. Done? Oh, that was 22 hours ago. Hang on. Ted Daniel of, I don't know what channel he's with, but whatevs, doesn't really matter. Judge Cannoni starts by bringing both sides to sidebar for a private discussion. Defense attorney Elizabeth Little appears to show her something, and then everyone returns to their seats. That's what you missed if you're watching the stream. There are 58 prospective jurors today, according to the clerk. Then he says, 2 hours ago, the judge says whatever issue was raised doesn't need to be dealt with now. She asked that the jury candidates be brought in. I think there's a panel of something like 58 new jurors today. They need 4 more. And then he talks about what's in the Yeti cooler. And I don't really know. I don't really get that joke. Who brings the cooler? Alessi brings a cooler every day? And he says, as requested, the Yanetti cooler contains Trader Joe's chicken breast, plant-based cheese, unsweetened applesauce, Alyssa's oatmeal cookies. David Yanetti is once again renting space in his namesake. And Alessi says his healthy eating is rubbing off on him. Let's have a good one. Trevor is here, and he says, so refreshing watching a professional judge who doesn't prohibit reasons for objections and doesn't question the witness. Yeah. Right in the courtroom next door, the same exact courtroom where Karen Reed's first case was tried and her second case will also be tried. Thanks for your super chat. Hi, Sandy. I'm so behind. I'm sorry if you already answered this. Doctor not having any money to get an apartment, didn't have a bank account. So I don't understand why he had to move back in with her. He had to pay $150,000 because of his Medicare fraud case. That may have depleted his resources a bit. He was also apparently very, very, very afraid of dying of the virus that we're not allowed to talk about on YouTube. But it begins with a C. And so I think he wanted to stay in his own home and not in a hotel. But yeah, I don't know, Sandy. He claims, even though they signed a post-nuptial agreement, which a lot of people didn't know is a thing. It is a thing. It's like a prenup, but you sign it after you're married. He said he signed over half the house to her because he had to, because he wanted to get back into the house. Sound's coming back up. Hi, Renee. Thanks for the 20. Melanie, it's important to point out that the pond Katie was dumped in is also in Kurt's backyard. What? I thought it was a vacant house that they looked at because they had the real estate agent on the stand. Renee? So, I don't know. Also, here's an interesting thing about Kurt Pfannenstiel. Kurt Pfannenstiel made case law. Somebody sent me the case law in his divorce. Apparently, he's the heir to some very serious fortune. And his wife wanted part of the trust that he was entitled to in their divorce. And I think originally the divorce, the family court judge, whatever they call it in Massachusetts, I don't know. Do you call your family court like probate court? I don't know. Our probate court here is for wills and estates. But Pfannenstiel v. Pfannenstiel is like one of the seminal cases of divorce law in Massachusetts. And eventually, on appeal after appeal after appeal, it was decided that no, the ex-wife was not entitled to get a portion of the trust that Kurt Pfannenstiel was entitled to because it was speculative and new trustees could be added or new heirs could be added at any time. So I found that to be quite interesting that Kurt Pfannenstiel apparently is loaded. So I don't know. Just point it out because, you know, we're here for all of it apparently at this point. Probate and family court is called probate is all, you have two different courts, probate, Gibbons family probate court and family court, or probate court is also family court. Oh, Jess Machado has very excellent updates. Let's see what she's got to say today. Oops. Let's see. 3 hours ago, she said, good morning from Norfolk Superior Court for day 9 of jury selection in the Karen Reed trial. David is the lone attorney here first this morning. She says, we've got 58 potential juries today. Let's see if we can seat the rest of this jury today. Haven't seen the Commonwealth yet. So they need 4 more. The judge is here. Court is in session. Canoni says counsel has asked to see her and they are at sidebar. While we wait, I should mention today is not day 9. At a minimum, it would be day 8, but Ted says it's day 7. I will not be counting days going forward. LOL. The defense has shown something to Bev, and after the sidebar, Little has gone over to the Commonwealth desk with her phone and shown it to them. Oh, they're coming back. Bev says whatever this is, it's going to take some time. Doesn't have anything to do with the jury.
Yes.
Sure. I have one.
Oh, just to get the clip versus the know for attorney is. I'll read it. I think it's okay now. Just don't walk over there.
It's all tape.
All right, hot mic.
Okay.
Thank you. So you guys can follow Jessica. What's her Twitter handle? It is
Okay. Can
Jess
you see
Machado
counsel at
Show.
Sidebar while they're coming in. Nancy, you all set?
Jess Machado Show. Kaylee says, forced to move out a camper into hotel. Can't kill her in the hotel because of logistics. Signs the post up despite lawyer's advice so he can get into the house, have access to her, and get his, quote, life back premeditated. I think some people might see it that way. I think some people might see it that way. Thanks, Kaylee, for your super chat. Bye, BG. BG says, got to get stuff done. We'll listen in. Thanks, Melanie Mods and friends in the chat. Y'all wicked smart. You're all wicked smart. Thank you, BG. Thanks for hanging. Thanks to you, 10. After closings, we'll do another poll. But yesterday, it was pretty even split between manslaughter and first-degree murder. So it'll be interesting to see what you guys think after Harry's performance this morning.
Welcome back. What I'm going to do is I'm going to hand out the legal instructions. You're each going to have a copy. You can put your juror number right on there when you get them. What I would ask you to do is not to read ahead, but read along with me. Please don't read ahead.
So they're going to do jury instructions and then closing, and he's giving them a copy of the instructions. I think Canoni did that too, right? But she said, I'm going to give you written instructions and oral instructions, but if there's a conflict, oral instructions are going to govern.
Counsel, you have them as well?
Yes, Judge, thank you.
All right, everybody has a copy? All right. So jurors, thank you for serving on this jury. You are responsible to uphold the law and our principles of justice. That is what you promised to do at the start of this trial when you took your oath as a juror. Don't be influenced by any personal likes or dislikes or opinions, prejudices, biases, or sympathy. You must carefully consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that the defendant is guilty of the crime charged in this case. The final part of this trial will take place in 3 steps. I'll give you instructions about the law for the specific charge in this case. Then the attorneys will make their closing arguments, where they will highlight the evidence that they think is important and will argue in favor of the conclusions that they ask you to reach. The defense attorney will argue first, and the prosecutor will argue last. Again, that is because the burden of proof is always on the prosecution. After the closing arguments, I'll give you general instructions that apply in every case. You'll then work together to reach a verdict.
Thank you, Midnight Mike.
Please pay close attention to my instructions, which you must follow, even if you do not agree with them. To make sure that I give you the instructions accurately, I'll read them to you. You'll also get written copies so you can refer to them in the jury room during your deliberations. So let's talk about the prosecution's burden of proof and the presumption of innocence. There is a fundamental rule that applies in all criminal cases. Every person who is accused of a crime is presumed to be innocent of that crime. All of us are entitled to that presumption under our Constitution. The defendant, Ingolf Tuerk, is presumed innocent of the charge in this case. That means you must consider the defendant to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented during the trial that the defendant committed the crime charged. I will explain what I mean by reasonable doubt in just a moment.
Please do.
The
Maybe you can read it
defendant does
twice.
not have to do anything to convince you he is innocent. He does not have to explain anything. He does not have to testify, call or question witnesses, or provide any evidence at all, because you must presume that he is innocent. Instead, it is up to the Commonwealth to prove the charge against the defendant beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you've considered all of the evidence carefully and fairly, if you have a reasonable doubt about the defendant's guilt, then your verdict must be not guilty. You may find the defendant guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So the burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. Now, since this case raises a question as to whether the defendant properly used force to defend himself from attack, I'll provide you with instructions concerning the law governing the use of deadly force in self-defense before discussing the elements of the crime of murder. A person is not
Okay. Oops. He's gonna go. Can you guys hear me? That's so weird. He's gonna go into self-defense now. What just happened to my mic? See, Midnight Mike likes me. He doesn't think I hate all men. Thank you, Midnight Mike, for gifting another 5.
guilty of any crime if he acted in proper self-defense. When I use the term proper self-defense, I'm distinguishing self-defense as both justified and proportional, and therefore a complete defense to the crime, from self-defense that is justified, but where excessive force is used. It is the Commonwealth's burden to prove beyond a reasonable doubt that the defendant did not act in proper self-defense. The defendant does not have the burden to prove that he acted in proper self-defense. If the Commonwealth fails to prove beyond a reasonable doubt that the defendant did not act in proper self-defense, then you must find the defendant not guilty. The law does not permit retaliation or revenge. The proper exercise of self-defense arises from necessity of the moment and ends when the necessity ends. An individual may only use sufficient force to prevent occurrence or reoccurrence of the attack. The question of what force is needed in self-defense, however, is to be considered with due regard for human impulses and passions and is not to be judged too strictly. The Commonwealth satisfies its burden of proving that the defendant did not act in proper self-defense if it proves any one of the following 4 propositions beyond a reasonable doubt. Number 1, the defendant did not actually believe that he was in immediate danger of death or serious bodily harm from which he could save himself only by using deadly force. Deadly force is force that is intended or likely to cause death or serious bodily harm. Number 2, a reasonable person in the same circumstances as the defendant would not reasonably have believed that he was in immediate danger of death or serious bodily harm from which he could save himself only by using deadly force. Number 3, the defendant did not use or attempt to use all proper and reasonable means under the circumstances to avoid physical combat before resorting to the use of deadly force. Number 4, the defendant used more force than was necessary. The defendant used more force than was reasonably necessary under all of the circumstances. I'll not now discuss each of these 4 propositions in more detail and remind you that the Commonwealth may satisfy its burden of proving that the defendant did not act in proper self-defense by proving any one of these propositions beyond a reasonable doubt. The first proposition is that the defendant did not actually believe that he was in immediate danger of death or serious bodily harm from which he could save himself only by using deadly force. The second proposition is that a reasonable person in the same circumstances as the defendant would not reasonably have believed that he was in immediate danger of death or serious bodily harm from which he could save himself only by using deadly force. In considering whether or not the defendant actually believed that he was in immediate danger of death or serious bodily harm and the reasonableness of that belief that he was in such danger, you may consider all the circumstances bearing on the defendant's state of mind at the time. Moreover, in determining whether the defendant was reasonably in fear of death or serious bodily harm, you may consider any or all of the following. Number 1, evidence of the deceased's reputation as a violent or quarrelsome person, but only if that reputation was known to the defendant. Number 2, evidence of other instances of the deceased's violent conduct, but only if the defendant knew of such conduct. And number 3, evidence of threats of violence made by the deceased against the defendant, but again, only if the defendant was aware of such threats. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of the effect on the defendant of his consumption of alcohol, in determining whether the defendant actually believed that he was in immediate danger of serious bodily harm or death, but not in determining whether a reasonable person in those circumstances would have believed he was in immediate danger. A person may use deadly force to defend himself even if he had a mistaken belief that he was in immediate danger of serious bodily harm or death, provided that the defendant's mistaken belief was reasonable based on all the circumstances presented in the case. The third proposition is that the defendant did not use or attempt to use all proper and reasonable means under the circumstances to avoid physical combat before resorting to the use of deadly force. Whether a defendant used all reasonable means to avoid physical combat before resorting to the use of deadly force depends on all of the circumstances, including the relative physical capabilities of the combatants, the weapons used, the availability of room to maneuver or escape from the area, and the location of the assault. A person must retreat unless he reasonably believes that he cannot safely do so. A person need not place himself in danger or use every means of escape short of death before resorting to self-defense. The fourth proposition is that the defendant used more force than was reasonably necessary under all the circumstances. In considering whether the force used by a person was reasonable under the circumstances, you may consider evidence of the relative physical capabilities of the combatants, the number of persons who were involved on each side, the characteristics of any weapons used, the availability of room to maneuver, the manner in which the deadly force was used, the scope of the threat presented, or any other factor you deem relevant to the reasonableness of the person's conduct under the circumstances. So let me talk about murder. There are two different degrees of murder: murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree by the following theories: murder with deliberate premeditation and murder with extreme atrocity or cruelty. To find the defendant guilty of murder on either of these theories of murder, you must be unanimous. That is, all the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory on which you agree unanimously. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt that the defendant is guilty of murder in the first degree or murder in the second degree, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of the lesser offense of voluntary manslaughter. So I will begin by instructing you on the elements for murder in the first degree. I'll next instruct you on murder in the second degree. I'll then instruct you on voluntary manslaughter.
How much more engaging is this judge than listening to Judge Cannoni? In your opinion? He's easy to follow. He seems interested in what he's saying. He's engaging. He doesn't seem like he's breathing heavily into the mic and couldn't be bothered to be there. Listen to the elements of each. Then we're going to do a poll at the end. Somebody asked about time limits for closing. No. However, the defense said he only needs 15 minutes, and the Commonwealth said they only need 25 minutes. So hopefully, after he's done reading these jury instructions, he'll let them close. Then they'll go to lunch, and maybe we'll get a verdict today. Because like I said, tomorrow I have a conflict, and it doesn't really work for me. So I'm hoping they come back today.
First degree with deliberate premeditation. I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. First, the defendant caused the death of Kathleen McLean. Second, the defendant intended to kill, that is, the defendant consciously and purposely intended to cause the death of Kathleen McLean. 3, the defendant committed the killing with deliberate premeditation, that is, he decided to kill after a period of reflection. 4, the defendant did not act in proper self-defense. And 5, in addition to these elements, the Commonwealth must also prove that there were no mitigating circumstances. I'll now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Kathleen McLean. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Kathleen McLean. That is, the defendant consciously and purposefully intended to cause her death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from the decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. In deciding whether the defendant intended to kill Kathleen McLean and whether he formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant was affected by his consumption of alcohol. A defendant may form the required intent and act with deliberate premeditation even if he consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved these elements. The next element is that the defendant did not act in proper self-defense. I have already instructed you as to the circumstances under which a person may properly act in self-defense. Finally, the Commonwealth is also required to prove beyond a reasonable doubt that there were no mitigating circumstances. The law recognizes that in certain circumstances, which we refer to as mitigating circumstances, the crime is a lesser offense than it would have been in the absence of a mitigating circumstance. A killing that would otherwise be murder in the first or second degree is reduced to the lesser offense of voluntary manslaughter if the defendant killed someone under mitigating circumstances. Not every circumstance you may think to be mitigating is recognized as mitigating under the law. In this case, the mitigating circumstances that you must consider are: 1, heat of passion on a reasonable provocation; 2, heat of passion induced by sudden combat; 3, excessive use of force in self-defense. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt that there were no mitigating circumstances. I'll instruct you on each of these mitigating circumstances in more detail later when I discuss voluntary manslaughter. Murder in the first degree with extreme atrocity or cruelty. Next, I'll define the elements of murder in the first degree with extreme atrocity or cruelty. You shall consider this theory of murder in the first degree, regardless of whether or not you find the Commonwealth has proved murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, the defendant caused the death of Kathleen McLean. 2, the defendant either A, intended to kill Kathleen McLean, or B, intended to cause grievous bodily harm to Kathleen McLean, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. 3, the killing was committed with extreme atrocity or cruelty. 4, the defendant did not act in proper self-defense. 5, in addition to these elements, the Commonwealth must also prove that there were no mitigating circumstances. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Kathleen McLean. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant, A, intended to kill Kathleen McLean, or B, intended to cause grievous bodily harm to Kathleen McLean, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, this second element has 3 sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Kathleen McLean. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the decedent's death. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant, it should say defendant there, was affected by his consumption of alcohol. The third element is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in any taking of human life. You must determine whether the method or mode of a killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's action in terms of the manner and means of inflicting death and on the resulting effect on the victim. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death of the deceased with extreme atrocity or cruelty, you must consider the following factors. 1, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2, whether the defendant's method or means of killing the deceased was reasonably likely to substantially increase or prolong the conscious suffering of the victim. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the three factors I have just listed. A murder committed by a single blow may be extremely cruel or atrocious where there's evidence of one or more of these three factors. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of the effect on the defendant of his consumption of alcohol in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killing with extreme atrocity or cruelty. The fourth element is that the defendant did not act in proper self-defense. I've already instructed you about when a person properly may act in self-defense. In addition to these elements, the Commonwealth must also prove that there were no mitigating circumstances. I've already mentioned that. I will instruct you on mitigating circumstances later when I discuss voluntary manslaughter. Murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of Kathleen McLean. 2, the defendant A, intended to kill Kathleen McLean, or B, intended to cause grievous bodily harm to Kathleen McLean, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result.
And he's a doctor. He knew she could die from that. He knew he was choking her with one hand right on her carotids, right? He knew. That's it. That's where I land. I think I'm landing on murder 2 right now.
3, the defendant did not act in proper self-defense. And 4, in addition to these elements, the Commonwealth must also prove that there were no mitigating circumstances. If the Commonwealth proves all the required elements, but fails to prove beyond a reasonable doubt that there were no mitigating circumstances, you must find the defendant not guilty of murder, but you shall return a verdict of voluntary manslaughter. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity or cruelty. Voluntary manslaughter. To prove the defendant...
Before we get into that, here's the difference. In Massachusetts, murder 1 is life without possibility of parole. Murder 2, life with possibility of parole after a certain number of years that the judge will determine at sentencing. So now he's talking about, I think it's involuntary manslaughter. Let's go there next.
Voluntary manslaughter. To prove the defendant guilty of murder in the first or second degree, the Commonwealth is required to prove beyond a reasonable doubt that there were no mitigating circumstances that reduced the defendant's culpability. A mitigating circumstance is a circumstance that reduces the seriousness of the offense in the eyes of the law. A killing that would otherwise be murder in the first or second degree is reduced to the lesser offense of voluntary manslaughter, where the Commonwealth has failed to prove that there were no mitigating circumstances. Therefore, if the Commonwealth proves all the required elements of murder, but fails to prove beyond a reasonable doubt that there were no mitigating circumstances, you must not find the defendant guilty of murder, but you shall find the defendant guilty of voluntary manslaughter. I'll now instruct you each of these mitigating circumstances. 1, heat of passion on reasonable provocation. Heat of passion includes the state of mind of passion, anger, fear, fright, and nervous excitement. Reasonable provocation is provocation by the person killed that would be likely to produce such a state of passion, anger, fear, fright, or nervous excitement in a reasonable person as would overwhelm his capacity for reflection or restraint and did actually produce such a state of mind in the defendant. The provocation must be such that a reasonable person would have become incapable of reflection or restraint and would not have cooled off by the time of the killing, and that the defendant himself was so provoked and did not cool off at the time of the killing. In addition, there must be a causal connection between the provocation, the heat of passion, and the killing. The killing must occur after the provocation and before there is sufficient time for the emotion to cool, and must be the result of the state of mind induced by provocation rather than by a pre-existing intent to kill or grievously injure, or an intent to kill formed after the capacity for reflection or restraint has returned. Mere words, no matter how insulting or abusive, do not ordinarily by themselves constitute reasonable provocation. Reasonable provocation does not require physical contact, but physical contact, even a single blow, may amount to reasonable provocation. Whether the contact is sufficient will depend on whether a reasonable person under similar circumstances would have been provoked to act out of emotion rather than reasoned reflection, and on whether the defendant was in fact so provoked. The heat of passion must also be sudden, that is, the killing must have occurred before a reasonable person would have regained control of his emotions, and the defendant must have acted in the heat of passion before he regained control of his emotions. If the Commonwealth has not proved, beyond a reasonable doubt, the absence of heat of passion on reasonable provocation, the Commonwealth has not proved that the defendant committed the crime of murder. 2, heat of passion induced by sudden combat. Sudden combat involves a sudden assault by the person killed and the defendant upon each other. In sudden combat, physical contact, even a single blow, may amount to reasonable provocation. Whether the contact is sufficient will depend on whether a reasonable person under similar circumstances would have been provoked to act out of emotion rather than reasoned reflection, and on whether the defendant was in fact so provoked. The heat of passion induced by sudden combat must also be sudden. That is, the killing must have occurred before a reasonable person would have regained control of his emotions, and the defendant must have acted in the heat of passion without cooling off at the time of the killing. If the Commonwealth has not proved beyond a reasonable doubt the absence of heat of passion induced by sudden combat, the Commonwealth has not proved that the defendant committed the crime of murder. In summary, a killing that would otherwise be murder is reduced to the lesser offense of voluntary manslaughter if the defendant killed someone because of heat of passion on reasonable provocation or heat of passion induced by sudden combat. The Commonwealth has the burden of proving beyond a reasonable doubt that the defendant did not kill as a result of heat of passion on reasonable provocation or heat of passion induced by sudden combat. If the Commonwealth fails to meet this burden, the defendant is not guilty of murder, but you shall find the defendant guilty of voluntary manslaughter if the Commonwealth has proved the other requirements. 3, excessive use of force in self-defense. As I have explained to you earlier, a person is not guilty of any crime if he acted in proper self-defense. The Commonwealth must prove beyond a reasonable doubt that the defendant did not act in the proper exercise of self-defense. If the Commonwealth fails to do so, then you must find the defendant not guilty, because an element of the crime that the Commonwealth must prove beyond a reasonable doubt is that the defendant did not act in the proper exercise of self-defense. In this case, you must consider whether the defendant used excessive force in defending himself. The term excessive force in self-defense means that, considering all the circumstances, the defendant used more force than was reasonably necessary to defend himself. In considering the reasonableness of any force used by the defendant, you may consider any factors you deem relevant to the reasonableness of the defendant's conduct under the circumstances, including evidence of the relative physical capabilities of the combatants, the number of persons who were involved on each side, the characteristics of any weapon used, the availability of room to maneuver, the manner in which the deadly force was used, the scope of the threat presented, or any other factor you deem relevant to the reasonableness of the defendant's conduct under the circumstances. I've already told you that to prove the defendant guilty of murder, the Commonwealth is required to prove beyond a reasonable doubt that the defendant did not act in the proper exercise of self-defense. If the Commonwealth proves the defendant did not act in proper self-defense solely because the defendant used more force than was reasonably necessary, then the Commonwealth has not proved that the defendant committed the crime of murder. But if the Commonwealth has proved the other required elements, you shall find the defendant guilty of voluntary manslaughter. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find him not guilty. All right, so jurors, that concludes the first part of my instructions. What I'm going to ask you to do is you're going to leave your instructions on your chairs with your notebooks. Please do not take the instructions into the deliberation room with you at this time. And we'll come back at 2 o'clock.
Oh,
We'll
man.
hear the closing arguments, and then I'll give you the remainder of the instructions, and then I will send you out to begin your deliberations. Again, you are not yet deliberating, so please don't talk about the case at all.
All right, please.
Okay, so there's only 3 choices. There's murder 1, murder 2, or voluntary manslaughter. Reddington was trying to get an involuntary manslaughter charge, but the judge did not agree to that. So it'll be interesting to think what you guys think. We will take a poll, which I need to set up. Thank you, Renee Foster, who tells us that the pond lies in between the vacant lot and Kurt's house, which is interesting. Was that a message? I don't know. Or was it just opportunity that he knew that that pond was there and he didn't want anybody to find her? But he said he didn't really care if anybody found her because, he was so drunk and like that. Sarah, be creative. Whatever the outcome, prayers to the kids involved, as always. Thank you so very much. Uncivil was here. Thanks for your super chat, super sticker. And Midnight Mike has been gifting all day. This is 10 in a row. He gifted around 12:35 to 12:37 East Coast time. Thank you, Mike, for always being such a generous supporter. And Twilight Zone 913, I'm not sure if I don't remember if I addressed this before, but it says, so I started this late, not a troll, but definitely think she snapped. I definitely think that she wanted money. Definitely know above all, she didn't deserve to die. And to be honest, I was more on manslaughter before he started talking. He is gross. I think a lot of people feel that way. All right, what should we do? Should we hang out here until 2? Should we end this and then start up again at 2 into a different stream? I don't know. I'm torn. That's something that we could watch that might make you laugh. If you want to watch something during the break, it's like one of those days in elementary school where you get to watch a movie. You get to watch a movie during school, and it's like fun. All right, in order to do the poll, I have to get onto YouTube. This is like the way I have to do this. So let us take our poll. And so this is not how you think the jury is going to vote, but how you would vote if you were on the jury. So first-degree murder requires premeditation. Second-degree murder, the way I understood it was second-degree murder was not premeditation, but that he caused her death, he intended to kill her. And that's where my notes end. So I thought that was heat of passion. No mitigating circumstances. The only difference between first and second was that there was no premeditation, right? Hold on, second degree. And then voluntary manslaughter. Okay, and go. I was just looking up the penalty for voluntary manslaughter. Wild to think that Karen Reed is also charged with second-degree murder, right? And this is the guy who confessed. Also in the jury instructions were that the premeditation does not have to be any certain or specific period of time. It could be seconds, it could be minutes. So where were we on manslaughter? Hang on, this is motor vehicle. Whoever commits manslaughter shall, except as hereinafter provided, be punished by imprisonment in the state prison for not more than 20 years. So it's a max of 20. Max of 20. But I don't, the jury doesn't know what the penalty is when they're deciding. Oops. Sentencing is decided by the judge, not the jury, in Massachusetts. So there's that. Let me get to second-degree murder, because I want to read that charge again. He wanted Kurt to be the suspect. That's an interesting theory, Cindy. Okay. There's a lot of courthouse activity going on today. There's stuff going on in Coburger. But we've committed to this, so we need to see this through. Justice for Katie McLean. I'm going to put the National Domestic DV Hotline up here. It is a resource that has saved many of my clients and viewers as well. KDB says that Harry has the Shank Shop special haircut today. It's so uneven. Looks like it was cut with a toothbrush. I've been saying it looks like we've been calling him Hammer Haircut Harry because it looks like it was cut with a hammer. And then yesterday I said it looks like he had a fight with a lawnmower and lost. So I'll allow all of that. I like the Shank Shop special haircut. I'll allow that as well. Helena said, I had a law professor say, revenge isn't justice. If your decision makes you feel elated, you've made a mistake when it comes to the law. Justice should bring sorrow for the destruction, not joy for revenge. That is great. You had a great law professor. And Belam points out, and many of you noticed this, that this judge said he said he was going to instruct the jurors on the law, not teach them the law. And I scream every time Judge Cannoni says that. So you are not here to teach them the law. You instruct them as to what the law is. So thank you for pointing that out too. And Monge, thank you so much for your super sticker. I appreciate you. Marie says, do you think Katie was texting him about having sex to prevent him from seeking an annulment based on marital abandonment? I have no idea. I don't know much about their relationship. What I know about Katie are things that I've heard from her friends who have sent me emails and told me that, you know, she was just looking for love. She was just looking for love, and she just wanted to be loved, and she was a wonderful person. And you know, there's what do they call it? The wheel of power and control when people are in abusive relationships and they keep going back to the person. They keep going back to their abuser because that is their comfort zone. So I don't know what she was thinking. I mean, some people think she had nefarious intentions. I happen to think that maybe she found herself in abusive relationships because she didn't know how to break the pattern. But those are my personal thoughts. And I don't really know. I don't know that anybody really knows the answer to that. Steve became a new member. Hey, see, the boys are showing up. Tail like Confetti Fairy says, that's what I don't get. Why not file for divorce and keep the house if she wasn't on the deed? I just can't see him feeling powerless in that situation. Yeah. And I'm not buying the self-defense thing either. You know, the provocation. Like, I mean, he was practically twice her size. I just don't see it. It was definitely a toxic relationship on both sides. I agree with you, Peggy. Helena says, not once did he apologize to her children, right? I think he made a horrible witness on his own behalf. I think there was nothing sympathetic about him at all. And SJ points out, the trouble of the dynamics of a volatile relationship and says it is not always bad. When it's good, it can be really good. That is what I've been told too many times. Right. And that's what people say too. You know, it's like highs and lows. Like they get addicted to the adrenaline rush of it all. And then, you know, when it's good, it's really, really good. And when it's bad, it's really, really bad. And it's like a roller coaster. And it's a very complicated dynamic that a lot of people don't understand. And I say to those people, you're very lucky that you don't understand it and that you don't know that it exists. You're very lucky. Katie B says people really need to do research on trauma and trauma victims. I agree. Max says absolutely not self-defense. Marta thinks he's a narcissistic man. Robin, we could do another poll after, but we could be doing polls all day long. How do we think the jury will vote, and how long will it take for them to decide? I don't know. It might not be that quick. I mean, look at how our poll is so divided already. I mean, we've got 30% first degree, 38% second degree, and 32% at voluntary manslaughter. I mean, it could be a while. Mastad, though. Mastad has an opinion. It says manslaughter and 4 hours. Does anybody think that alcohol is a mitigating factor? I don't. And I don't see the heat of passion thing either. Because I don't think she provoked him. I don't think that was a reasonable provocation or sudden combat or that it was excessive use of force in self-defense. I don't see any of that. But that's just me. So I'm curious to hear what you guys think. Goblin Misfit says that self-defense was sunk by his own testimony. Tom says, I changed my mind since yesterday, listening to the rest of the cross this morning, listening to the instructions, second degree. Green-eyed Southern Girl says, I think he's got uncontrollable anger. He's scary. I want to go back. I want to look at, I'm trying to find the second degree instruction again, because that's the one that, as I was listening to it, that's the one that just hit for me also. Let's see. Murder in the second degree. Okay. Okay. So here's the elements of second degree murder in Massachusetts. Number one, the defendant caused the death of Katie McLean. Number two, the defendant intended to kill Katie McLean or intended to cause grievous bodily harm to Katie McLean. See, that's where I land right there. Done. Ding, 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 ding. That he did kill her and that he intended to cause grievous bodily harm to her. Or that he intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. See, both. Because this is murder in the second degree. Murder in the second degree. I think that he intended to do an act. I mean, at the very least, this is where I'm landing. That he did cause her death and that he intended to do an act which in the circumstances known to him, remember, he's a doctor, he's a surgeon. A reasonable person would have known created a plain and strong likelihood that death would result. And I do not think that self-defense was involved. And this is just me. And I do not think there were any mitigating circumstances. I'm not buying his I was so drunk defense either. All right, going back to murder in the first degree. Murder in the first degree. The defendant caused the death of Katie McLean, that he intended to kill Katie McLean. That is, that the defendant consciously and purposefully intended to cause Katie McLean's death. The defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. And remember, there's no set time on what that period of reflection needs to be. Number 4, he didn't act in proper self-defense. And there were no mitigating circumstances. The Commonwealth has to prove there were no mitigating circumstances. So that could cause some issues too, you know? Like, it seems that everyone agrees that he was drunk. He was brought into the, but then again, he could have been drinking after, because there was like a half a bottle of Glenfiddich on the nightstand in the hotel, right? So if there doesn't have to be any specific period of time required for the premeditation, some people might think first degree. That's why our poll is less split now. So it's 29% first degree, 37% second degree, and then 33% on the voluntary manslaughter. Let's go back to the voluntary manslaughter charge. And the jury gets to have these instructions with them in the jury room. So if you find that he caused her death, but there's a mitigating circumstance. So a killing that would otherwise be murder in the first degree or second degree is reduced to the lesser offense of voluntary manslaughter, where the Commonwealth has failed to prove that there were no mitigating circumstances. Therefore, if the Commonwealth proves all the required elements of murder, but fails to prove beyond a reasonable doubt that there were no mitigating circumstances, you must not find the defendant guilty of murder, but you shall find the defendant guilty of voluntary manslaughter. I mean, I've been practicing law for over 30 years, and this is confusing to me. How is an average juror going to get it? They're going to say, well, the Commonwealth didn't prove that he wasn't drunk, and so therefore we think he was drunk, and so we have to go with manslaughter, right? So here are the mitigating circumstances. Heat of passion, unreasonable provocation. See, but I'm not buying that because I don't think he was provoked. But that was one of the mitigating circumstances. Or heat of passion induced by sudden combat. Sudden combat involves a sudden assault by the person killed and the defendant upon each other. Even a single blow may amount to reasonable provocation. And then, if you find that he used excessive force in proper self-defense, then you must find him not guilty at all. Right. Right, Toots. He dumped her body in a freaking pond. Sober enough for that. No respect for her. Agreed. Agreed. Canoni's baloney says a lot of, not all doctors have a God complex. He didn't like it when Katie tipped the balance of power in her own favor, and he planned it, so she died before half the house was officially signed over, right? I think the deed was recorded on the exact date of her death. I think it was like, we did, Little Cupcake, I think, did the math on that and put it up in the chat earlier. Let me see if I start it for later. Yep. He signed the deed over on 4/29/2020. Then he drove back to Massachusetts on 5/8 of 2020. She let him into the house for the first time since the restraining order on May 14th of 2020. And that night he strangled her to death. And I think the deed was recorded on the 15th, right? Thank you, Josh. Josh says, personally, I don't think the Commonwealth has proved intent to kill beyond a reasonable doubt, right? So that would be murder 1, right? But we just read through murder 2. So what did you think of murder 2? Steve, I think I welcomed you in. If it was an accident, he would have called 911. Right. He's doctoring. He could have saved her life. He had to put her away. Yeah, that was revolting testimony too. Carrie says, I probably could be swayed in the deliberations room between murder 1 and murder 2 with proper argument. Did anybody watch the series Presumed Innocence? Presumed Innocent. Presumed Innocent? Yeah, with Jake Gyllenhaal. The recent one was good. I liked it. Kim said he only agreed to sign the deed to allow him to get back in the good graces of Katie. He manipulated her into dropping the restraining order to get back into his house. He attacked her in bed after they argued. Murder won. Great argument, Kim. Great argument. It's going to depend on who's on the jury. He had a pattern of abuse, don't forget. But how much did the jury hear about that? I mean, they knew there was a restraining order, but how many, did they hear about the other times? Didn't she text her friend the word popcorn, which was the key word? She was in danger, yes. So I don't think she provoked him. Right. And now remember, there was a motion in limine to exclude the use of the word popcorn because that was like her, not safe word, but I'm in trouble word. But it got in a little bit. Thanks, Laura, for reminding me of that because, yeah, she texted popcorn. So there was time to text popcorn. I think we have a popcorn situation, and I don't remember exactly when they received that text. That's a great point. And then Vanessa and Kurt were texting back and forth. Problem is we had some days off in this trial, and so that was like way at the beginning of the trial because weren't Vanessa and Kurt like the first two to testify? Right. Neurospacey says he's cold, a narcissist. I don't see any kindness or love in him. He feels justified in killing her. I don't see regret. You guys loved that show. Well, the house was sold. Actually, the house was sold. I don't know if the proceeds were split with her children. I don't know. What I do know from watching some other coverage on Karen Reed, some talking heads who hate her, there is no son of Sam law in Massachusetts. So in New York, we have the son of Sam law, which means that a criminal or a convicted felon, I guess, Scott, you can help me here, cannot profit from their crimes. They can't write a book or keep any profits from a book deal or a movie deal or anything like that. Massachusetts does not. I don't know what that would have to do with the sale of the house, but that was just a side note that I had. Let me look it up because I know it was sold. Let's see how much it sold for and when. Because I remember we looked at the listing on this. "29 Valley Road in Dover." Okay, it's off the market, so let's see if we can figure out when it was sold. He said it was sold, so we knew that. What do we have here? It's sold in May of 2021, so exactly 1 year after she was murdered for 1.7 million. You want to see the listing? I'll allow it. Here's the listing. Four bedrooms, 6 baths. The Zestimate is 2.43, 5,380 square feet. Remember, he owned this as a single man. I think he had 2 children. He has 2 children of his own. I don't know if they were in the courtroom supporting him. Oh, Mind Blown says, I think Kurt texted Vanessa. I think we have a popcorn situation. Beautiful house. Not a fan of this green paint, but it's just a coat of paint, right? Yeah, that green is not doing it for me. It's like pea green. Ooh. Ooh. Huge. Huge. Enormous kitchen. Wolf stove. Looks like the 8 burner. Oh, I love this mudroom. But it's a murder house. Do they have to disclose in Massachusetts when it's a murder house? 3-car garage. They don't show the home theater or, you know, the pool and the gazebo and all that stuff he said he spent $250,000 on. Why come they don't show that in the listing? Isn't that like a huge selling point for this house? You would think. Dover is expensive. Only if they ask. Only if they ask if it's a murder house, then they have to tell them. Robin says alcohol should always be an aggravating factor, just like in a DUI case, not a mitigating factor, in my opinion. I think you're so right about that. I think you're so right about that. It's a great point. Let's see if Jess Machado has any more updates here. See what's happening in the courtroom next door. All right, let's see. Her notes are really detailed, so I'm trying to get to the point here. She says it looks like we have seated 2 more within the first 6 potential jurors, but I think they didn't really know until the end. No break for lunch. Okay, so 2 minutes ago, she said there's going to be a 30-minute lunch. Okay, so that is crazy. So it's unclear if they seated any or not. Unclear. I mean, they're only calling them up one at a time, so it takes forever. No, I did not see her sneak through this courtroom yesterday, did she? Yeah, we heard there was 12 as of this morning. They had 10, and then yesterday one of them left, and then they got 3 more, so it's still a total of 12. So we need 4 more. And we don't know if they've seated anyone today yet. All right, we have about 20 minutes. Let's see. Should we end this poll? We only have 1,000 votes, and there's over 3,000 people, so I'll give you another second to vote if you want. And the jury should be back in about 20 minutes. And while we're waiting, let's watch some. Let me introduce you to my friend Kathy. If you don't know who Kathy is, you will now. This was a trial, and a lot of times I find out about trials from Kathy. Kathy has a channel called Gossip, Rumor, and Innuendo. No, there's no verdict. We're waiting. We haven't even done closings yet. Closings are coming up after this. So we're waiting for them to come back 2 o'clock to do closings. So closings are next. Let me just put that up here so people don't get confused. Let's see. Court is back at 2. Okay, who knows Kathy? Kathy is she has a channel called Gossip, Rumor, and Innuendo, and I love her, and she's hilarious. And every morning she drops a video talking about true crime cases, and she's talking about a case about Linda Sturmer. Does anybody know about Linda Sturmer? I didn't, but now I do, and now you're going to know a little bit about Kathy because every morning she drops a video and she makes me laugh every morning. And every morning I start out my day with Kathy, and I would like you to start your day out with Kathy too. Here's her video on Linda Sturmer. I'd never heard about this case, but now I kind of want to go watch it just because of Kathy. So enjoy Kathy for a few minutes while I go refill my drink. Because if she can make us laugh about true crime, I mean, she's amazing.
Good morning, true crime friends. How y'all doing? Listen, we need to talk about this Miss Linda Sturmer. Initially, I was convinced that she was not guilty because of all the gorgeous hair. Now, is that gorgeous hair holding secrets? She got a bunch of secrets tucked up in there. But now, the more I learn about this case, I'm like, oh, she's garbage. We're gonna talk about it, but first, you know what you need to do. Please like this video and subscribe to the channel. That helps other people find us. Also find me on Instagram, Facebook, and Blue Sky. Okay, so look, let me give you the quick and dirty overview. I have an entire Linda Sturmer playlist so you can get all the parts, but in case this is your first video about this lady, let me tell you, she and her husband was having a real bad time. They were like, maybe we get divorced, maybe we don't get divorced, but she's like, you know what I'm gonna do? I'm gonna go get some gas, and she poisoned him lightly, like a light poisoning with she sedated him with some sleep medication or whatever, and then she poured gasoline on him, set him on fire, was like, I'm all done with that. That was easy. But then while he was on fire, he ran out of the house, and she's like, dang it, I did not expect that. And then she ran him over with the car, and then she was just like, he seems to still be like a little bit alive. Oh, look, help looks like it's coming. That's okay. So she laid her body on top of his body and then covered his mouth with her hands. And she's like, I was trying to do CPR, ma'am. That's not how CPR works. Anyway, so he died. And she was like, oh, oops. And so they went to trial, and she got convicted and sent to prison. And I know you're asking yourself, well, if she went to prison, why are we back here? Well, her defense attorney in the first trial was like, Your Honor, I might have done ineffective assistance of counsel. I really should have hired like a fire expert or whatever, and I didn't. So can she get a new trial? And the original court was like, nah, half a done did this. But then the Supreme Court was like, well, you really should have hired the state Supreme Court over there in Michigan was like, you really should have hired a fire science expert. So we gonna get Linda a new trial. Linda gets out. Look, she was locked up for 8 years, and then she gets out. She's been out for 8 years. Can you imagine being in prison for 8 years? Then you free for 8 whole years. Now she's back at trial number 2. The original crime happened 18 years ago, right? So you would think a whole lot of people would have forgotten. And I was like, I think Linda's gonna go free. At the beginning of this trial, I was convinced Miss Linda was gonna be free. Y'all, Linda going to jail. Linda belongs underneath the jail. She's a horrible, horrible human, even though she has gorgeous hair. And yes, that hair is holding secrets. And I don't think that hair should be punished for the evil things that she did, but punished, that hair is going to be. So look, what you need to understand is Linda got 5 kids, right? She has 2 daughters from her first marriage. And then she adopted a son. And then she has, 2 sons from her last marriage, right? So the way it breaks down is the girls are team mom and the boys are mama's a whole trash bag. So last week we saw her oldest son, Corey Pierce, take the stand. That's the adopted son. But child, if you adopted that child's your baby. It was her nephew or whatever. He came to live with them and everything was going good. And so Corey got on the stand and he was like, she sent us to the movie. She woke us up early in the morning, wouldn't let us kiss dad goodbye, gave us some money, told us, go to the movies, go have breakfast, go to the mall, have a good time, don't come back here no time soon. And so they were like, okay, we don't want to go to the movies, but fine. And so they go to the movies, right? The older son, Corey, takes his 2 little brothers to the movies. And then while they're in the movie, they get a call that's like, oh my goodness, your house is on fire. So they run home and they find out all this tragedy has happened. And Linda is crying and she's super duper sad and it's terrible. So we heard all from her first son, Corey Pierce. Then we heard from her yesterday on the stand. We heard from her youngest son, Trenton. The heartbreak. Now listen. What you need to know is, number 1, Trenton was only 12 at the time of the fire, but 12 is old enough to remember a whole lot of stuff, especially if it was something super duper tragic, right? And Trenton looks exactly like his daddy, like exactly like his daddy. I was like, wait, I thought Todd was no longer on this mortal coil. Why has this boy got his whole face? And so Trenton shows up and he was just like, Trenton was not happy to be there. He was salty. He was mad. The jury is not supposed to know about the first trial. Over and over. Look, Trenton had no time for the mess. Trenton was like, I don't care what they not supposed to know. Trenton was fresh out of cares. I keep jars of cares here in case I run out. I want to send Trenton some of my cares because he all out. He's all out. So I was like, don't you worry, Trenton. I got 2 jars. So I'm gonna send you some of mine. He was like, during her first trial and at her first trial, he could not have mentioned her first trial more. I was like, Trenton, my man, I'm here for the shade. I'm loving every single moment of it. So the prosecutor was asking him questions, and he was just like, I couldn't care less. But he was answering the questions like, yeah, she was a whole garbage bag. She sent us to the movies. I was young. I don't know what was happening, but I know they have to kill my daddy. That's not what he said, but that's the spirit of what he said. And then they were like, well, did your mother talk poorly about your father? And Trenton was like, yeah. And the district attorney was like, well, what are some of the types of things she would say? Trenton opened his whole mouth. Oh, the way I loved this. He was like, she came down and she said to me, wouldn't it be better if he were dead? I was like, Trenton, you done throwed your mama all the way under the bus. Mom is over here crying her behind. She in the ugly cry. She's really, really in the ugly cry. The defense is like, objection, Your Honor. The judge was like, what's your objection? That was really, really kind of bad. But like, yeah, what was your objection? And the defense attorney was like, we never knew anything about that. The judge is like, okay, jury, can y'all go on to the jury room and take a break or something? We're going to have a little chitty chat about this. The defense attorney was fully melting down. This is a mistrial. He never said these things before. Still, Trenton sat there unbothered. I'm telling you right now, he could not find a care if he wanted to, not with a map in both hands and a flashlight. He was just like, now, did she actually say it, or did she say something like that? I don't know. I believe Trenton, though. Also, Trenton is extra strength salty. I was like, yes, Trenton, come through with the shade for your garbage mama, who unfortunately unalived your father that you clearly loved. And so the lawyers argue back and forth. Had you heard him say this before? Did you know he was going to say it? The state was like, he said lots of terrible things about his mother. I wasn't sure which thing exactly he was going to pick. She's clearly a horrible human being. And the defense attorney was like, Your Honor, this is a bell that cannot be unrung. And the judge was like, okay, defense attorney, calm down. Listen, I'm going to give a limiting instruction. And I was like, what possible limiting instruction could you give on the heels of that little tidbit? And so the jury came back in, and the judge was like, that last question and answer is going to be stricken. Just forget you heard that. And I was like, okay, we all just gonna we all just gonna forget. Like those little, what is it, the Men in Black, the little flashy things like bleep. He didn't just say his mama was talking to the kids about unfortunately unaliving their daddy. Okay, sure. And then the jury had questions, right? Keep in mind, Trenton does not call his mother mom, mother, the heifer over there. He calls her Linda, but this is him. Linda said this and Linda did that. The way he said Linda had such contempt, I was here for it. And so the jury was like, and this is one of the cases where the jury can ask questions the way I love a jury question. So the jury was like, hey boy, hey, how you doing? Listen, this is not exactly what they said. This is the spirit of what they said. They were like, hey, when did you start calling your mother Linda? Trenton, again, not a care to spare, was like, I started calling her Linda when I found out she killed my father. Oh, okay. Thanks so much. I was like, oh, the shade. Okay. He didn't hide how he felt about the lady at all. Not even a little bit. And Trenton, I'm team you. I want to get like a Trenton Sturmer t-shirt with the face that it looks like I don't give a care at all. So the boys were raised by Grandma Sturmer. That is their father's mother after the father passed away, also after the mama went to prison. And I was like, okay. And when Trenton was done, he was just like, are you done? And then he sashayed out. I don't even think he sat in the gallery. He just went on about his day. He was like, I'm gonna wait for the heifer to be convicted and then we gonna go from there. And then Trevor Sturmer got up. Now Trevor was 14 at the time of the fire. This is the middle, like of the boys, this is the middle boy. And he was more calm. He was more reserved. He was giving less contempt than his brother, but I was here for the very, very salty brother. I kind of loved it. So they were like, okay, Trevor, hey, how you doing? The state was like, how do you know Linda Sturmer? Trevor was like, she was my mother. Oh, the past tense. She used to be my mother. I don't know that heifer now because she garbage. And so Trevor told the same story that all of us have heard before. The boys were woken up. They were not allowed to say goodbye to their father. They didn't really want to go out. The mother threw them out the house. Now, Trevor did throw shade at the mama in that this was a gas fire, right? Linda went and got gas and poured it all over her husband. And she said she had filled up the tank full of gas. And so the state said, did the car that you guys drove to the movie have a full tank of gas? And Trevor was like, if it did, it was unusual. We was broke. We never had a full tank of gas because my parents were terrible with money. Mostly my mother, not my father, because my father was a saint. Again, I'm not quoting. This is the spirit of what he said. And so Trevor got up and threw a lot of shade at his mama. Not as much as that brother, though. Oh, I love that salty little brother. And then the state was finally like, we rest. And I was like, okay, now if you ask me, there's more than enough evidence to convict this lady. In my opinion, she going to jail forever, ever. The rest of her life, that gorgeous hair. Although now I feel like that hair is full of evil. That's why it's all puffed out like that. It's just all crammed full of evil and secrets and lies. Anyway, so the defense got up and asked for a directed verdict. They were like, Your Honor, there's not enough evidence. They have not proven anything. And so Your Honor listened patiently, and then she went through her notes, and she's like, well, there is the fact that, and she listed 400,000 reasons why the jury could realistically convict this heifer, which in my opinion, they absolutely will. And so then she was like, okay, so no judgment of acquittal. What you got next? Defense, are you putting on a case? So the defense was like, we are calling a fire expert. He's the expertiest expert that ever experted. And so this is what you need to know about this fire expert. The previous trial was thrown out because the defense team did not call their own fire expert to talk about what happened in the course of this fire. So now, like, this is the moment. This is the chance for the defense to get up there and be like, we have our own fire expert. This is what our fire expert's gonna say. This is different than the state fire expert. And I was like, they've had years to prepare for this. Who are they gonna bring? I'm on the edge of my seat. So this little old man gets up there. He's been he has 50 years of experience. Oh, he used to be a fire this and a fire that. He's done everything related to fire. He knows about fire science. He knows every single thing. And I was like, okay, he's an expert. Great. Although some of the areas that he claims to be an expert in, he really might not be an expert in. And I was like, okay, he knows a lot about fire and a lot about arson, but he's not a forensic fire expert. Forensic is where, like, fire meets crime. And so if you have to testify in trials, that makes you a forensic expert. He's a fire expert, but he's not a forensic expert. Okay, they declared him an expert, and we're gonna see. So he got up there and he gave his experience or whatever. He was expert. He knew a lot about fires in Detroit in the 70s, which, okay, good for you. Mostly, he just wanted to tell us his fire war stories, which I, for one, was here for. Oh, the way I love a war story. Oh, and this man could tell. He's like, so listen, there was this one time we was on the back of the truck, right? And then the house went up in flames, and then 2 people went in, and then one guy came out, but the other guy didn't come out. And I was like, really? And then what happened? And the state was like, Your Honor, he's rambling. And I was like, I don't know if that's an official objection, but he is kind of rambling. And so the defense team was like, no. We're going to get him back on track. We're going to corral him. I promise. And so they asked him a few more questions, which he kind of stayed on topic. And then he started telling more war stories. He was like, I mean, people die from fires, but remember Jimmy back in 84, he died from a gunshot wound. And then Tommy, remember that time he got electrocuted? See, what had happened was the line fell down in a puddle of water. The state was like, Your Honor, objection, war stories. And I was like, it was a good war story, though. I want to hear the rest of that electrocution story. And the defense team was like, okay, we only have a couple of more minutes. Can you stay on track? Can you keep these trains on the track? And the expert was like, yes, of course I can. They asked him another question. He was like, okay. In 92 in Detroit, I was wearing my big boots, the yellow ones with the stripe. You see, that's after they had just come out with that safety stripe. Oh, the way I love the safety stripe. And then the court ended for the day. And I was like, oh, defense, were y'all free? I was asking for myself. Now I am living for their fire expert. He gonna come back and expert some more tomorrow. Something tells me he's gonna have a lot more war stories. And will they counsel him and talk to him and be like, sir, we're gonna need you to just like hone in. He failed shut up class too. Now listen. As a shut-up school dropout, I entirely relate to this man. Oh, he's loquacious. He's a raconteur. He can tell a story. Oh, that boy can tell a story. Now, can he be a fire expert? Child, it is unclear. It doesn't really matter that much, in my opinion, because I believe this time Miss Linda is getting a very, very fair trial. And so when this jury convicts her and sends her to prison forever, they will have gotten it right. We'll find out soon. Like this video, subscribe to the channel, and I will see you soon. Bye.
I love her. I love her so much. You just can't put her on, something's going on with my mic. You can't put her on like 1.5 speed or any faster speed than that because she is funny. It's called the Linda Sturmer case. Tail like confetti fairy failed shut up classes too. Apparently so did Harry Tuerk. Harry Tuerk also failed shut up classes because he just self-snitched on himself so much. I put the link to Kathy's channel down below. I think the first time I shared her channel, I forget where her subscriber count was, but now she's up to like almost 16,000 subs. So good for her. I think what had happened was I think she had her 10,000 subscriber count stream planned, I think, right? For 10, and now she's at 15 or something. And you guys blew her channel up, and I love you for that. Because that's what we do. We like to help other creators, women helping other women. And there's her channel, Gossip, Rumor, and Innuendo. And the fan is back. We have 5 minutes to spare. So let's see if you guys have any thoughts, questions, comments, concerns. Let's put the fan back up for a sec. Still spinning. Oops, I did it again. Yeah, I put the her channel link in the video show notes below. It says halftime entertainment by, and then it's got a link to her channel. So go give her a sub. Tell her I sent you. She's got some good funny stuff on Lori Daybell Vallow. Is anybody watching that trial too? I know I swipe myself out. I do that sometimes. StreamYard really needs to, I don't know, take a meeting with me maybe. But it's funny because they doubled their prices because they sold to a foreign company and their service is it's not as good. They doubled their prices and it's the whole thing. Yeah. So what's going on with Lori Daybell? Is she good? I watched her opening. I had to say she's better than some attorneys I've seen open. I was shocked. I was shocked. How is she doing? Because I have not had a minute to go back. There she is. Melanie Little's left swiping. StreamYard is here. Love you too, girl. It's the perfect name. I mean, sometimes I don't do it at all. Some days I don't swipe myself out at all. Some day, the other day it was 3 times. I think it was a record. I think we needed a laugh, and I thought Kathy was the one to give it to us, and Debbie thinks so too. OMG, I just love that lady. Thank you for telling us about her. I've been following a Linda Streamer's trial, but that was good enough for me. You haven't been, or you have been? I hadn't been following it, and sometimes I'll just listen to Kathy in the morning and it'll get me interested in something. And then I'll just go watch the testimony that she's talking about, and I did watch that son testify, although I was driving, so I couldn't watch him. So I don't know what he looked like or what his demeanor was, but she's hilarious, and she just, I don't know, she just has a way about her that just makes me laugh every morning. And somebody said in the comments, do you wake up like every day like this, like with this kind of energy? And she said something like, I wake up at 4 a.m. and I record by 5:30. And it's like, oh my God, what time do you go to bed? She also is friends with Brandy Churchwell, and Brandy Churchwell got married the other day. That was a surprise. She had told everybody she was going to get married April of next year, and then she had like a surprise wedding because she just got engaged or just announced her engagement like a little bit before that. So congratulations to Brandy Churchwell. We love you, and we're so happy for you. And does anybody know the real tea before that? I mean, about Brandy, because I heard that Brandy married a guy that she met in her chat. Is that true? Or did she meet this guy and then he just started coming into her chat? Or is it a guy that was like a fan that was in her chat and then she got swept off her feet and has a giant, enormous, blinding, like emerald cut diamond ring, and then they're on the beach showing off the ring, and then like 3 days later they're showing off their wedding pictures. So it was amazing. I'm glad she got to keep it secret. I'm so happy for her. So happy for her. And also, I didn't know at the time when I brought Kathy on because we were doing a trial. Brian Camp, that's what it was. I wanted to cover Brian Camp, and we started to cover Brian Camp, and then we were a little behind because nobody was televising the Brian Camp trial, and that was in Hampshire County, Massachusetts, right? And then when I was looking for information on Brian Camp to see if I could even find like news clips, I could find nothing. Kathy's video came up, and she gave such an amazing synopsis of the Brian Camp case that I was like, I wrote her right away. I'm like, can I please? I said, I know this is short notice, but I'm going on live in like an hour. Would it be okay if I play your video for my audience so that they could just get an idea of what the case is about? And she wrote me back right away, and she said that sure, of course you can. And so then we became friends, and then she came on the show another time, and that's when her like subscriber count kind of blew up a little bit after that. And Brian Camp was a tragic story out of Hampshire County. Brian Camp was a young man, 23, 24, I think at the time. And he was living with his girlfriend, and I think their two children, or maybe one of the children was theirs and one wasn't. But anyway, they were living together, and a home invader broke in and tried to kill him. The next thing he knew, he was asleep in his bed with his girlfriend, and the home intruder broke in, the home invader, and the next thing he knows, he's bursting into the bedroom, and the home invader jumps on top of him and starts trying to kill him, like smashing his head against the wall. And they had this crazy struggle, and Kathy told the story way better than I could. And then they wind up downstairs, and then he grabs a gun, and then he shoots the home intruder, and then the home intruder is down, and then the girlfriend wakes up, and she's outside on the phone with 911, and where they live in Hampshire County, it's Hampshire County, right, you guys? It took like over 20 minutes for law enforcement to even get there. And in the meantime, the home intruder was like laying in the kitchen floor. He came after him again, and then he shot him again. And then, of course, Brian Camp is now on trial. Thank you, Mass Dad. The home invader, right? The home invader, it turns out, was Brooke, the girlfriend's boss at Dunkin' Donuts. Like, the story was crazy. And then, of course, Brian Camp is on trial for manslaughter because the Commonwealth said, well, the first shot was okay. The first shot was self-defense. But then when, you came back and you shot him again, like 20 minutes later, because it took too long for anybody to get there. Yeah, that's what we're gonna charge you with, manslaughter for that. So he was on trial for that. We watched what we could watch of the trial. One of our amazing viewers, Bo, went to court and sat there because we didn't feel like Brian Camp had enough support. And Bo went there and she watched the trial and made friends with his attorney, Tom Kokonowski, who now is my friend because Tom came on the show after, and we watched Brian Camp get acquitted by a Hampshire County jury. We were so happy. We were crying, tears of joy. We were crying. And then after that happened, Brian and Brooke got engaged. I think they have since wed, and so they also are married, and we watched an acquittal in Hampshire County in Massachusetts that kind of like for a little while restored our faith into the justice system in Massachusetts. And then after that, we watched the bench trial of Penny McGee, which was a bench trial in front of Judge Cannoni, and that was a wacky trial too. Penny McGee was on trial for I can't remember what she was charged with. You guys remind me. Manslaughter again? In the death of her ex-husband that she was still living with, Andrew Savitz, who died of a heart attack after a verbal argument. That was wild. And the medical examiner in that case was insane. Like, she full on, Trooper Kikowski was in the room with her when she did the autopsy of Andrew Savitz. And she at first said it was undetermined, but then she changed it 3 months later to homicide. And then Penny McGee stood trial for that one. And we watched her be acquitted too. And Judge Cannoni didn't even leave the bench before ruling on that. She just, didn't even need to take time out, nothing. Just acquitted her. And so twice our faith has been restored since the Karen Reed trial in Massachusetts. And now, again, we are back to not having our faith restored because of things like the re-persecution of Karen Reed. And so there's that. The medical examiner was nuts, right? Overcharging. And here's what they do, because we saw this happen in the Daniel Penny case again, which was a New York federal case. Mark Bettero and I met in the courthouse one day. I went into the trial. He had something else to do. Then we had a nice lunch in Little Italy. Daniel Penny was a guy who got on a subway car in New York City when a crazy homeless man came on the train and started threatening to kill people, and Daniel Penny held him down. And the man unfortunately died of what turned out to be a lethal dose of synthetic marijuana in his system. But Daniel Penny was charged also with manslaughter. And so that trial was crazy too. But what had happened was, during the course of the trial, the district attorney in Manhattan, Alvin Bragg's office, decided they were going to drop the top charge during the trial and then only try him on the lesser charge, which really is not really fair, because that just means they'll just overcharge everyone. And if it doesn't work out at trial, then they'll just drop the charges. I don't like that. I don't like that idea. So yeah, exactly, big dog. That made me go off into a different segue of Daniel Penny and Penny McGee. You've never been to New York? I heard it is much like Boston. No, not like Boston at all. Actually, I think Boston might have worse traffic. It is a lot more big, not a lot bigger built, much taller skyscrapers than you guys have in Boston. And synthetic marijuana is not lethal, but it absolutely led to his hysteria and his break that caused him to go on the train and threaten people. So he had an unknown amount. And that was the thing also about the synthetic marijuana, or whatever it was that he was on. I can't remember exactly right now, but they can't test for it. So when they test for it, you can't tell how much was in his system. He also had a long history of mental illness and a long history of arrest records, but it was just my example of overcharging and then choosing to, and that's exactly what, they couldn't measure how much he had in the system, just that it was in the system. Overcharging and then dropping some charges when they couldn't prove it as such. So you guys have never been to New York? Antibes Newport says Lifetime movie, Mickey Rourke as Lori Daybell, maybe. Mickey Rourke. Is Mickey Rourke still among the living, or is he at the Endless Heaven buffet? I don't know. I don't think so. I mean, she's getting her hair. She's a hairdresser, right? Her hair is being done up in jail. Thank you again, Melanie Little's left swipe in StreamYard. Boston is Dublin. New York City is London. It says Canton expat. What do you guys think? Yeah, Carrie misses New York. Mostly pizza and bagels. We do have the best pizza and the best bagels. Come for me in the comments. Fight me about it, cry about it, but it's true. Once you have New York pizza, you just can't eat pizza anywhere else. You just can't. And the bagels, it's all about the water. It's all about the water that makes the bagels so good. Now the hiccups. Bloviating Ingredient says it was during deliberations that the DA dropped the charges on Penny. That's right. You are right. You are correct. I cover so many cases that sometimes I conflate them, and I love it when you guys are so collaborative here that you absolutely help New Haven Pizza stop it. Don't even. I will not even allow that in my chat. I may have to delete that. New Haven Pizza stop. You're joking, right? Best pizza, bagels, and bakeries. True. True. And we have one of each on every corner, right? The thing that makes me mad, though, here's what makes me mad. Melanie Little's left swipe and StreamYard. I can say that because we're like the same person. The bagel stores here close at 3 o'clock. Sometimes you want a bagel after 3 o'clock. Why? Why do we need to close the bagel stores at 3? The only good part about that is you can go in at 2:30 and get all the bagels for half price. You can buy a bag of bagels for half price because they got to get rid of them and make way for the bagels for tomorrow. But Why do they need to close the bagel stores at 3 o'clock? I want to protest. What place has the best pizza? Well, there's that's debatable. I mean, you got to ask around. There's Original Ray's, and then there's Ray's number 2. Some people like Ray's pizza, but there's a good pizza place on every corner. That's the thing. I wouldn't go to a chain. You don't do Domino's. You don't do Papa John's or any of those. It's sacrilege. Okay. My kids once in a while would order like Domino's from DoorDash. Be like, yeah, no, we don't do that in this house. We do not do that in this house when we have a pizzeria, like a real family run pizzeria on every corner. Absolutely hell to the no. Oop, they're back. They do have gluten-free pizza. Some pizzerias do. Here they come. God save the Commonwealth.
Ready for the jurors? Okay, we're all set.
Yes, you're on the vote.
I'm going to close out the poll, so get your votes in. Last call for alcohol. You don't have to go home, but you can't stay here. Really, you are going to stay here because we still have to listen to closings. Closing the poll in 3, 2, 1. Oh, wow, man, we are split. First degree, 30%. Voluntary manslaughter, 33%, and second degree, 36%. Wow. Very slim margin here. I've been to Italy, David, and I have to say that I do love the pizza in Napoli. However, it is very thin crust pizza, right? Like all the pizza that I had in Italy and Rome, it's a very thin crust pizza, more like a cracker. I prefer a doughier pizza, but again, preference, right? Thank you, Bloviating Breenan, for your 5. Appreciate you guys so much. Love you with all of my heart. The defense will close first. Commonwealth will close second.
All right, so jurors, we're going to go into closing arguments. I would ask that you put the instructions that I gave you, just put it under your seat and put your notebooks under your seat. Closing arguments are not evidence. And then when I resume the instructions, obviously, you can take the instructions back out. Mr. Reddington?
Thank you. Members of the jury, thank you again for your attention. The time you took away from your family, your work, to sit here in a courtroom for a long time and listen to evidence. And when you think about the beauty of the jury system, is that a citizen, when they're charged with a crime, has the right to have a jury of their peers sit in judgment on the case. And you're all, people come from all walks of life, different jobs, different backgrounds, upbringings, and you have your common sense. You have your life experience that you bring to that jury room when you sit down and you deliberate the case and you determine whether or not, consistent with your oath as jurors, that the government has proven the charge beyond a reasonable doubt. And you heard His Honor explain to you what beyond a reasonable doubt is. Often used, hard to explain. He did a pretty good job on it as far as explaining to you that close is not enough. More probable than not is not enough. They have to have proof beyond a reasonable doubt to the highest degree of certainty in lives of human beings. You heard His Honor indicate that the government, anytime the government charges somebody with a crime, the government has the burden to prove that person's guilt beyond a reasonable doubt, and that is up to the government. They determine what charges are going to be leveled against someone. They determine what the person is going to be charged with, and then the judge will give the jury the elements, the building blocks of the case, what the jury considers as far as whether or not they've proven a particular charge beyond a reasonable doubt. And the burden of proof in this case lies squarely on the government, on the Norfolk County District Attorney's Office to prove to you beyond a reasonable doubt the allegations. Murder in the first degree, premeditated malice aforethought, cruelty and atrocity, the worst thing we ever reserve on cases. First degree murder, second degree murder, the intentional killing, taking of a life, knowing what someone is doing, having the ability to think, deliberate, plan. Whether or not they react, the government has to prove that this killing was not as a result of self-defense. They have to prove that it was not as a flow from a reaction to an assault that is the culmination of the plan. There's a plan here for sure. And the plan was on the part of Miss McLean to get that house, to get his money, and get him out. You can see a lot of these issues, you can see by evidence, not what someone says to you here in the courtroom, but what was in existence at the time. Text messages speak volumes because they show what's in someone's mind at the time that they send the text message. Photographs showing the scene is important because they show, for example, the shattered glass all over the bedroom floor in the front of the bed by the end board. The glass that's broken, that's up on the piece of furniture. The other glass that's broken, that's underneath the other piece of furniture. All of those items speak volumes as to what happened that night. That night, which was the culmination of the McLean plan, and again, you look to the texts and the evidence that was in existence. If he dies, do I get the house? If he dies, do I get the house? You saw that from the text twice that she sent to Mr. Titan about the deed. Get on the house, get on the property, you own it. If he dies, you get it. Height of the pandemic, get out. You heard, get out. Get out, go walk to your hotel. Leave the car's mine. No, it's not. Well, the judge says it is, as is the house. This is all about money, all about money. And she played him pretty darn good. Smart guy, obviously, in an operating room. Not a smart guy when it comes to real life.
Oh, he's
You
not
heard
gonna
his
like that.
background, you heard his life story, you heard he learned English, taught himself English, rose to the pinnacle of his profession, specialized for a while dealing with pediatric oncology surgery, robotic surgery, all of that, wonderful. Doesn't mean anything, it's ashes blown in the wind. Because he had the pleasure of meeting Kate McLean on Bumble. And they went out on a date. A lot of people do. Many people get together as a result of that. God bless them, that's awesome. If they have a good relationship, wonderful. You think about it. He's living life large. He's got his Harley Davidsons. He's got his house. He's got his job. He's got his money. He can go out on dates. He can stay at home. He can go do whatever he wants to do. 2 years. 2 years they lived together. She comes in with her 3 children after a number of weeks, brings the 3 children into his house, welcomes them in. They lived together for 2, apparently uneventful years. He's paying the bills, taking care of the house. She's got the 3 kids there. You heard evidence that during that period of time, Mr. Rocca, saw the man with the beard, father, he's trying to visit with his kids. Couldn't visit with his kids. Had to park his car out in the street. You heard all that. This is Katie McLean.
He's sitting right behind him.
Katie
Hold on.
McLean's life. Then, all of a sudden,
Steve Rocca is sitting right behind him on the left side of your screen. Katie's first husband, father of her 3 children. I'm going to take it back a second.
this is Katie McLean. He's trying to visit with his kids. So you heard evidence that during that period of time, Mr. Rocca, saw the man with the beard, father, he's trying to visit with his kids. Couldn't visit with his kids. Had to park his car out in the street. You heard all that. This is Katie McLean. Katie McLean's life. Then, all of a sudden, she applies for a wedding license or whatever, marriage license. Applies for the marriage license. Gets the marriage license. He's going out to Las Vegas to do a thing. We're talking about elderly medicine at the Bellagio. And he takes her along. Next thing you know, they're going through, and again, I don't have to hold up pictures and I don't have to have visual aids. You're sitting, you're intelligent people, you sat here through this trial, you know what the photographs show. You know what evidence has been presented to you. You know that they went through the Elvis drive-through. Who does Elvis drive-through wedding?
A lot of people.
No. Hallelujah, we're married now. 5 weeks. 5 weeks. And then he reaches out to an attorney and says to the attorney, look, I want a divorce or an annulment. One or the other, I don't care. I want out of this. 5 weeks. She goes on his phone, you get evidence, she goes on his phone, she checks his phone, she's looking for girlfriends, texting, what are you doing? Who are you doing it with? Let me see it, give it to me. And she sees that deadly email from the attorney, Mary Lesavita. And do the math, it's a day or so later that she gets her bogus restraining order.
I'm going to submit to you that she sees that deadly email might not have been the best choice of words here. That deadly email. Yeah, SJ, you picked that up too, right? So that was the email that led to her death, which was how long before he actually killed her. See now, Kev, you're kind of walking it into premeditation. Hang on a sec. Yeah, 5 weeks they were married, but you just said they were together for 2 years before they got married.
And she sees that deadly email from the attorney, Mary Lesavita. And do the math, it's a day or so later that she gets her bogus restraining order. Throws him out of his own house. He's now out. You heard the officer testify. He was a gentleman. He wasn't some crazy ranting person, angry, upset. Had his hands on his knees. He's like hyperventilating. Please, do we have to do this? What do you mean? I'm out of my... You gotta go. Okay, Katie McLean says, gotta go, you gotta go. Now, she stays in that house. She has a place in Belmont, her mother's condo in Belmont. She could have gone there. No, she likes Dover. She loved Dover. The kids loved Dover because Harry went because they wanted. At entertainment, Harry builds the theater. He builds the swimming pool. You heard about the waterfalls and the TVs and the entertainment thing because she liked to entertain. He didn't say that like, oh, she liked to. He said just like Katie loved to entertain. He had an affinity. He had a respect for her. He had a love for her. He wanted her to be happy. He built all these things in the house to make everybody happy. Want everybody, no problem, take care of everybody.
Why did he want a
problem.
divorce?
Well, once the passage of time goes by, into, what is it, February of 20, he's with Charlie Lax. Friend who allowed him to come in, no problem. After that, he ends up for a period of time with Richie Kovitz. You saw Richie Kovitz, nice guy, testified, had to go to Florida, he lives in Florida. He let Harry come in to his condo with his girlfriend, fiance, Hallal, for months. Harry stayed there for months. Pandemic hit. We all know that. We all lived it. We all know how horrible people, many times people were drinking wine at 11 o'clock in the morning. You don't know if you're going to die the next day. You don't know. Go into supermarkets, you get arrows telling you, go this way, go that way. Wear masks, can't eat, can't go to a restaurant. He, meanwhile, doesn't have what did the police officers say? Shelter in place. He doesn't have a shelter in place. Because now, after he went to Germany, again, he has his life back on track. He's got a job in Germany with robotic surgery. Katie McLean and her 3 kids are in the rear view mirror. He's moving on. He's getting a divorce. He's moving to Germany. And he's going to have a darn good job working at that hospital. Not to happen. Because at the height of the pandemic, he has to come back. He's back because of the presidential decree. He's back to Massachusetts. What's he going to do? Goes to a hotel. Okay, fairly expensive. If you recall, maybe you have life experience during that period. You can't do anything in a hotel. You can't eat. You can't go to a restaurant. You can't do anything. So he's living in a hotel. He's communicating as time goes by with friends or family, and during that period of time, he ends up with Kurt Vanensteel. Good old Kurt. His best friend. Kurt backed up on that like a poodle on a linoleum floor when I asked him, you're his best friend. Well, no, I'm not his best friend.
A poodle. Wait,
I was friendly.
sorry, Kev. A poodle on a linoleum floor has entered the chat. I don't think I've ever even heard that term or that phrase, that analogy, that metaphor. A poodle on a linoleum floor. Yeah, we also learned from Kurt that there's no bro code. Thanks, Kurt, for that. Here we go. I got to hear that again. Poodle on a linoleum floor. Let me know if you've heard that before.
By with friends or family, and during that period of time, he ends up with Kurt Vanensteel. Good old Kurt. His best friend. Kurt backed up on that like a poodle on a linoleum floor when I asked him, you're his best friend. Well, no, I'm not his best friend. I know the guy. I was friendly with Katie. I guess you were. Do you really think that Kate McLean had the intent to take this guy back into her life? Do you really think that Kate McLean wanted to have this old man back in her life and she loved him?
Yeah,
She has
maybe.
her goals. She reaches out to him. And you heard the governor jump up and down and ask him, I said, well, you're the one that...
Here's the thing. Kurt had a ton more money than Harry did. If she wanted to be with Kurt, she just would have went and been with Kurt. We learned about Kurt before. He's like an heir to like some $1 billion fortune or something. Because we learned about his matrimonial. If she was after money, why wouldn't she have just stayed with Kurt or gone with Kurt?
wanted to reconcile. Katie McLean has just had many friends. Wonderful, wonderful woman. You wanted to reconcile with her. And I suggest to you that his testimony was consistent because it's the truth. And he testified and told you under oath that it was Kurt Vanensteel that reached out to him initially on a FaceTime call with Katie McLean. Come back. Now, meanwhile, he's in Florida, right? He's living in a trailer in Florida. How the mighty tumble, he's living in a trailer. Got to get out of the trailer. You can't fall much lower than that when you got to get out of the trailer. So he's got to leave the trailer, and now he's got his problem with his head and his back, and he's got to come back up to Massachusetts. Well, Kurt comes to the rescue with that call. I love you, I want you back. He now sees a light at the end of the dismal tunnel. And during that period of time, he is able to make arrangements to meet Ms. McLean in New York, drive back. She's got Mr. Roca with her. He told you he was shocked, surprised, because that was the last guy in the world that he expected to see her with. You heard evidence that During this period of time that she had people in the house, and she's certainly not entertaining her friends. During this period of time, he's thinking that they're going to reconcile, but right up to the very end of that period of time, she's not in a mindset that she wants to reconcile. She's more interested in talking to guys and doing whatever she's doing with Kurt, and you heard the evidence. What do you think was in her mind? You think she really wanted to reconcile? No, she wanted the deed. She wanted the house. She wanted the security. We can say security. She wanted the security. So this fool signs a deed against his
He just called him a fool.
advice.
He just called his client a
He
fool.
says to him, don't sign the deed. Don't sign the post-nup. What are you, nuts? There is no basis for alimony in a 5-week marriage. You've been played. But he signs the deed. He signs the post-nup. Makes arrangements to meet with her. Now, he then is living in that hotel that we saw, that little room. There's a restraining order. She drops the restraining order. Of course, it's part of the plan. Drop the restraining order. She didn't care if he was in the house. Come on, come in the house. Let's go, in the house. You're able to go in the house. Brings his little ditty bag, goes in the bedroom. Beautiful, everything's great. We're going to live together. Things are going to be great. We're going to reconcile. Didn't know about Kurt. Didn't know about the text. Didn't know about that state of mind. During that period of time, they end up, and it's not easy to talk about people. I mean, the woman is dead. As an attorney, I'm not stupid. I know you don't, as we say, trash the victim. I know that.
So stop doing it.
But it's the facts of the case. And if I was arrogant or obnoxious, or I was hard on a witness, don't hold it against him, because that was my cross-examination. But in my opinion, I did what I believed that had to be done to show you what the truth is and was at that time. So he's now in the house with her. He said that it was sex, sex, sex. Said that at his age, it was a little overbearing, but nevertheless rose, so to speak, to the occasion. During that period of time,
All right, I need to take
I
a poll of
had
the men in the
texts.
chat. Really, would you find that a little overbearing at his age? He was like 58. A little overbearing if the woman that you're with wanted it all the time? Men, I know you're out there. Yes or no, would you find it overbearing? Dude, you just lost us.
at his age, it was a little overbearing, but nevertheless rose, so to speak, to the occasion. During that period of time,
Rose, so to speak,
I
to the
had
occasion.
texts.
Oh, come on, really? With the sexual innuendos in the closing? It's not necessary. Hold on, we gotta get that again. So weird, right? I gotta get back to the beginning of that sentence. Somebody's in the chat. What, if anything, says 50-year-old man? Hell no. No, no, no. AJ's best friend says never. Martin says no, no, no. Come on. I mean, they might have bought some of the other stuff you were selling, like she's, after him for his house, but this, no.
time. So he's now in the house with her. He said that it was sex, sex, sex. Said that at his age, it was a little overbearing, but nevertheless rose, so to speak, to the occasion. During that period of time, I had texts that showed it's 11:45. Let's fuck. Come home. And whatever she said, with your wife. Do this with your wife. And interestingly enough, the round spot of blood on the bed that is hers, yes. You have a text where she indicated on May 6th that in fact, she's telling him I'm on my period, so you can't have sex. We're talking a week later. They had sex. You heard the DNA the person talk.
Okay, what? So
Yeah, that was her DNA. And
she lied about?
3 other contributors. My God, 3 other contributors.
Okay.
YSTR profile, male profile.
3 other contributors to her period blood? What is he talking about? To the stain on the bed? What is he talking about now? None of this is in evidence. They could have had a housekeeper that did the laundry. There could have the son could have been sitting on the. What is he talking about? Hold on.
We're talking a week later. They had sex. You heard the DNA the person talk. Yeah, that was her DNA. And 3 other contributors. My God, 3 other contributors. YSTR profile, male profile, in that spot, in his bed, in his bedroom. In any event, they have sex. He told you that night they had sex. You heard the DNA woman say, yes, if a guy is married to a woman or a guy and a girlfriend or whatever, and they're intimate with each other, yeah, of course there's going to be DNA in their hands or in their fingernails. This is not blood. This is not skin cells. It's touch or handler DNA from touching someone, rubbing someone's back, clawing someone's back, grabbing their butt, grabbing their junk, grabbing whatever you grab, however you grab it, you're going to get DNA on your husband or wife's hands. But they run with that. That and the blood spot in the bed. Oh, you saw and heard. There's not one whit of evidence that she had a bruise about her face, her head at all. No evidence whatsoever of any bruising in the area of her face and head. Of course, we have the government's.
Wait, so are you saying it would have been worse if he beat her before he choked her to death? But because there were no other bruises or smacks or welts about her body, that somehow that makes it less of a crime? Okay, we're going to have to go back and revisit the blood issue. Because he's saying now it's touch DNA. I don't know.
Pathologist who testified, and it's your memory, not mine. Very nice woman. Testified as best she could. She's probably overworked, had a lot of files, a lot of cases. And I suggest to you that she couldn't remember basic things from that autopsy. That's fine. She says, oh, there's subdural hematoma in the back of the head and the side of the head. Initially, is there any bruising? No. And then it was, well, subdural hematoma. Yeah, that could be bruising. Yeah, okay. You heard Dr. LaPosada indicate that that is from the person being for a period of significant time prone over the water. And when we talk about the water, that is what is called post-homicide conduct. What's at play with a jury is what was in the person's mind at the time of the killing, not what occurs afterwards. Granted, you heard him testify. He's not proud of that fact. He lives with it, but it has nothing to do with what was his state of mind at the time she smashed the glass, which you believe obviously happened, off of his head. You saw the photographs. You saw it's almost an inch above the hairline of the cut. He indicates that he is holding his hand and reacts with one hand. You heard Dr. LaPosada's testimony. There is no bruising about the head or the face. There's no bruising anywhere, actually, other than the neck. Bilateral, not circumferential, not grabbing with 2 hands. Dr. LaPosada clearly and unequivocally states bilateral grab from a very, very powerful man with huge hands, okay?
Oh my God, come back to your screen. Come back to your screen for a second. He just grabbed his hand and held it up and showed it to the jury. Hang on a second, look at this. Oh, my freeze game is on point. I gotta take the closed captions down so you can get it all in all its full glory. I'm sorry, that's like creepy to me, but I'm just gonna take it back and see if they rehearsed this. Do you think they rehearsed it? Do you think Harry knew he was gonna do that? Watch. I mean, he's engaging, I'll give him that. They're not falling asleep during this closing argument.
Neck. Bilateral, bilateral, not circumferential, not grabbing with two hands. Dr. Lapasada clearly and unequivocally states bilateral grab from a very, very powerful man with huge hands, okay?
They are huge.
Bilateral grab. Reacting. Both of them drunk. She dies. He knows. Is that premeditated? Is that cruelty and atrocity? A matter of seconds, Dr. Lapasada stated. Seconds. I suggest to you that he reacted. He was drunk. He reacted to the assault. He defended himself. He did not use excessive force. He reacted to stop the assault. Any one of you or anybody is entitled to defend themselves. And the beauty of the law is that the government has to prove beyond a reasonable doubt that he did not act in self-defense. They have to prove, how can anyone say he did not act in self-defense? That's a not guilty. He acted in self-defense. The circumstances attending that set of events that occurred, the government has to prove to you beyond a reasonable doubt he did not act in self-defense. The government suggests that, oh, this is first-degree murder. Second-degree murder, when you look at the facts of the case, consistent with the instructions his Honor gave you, is this a killing that occurred in hot blood, heat of passion, on sudden, adequate provocation? Isn't that all over the place? They have a burden to prove to you beyond a reasonable doubt that he did not act on reasonable provocation, did not act in a heat of passion, did not act because of the emotion of the assault, did not have the ability to form intent at the time. There's no intent to kill. There's an intent for self-preservation. You heard Dr. Zeisel talk about fight or flight. You heard Dr. Zeisel talk as a psychologist about pretty fairly standard psychological principles that all of us have. That little hypothalamus or whatever it is, that thing in your brain, tunnel vision, you do stupid things afterwards. You try, it's because you're nervous. It's the overwhelming fear, the overwhelming fright that eclipses your ability to think straight. That's what the pond is about. The pond has nothing to do with the circumstances of the killing. The killing occurred, she smashed the glass, after she told him to get the F out, get out of my house, and the deed was recorded that day. And he moved in that night, that day. One night. The evidence shows shattered glass. Do we have it? No. Where is it? Who knows? Probably a dump somewhere. Is that important to have a full, fair investigation? You heard, and you know, the cops, you can wind them up and they'll walk up to the witness stand and you can press the button and they'll testify and they'll give the right answers. But does anyone really think Kwiatkowski knew what the hell he was doing here? Testifying? He didn't even know where the argument took place. He stood up there and told you, I don't know. It's possible. It's possible it took place in the bedroom. Come on. Was there glass?
He thinks Kwiatkowski is a buffoon.
On the floor? I think I recall. What do you mean you think you recall? You're a chief homicide investigator on a murder case. Man's life is at stake and you think you recall because you get your check on a Friday?
Welcome to Norfolk County. You've been here a long time, Kev. You know what's going on in the courtroom next door, don't you? Proctor was involved in your case too, but for some reason you never even mentioned him, you guys. I don't know if he was off limits for this, but we know.
That is a lousy police investigation. And you know what? The other young man that came in and said, well, if it had red marks on it, I would have examined it. And I said to him, you have to know it's there before you can examine it, right? He didn't even know that there was a second glass. When the police investigate, as citizens, we expect they're going to have an open mind, they're going to do a good job, they're going to seize evidence, they're going to secure things, and they're going to do the best they can to be able to prove a case to a jury beyond a reasonable doubt. Didn't happen in this case. It was a foregone conclusion. But they knew nothing about text messages, did they? They knew nothing about the goings on between the two of them. They knew nothing about the deed. They knew nothing about the postnuptial agreement and the money that's paid. They knew nothing about the destruction that she rained down on this man's life. This is not a murder. You bring your common sense, you bring your life experience to that jury room, you look at all this evidence, you look at the time frames, you look at the deed, you look at the photographs, you look at the medical records. The medical records have the guy, the 226 blood alcohol 19. You see the comment in there, suicide by alcohol. And you can make fun of the fact, oh, well, you know, it's superficial scratch. Anytime there's marks and cuts on somebody trying to kill themselves by not going sideways, linear lines, they're superficial. Post-contact, you can say that's superficial. He wanted to kill himself. He wanted to say goodbye to his friends. He wanted to say, I love you to some people. He did that with Kurt and some of the other people that he sent messages to. She played us. She was the devil. I love you, Harry. This is the end of a tragic human story. But I suggest to you, members of the jury, that when you consider Judge Hallal's instructions, ever mindful of the burden of proof, this man is not guilty of murder. Thank you.
Golf clap.
Thank you, Mr. Reddington. Ms. McLaughlin?
He's engaging. Look at him there. All right, this is not Laura McLaughlin. Let's not spread misinformation. Her name is Elizabeth McLaughlin. She's another ADA with Norfolk County DA's office. She's not related to Laura McLaughlin from the Carey trial. And so let's see what she's got to say. He was a bit longer than 15 minutes. It wasn't a time limit. He just had told the judge that's how much time he thinks he needs. But of course he gets going. He enjoys the theater of it all. And, you know, let him give Harry what he thinks Harry needs. Although he did call Harry a fool and said a couple of other things that Harry probably didn't like, and then grabbed his hand to show us the actual murder weapon. And it was pretty big. And so he should know with those big mitts that he could kill someone with one bare hand. And he did. So we'll see how this, if it plays in his favor or not. Anything less than first-degree murder for Reddington is a win, right? So think of it that way. Moving on to, this is Elizabeth McLaughlin. Yeah, Mass Dad? Okay, moving on.
On May 15th, 2020, Katie McLean took her last breath with the defendant's hands wrapped around her neck, squeezing the life out of her. He took her lifeless body past her children's bedrooms, down the stairs, placed her into the car, and drove her to a home that she and the defendant had once looked at to buy for their family. He took her body through a dark wooded area with thick brush and trees and placed 2 large rocks in her leggings, and then he discarded her in that pond like a piece of trash. During the course of this trial, you have heard that Katie was married to Stephen Rocca and had 3 children with him. After that marriage ended, she was briefly married to a man named Chris Foley. And then in November 2017, she and the defendant met online and began their relationship. You heard that sometime in 2018, Katie and her 3 children moved into 29 Valley Road with the defendant, and her children began attending school in Dover. In December of 2019, Katie and the defendant were married in Las Vegas, but the relationship deteriorated, and by early February 2020, Katie had obtained a restraining order against the defendant, who was no longer living at 29 Valley Road. The pandemic hit about a month and a half later, and the world shut down. The defendant made his way to Florida and planned to sell the house at 29 Valley Road. Both he and Katie were moving forward with the divorce. However, on April 17th of 2020, that all changed when the defendant reached out through his lawyer, John Hoffman, and requested Katie consider a reconciliation. You heard testimony from Vanessa Pettigrew and Stephen Rocca that show Katie wasn't sure about the reconciliation, but she wanted to try to make her marriage work because she loved the defendant and she wanted stability for her children. So Katie and the defendant worked out an agreement to try to help Katie feel secure in the relationship, which included signing the deed on April 29th of 2020. To give Katie half ownership in the house, and the two also established a post-nup agreement. You heard on May 8th of 2020, Stephen Rocca drove Katie to New York to meet the defendant, and she and the defendant drove back to Massachusetts together. You saw surveillance video and the reservation receipt from the Marriott showing the defendant check in on May 8th with the intention of staying at the hotel until May 17th. But on May 15th, 2020, that hope of reconciliation came to an end when the defendant killed Katie in their bedroom at 29 Valley Road. And for that, the defendant is charged with first-degree murder.
Thank you.
The defense suggests that the defendant killed Katie in the heat of passion or in self-defense. He was under extreme stress from the pandemic, had just placed her name on the deed of the house, and snapped that night when she threatened to make him leave again. He also suggests that because Katie had texted with friends about her relationship with her husband, and because she wanted stability for her children, that she just wanted his house and his money, and never really wanted to reconcile. And that, coupled with the fear of being kicked out of his own home during the pandemic, is what led him to snap. Ladies and gentlemen, I suggest that is not heat of passion. It is not self-defense. It is motive to kill. And the defendant's text to Kurt Vandensteel after the murder is further evidence that the defendant did not snap and kill Katie and then instantly regret it like he wants you to believe. That text shows his constant and enduring belief that Katie was a vindictive devil, and it shows his motive to kill her, to get rid of her so that he would not have to go through another divorce and he would not lose his house again. I want to remind you about the defendant's statement on May 16th of 2020. It was 1 hour and 20 minutes into that interview when the police first suggested that Katie had hit the defendant. Sergeant Kakowski continues to suggest that Katie hit the defendant with something. He tells the defendant about the broken glass in the bedroom and points out the small abrasion on the defendant's head. It is not until then that the defendant adopts Sergeant Kakowski's statement that Katie had hit him. I would suggest to you that the defendant adopted this theory to minimize his culpability as he was confessing to killing Katie. A killing that was driven by greed. As we heard numerous times throughout this trial, it was his house and it was his money, and he was not going to give those things up.
We heard it.
In those moments, the defendant was not overcome with emotion or fear or panic. He was angry. And he wanted to make sure that Katie was not going to get his house. And the only way that would happen now that the deed was signed was if she was dead. And so he killed her. I would suggest to you that all of the evidence you have seen and heard throughout this trial shows that the defendant not only had the motive and intent to kill Katie, but he also had the opportunity when he got himself back into that house. I would point you to the evidence in the bedroom the shattered glass all over the floor. Katie's blood on that bed in 2 different spots. The photographs of the scrape on the defendant's head, coupled with his medical records that documented it simply as an abrasion. The lack of red-brown stains on any piece of glass that was photographed in that bedroom, and the small cuts on the defendant's hands by his thumb and index fingers, with the evidence of the defendant's DNA under Katie's fingernails. This evidence is not consistent with a single blow from a glass and a quick grab to the neck that caused death. I would suggest to you what this evidence is consistent with is a violent struggle. A violent struggle as Katie fought for her life in that bedroom. And the extensive injuries to Katie's head and neck described by Dr. Matthews are just further evidence of that violent struggle for Katie's life that occurred inside that bedroom on May 15th. Now I want to talk to you about what some of the defense witnesses said. Think about Attorney Hoffman's testimony and the series of emails sent by the defendant on April 10th, on April 13th, and April 15th. He was still committed to that divorce, and he wanted back in that house. And he wanted Katie and her 3 children to move to Belmont. And then 2 days later, he suddenly had a change of heart and wanted to reconcile. He wanted to make Katie and the kids feel secure. So he put her name on the deed, which meant that she was entitled to half the house if they were to get divorced. But also remember that becoming tenants in common on a deed means if one of them dies, the other one gets the house. Dr. Lapasadas testified that Katie's death was a result of a one-handed application of force. I would ask that you remember this is a doctor who has not examined a body in over 20 years. Her demeanor appeared aggressive and argumentative as she was testifying. And I would suggest, as a paid defense expert,
I did not think she seemed aggressive and defensive. This is Dr. Laposada, who is also going to be an expert for Karen Reed. So let's hear what she says about her. I didn't find her to be that way at all.
20 years. Her demeanor as a doctor who has not examined an application of force. I would ask that you remember this is a doctor who has not examined a body in over 20 years. Her demeanor appeared aggressive and argumentative as she was testifying. And I would suggest, as a paid defense expert, she had an agenda. And she wouldn't even answer the simplest question on cross-examination without pushing that agenda. Dr. Laposada also made sure to emphasize all the things that she did do as she considered the cause of death and the circumstances surrounding Katie's death. But there are 2 things that she did not do. She did not examine Katie's body, and she did not listen to the defendant's statement to police from May 16th of 2020. The statements in which he said, "I choked her. I grabbed her around the neck, and she was fighting, and I continued, and then she passed out." The defense suggests that this was an impulsive knee-jerk reaction. Dr. Zeisel testified that people in highly dangerous situations can have a fight or flight response and can act without thinking. He gave examples of hurricanes, mass shootings, and being attacked. But he also agreed in those situations, you do not lose your free will, and you do not lose the ability to make a choice. The defendant, who I suggest appeared methodical and detail-oriented, testified that he was down on his knees, begging Katie to stop as she was yelling at him and then hit him with a glass. He testified that he snapped and blacked out. But he did remember that he grabbed her by one hand on the neck. He described her flailing, and then they both fell to the ground, and he told you that when he came out of his blacked out state, he saw she was non-responsive, so he put her on the bed and started CPR. But it didn't work. I would remind you that in his original statement to the police on May 16th, 2020, he did not tell them he was on his knees. He did not tell them that he only grabbed her with one hand, and he did not tell them that he tried to perform CPR. In his testimony yesterday, he also told you that he panicked and wanted to move Katie's body so that her children would not find her. I would suggest that the defendant took the methodical and detail-oriented steps to dispose of Katie's body in an effort to save himself, not her children. At times during this trial, the defense has also tried to disparage, embarrass, and blame Katie. But I would suggest that is not what this case is about. And it was meant to distract you from the focus of this trial, which is the death of Katie McLean. Earlier, Judge Hallal instructed you on the elements that the Commonwealth must prove beyond a reasonable doubt in order for you to find the defendant guilty of first-degree murder. He explained that there are two different theories by which the Commonwealth can prove first-degree murder. The first is deliberate premeditation, and the second is extreme atrocity and cruelty. I submit to you that the Commonwealth has proven both theories beyond a reasonable doubt. When considering the first theory, deliberate premeditation, the first element under this theory, it's not contested. The defendant admitted in his interview that he killed Katie McLean by strangling her. He told you in this courtroom that he killed Katie. And Dr. Matthews, the medical examiner, testified that Katie's cause of death was strangulation. The second element is that the defendant intended to kill Katie. The defense suggests that the defendant did not form the necessary intent to kill Katie, and they point to his intoxication and also argue that he killed her in the heat of passion or in self-defense. When thinking about this, I want you to think about the defendant's own words in his interview to the police. You always have a choice. And I would suggest to you that the defendant made a choice in the early morning hours of May 15th to kill Katie. Think about his other statements during that interview. She was fighting and I continued. Then she passed out. He had a choice to stop as she was fighting, and he did not. In those moments, he made the choice to keep going and to kill Katie. And I suggest to you that is intent. Attorney Reddington suggests that the defendant was intoxicated and snapped and could not control his conduct. When considering whether the defendant's drinking that night played a role in his behavior, think about the meticulous steps that he took after she was dead. He carried Katie's body down the long staircase at 29 Valley Road. He placed her into her vehicle and drove her to a pond that he had been to before. He walked in the dark through thick brush and trees, causing the scratches and abrasions to his head, to his legs, and his arms. Then he placed two large rocks in her pants to weigh her down, to hold her body down. Then he started driving to Dedham, but realized that he had forgotten his phone, so he went back to the house. He got his wallet, he got his phone, he changed his clothes, he locked the bedroom door. He drove those windy, dark, country roads from Dover to Dedham, without crashing, without getting pulled over, and then he parked within his parking spot. He put on his mask. He removed his wallet from his pants. He swiped his card around 5:30 a.m. to enter that building. He walked past the reservation desk, through the lobby, and up to his second floor room. Not stumbling, not falling down, not incapacitated. I would suggest he is quite the opposite.
I would suggest that you play that video again during your closing, because we totally forgot about that video because it was in the way beginning of the trial when you had the residence inn manager testifying. And I want to see that video of him coming back into the hotel now after he put her in the pond. I want to see that again. Maybe they can watch it whenever they want. But yeah, now I want to go back and watch it now. Maybe not now, but later.
not stumbling, not falling. He walked past the reservation desk, through the lobby, and up to his second floor room. Not stumbling, not falling down, not incapacitated. I would suggest he is quite the opposite. He is cool, he is calm, and he is collected. His clothes and his hair are neat and orderly. And again, look at that coherent text he sent to Kurt about his hatred for Katie. This text does not show panic. It does not show remorse. It shows motive, and it shows intent. I would suggest to you that the defendant's behavior directly after the crime does not indicate that he was in a fit of rage or so intoxicated at the time he killed Katie. I would suggest to you it's the behavior of someone who is in complete control of himself. He is aware of his actions and the potential consequences, and he took well thought out, methodical steps to dispose of her body and cover his tracks.
Oh my gosh, look at Alan quoting Taylor Swift, really? Alan, first of all, do you know you're quoting Taylor Swift, plays stupid games, wins stupid prizes? Or do you have daughters who are Swifties? I need to know. I had to stop to find out, but I'm going to continue now.
Also remember the defendant was alone in that hotel room for 5 hours with a large bottle of alcohol that was half empty when the police entered at 10:50 a.m. During that time when he was alone in the room, he had time to think, he had time to reflect, and he had time to plan. Likewise, the defendant wants you to believe that he was either intoxicated at the time of his interview or was feeling the effects of his prior intoxication. He wants you to believe he was confused, he had memory lapses, and he didn't understand what he was saying because of his blood alcohol level when he was admitted to the hospital. I would ask that you use your common sense and your life experience when evaluating these statements. The Dedham police arrived at the hotel around 10:50 a.m. on May 15th and found the defendant, who was immediately transported to the hospital. His lab results from noon on May 15th show his blood alcohol level to be elevated. But remember, the interview with the police did not begin until 5:19 p.m. on May 16th, almost 30 hours later. Remember the testimony of Ailish Wilkie, who told you it was her job to protect the defendant, and she would not have let him talk to the police if he was unable to or if he was unwilling to. Think about the defendant's behavior in that interview, how clear his voice was while even wearing a mask, how he was able to spell everyone's last name correctly without being asked. Think about the testimony of Detective Gonski and Sergeant Kakowski that the defendant walked in and out of that room unassisted. He sat up in a chair throughout the entire interview, and he was calm and coherent throughout that entire interview. All of these details, coupled with the police being calm and patient and allowing the defendant the time he needed, point to the defendant's statement being knowing, voluntary, and intelligent. The third element, whether the defendant decided to kill Katie after a period of reflection, Judge Hallal instructed you that that period of reflection can be just a few seconds or minutes. I would suggest to you that the defendant's words to the police on May 16th, that Katie fought and he continued, paired with the small cuts around his thumb and his index finger and his DNA found under Katie's fingernails, indicate she was fighting him. And I would suggest it shows that he knew exactly what he was doing when he continued to strangle her as she was fighting for her life. The defendant's own words indicate he had time to reflect about his actions and those consequences. She was fighting and he kept going until she was dead. Also think about the fact that the defendant is a renowned surgeon. We heard a lot about that through this trial. He is trained to react under pressure. He has training on the human anatomy. But As he said in his original statement to the police, he admitted he did not try to resuscitate Katie, and he did not call 911. Instead, he removed her body from the house. He weighed her down with 2 large rocks, and he sunk her body in a murky pond. Ladies and gentlemen, I would submit to you that all of that is deliberate premeditation. The second theory of first-degree murder that you must consider is extreme atrocity and cruelty. As with deliberate premeditation, we know the defendant killed Katie. And when considering the second element, his intent, again, remember the defendant has substantial medical training as a doctor. I would suggest that any reasonable person would know that cutting off someone's air or blood supply could result in death. The defendant, with his significant medical training, would have known that wrapping his hands around Katie's neck and continuing to squeeze as she was fighting him would reasonably cause her death. And during his testimony, he acknowledged that. The third element, that the killing was done with extreme atrocity and cruelty. When thinking about this element, I want you to remember the defendant's statements during his interview, as well as Dr. Matthews' testimony. I would suggest that the defendant continued to strangle Katie while she was fighting shows his indifference to her suffering. Think about the testimony of Dr. Matthews and the extensive injuries that she detailed, the petechia in Katie's eyes, the external injuries to her neck, the internal injuries to her head and her neck, and her broken hyoid bone. Remember where Dr. Matthews said the hyoid bone was, placed within the neck muscles, and the fact that Katie's hyoid bone was fractured. And the hemorrhages in her neck were 4 layers deep. Dr. Matthews agreed that it would take significant force for those injuries to occur, and that all of Katie's injuries occurred before her death. That, coupled with the injuries to the defendant's hands and his DNA underneath her fingernails, shows that she was conscious and suffering as the defendant was squeezing the life out of her. I would suggest to you that all of this evidence shows beyond a reasonable doubt that Katie's death was completed with extreme atrocity and cruelty. Ladies and gentlemen, you were instructed at the beginning of this trial and again at the end of this trial on the meaning of reasonable doubt. You have heard that the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment. As you consider how the Commonwealth has convinced you of the defendant's guilt as to first-degree murder to a reasonable and moral certainty, I'd ask that you remember the layers of injuries to Katie's neck, her broken hyoid bone, the fact that the defendant was a doctor with extensive medical experience, and he knew that strangling Katie would reasonably result in her death. The statements to law enforcement that he made, you always have a choice. The 2 large rocks that he placed within her pants before dumping her half-naked body in that pond. The text he sent to Kurt after he had killed her and disposed of her body. That, members of the jury, is proof beyond a reasonable doubt. I'd ask that you consider all of the evidence and return with a verdict finding the defendant guilty of first-degree murder. Thank you.
All right, relatively short and sweet.
Thank you. Jurors, why don't you stand up for a minute if you want to stretch before I finish the instructions?
Okay, we're a little behind. 7th inning stretch for the jury.
All right, and the heading is no transcripts. So although our court reporter recorded everything in court during the course of the trial, we do not have written transcripts of any portions of the trial testimony that we can give you for use in your deliberations. You must therefore use and rely on your own collective memories of the evidence, assisted perhaps by your notes. Now, since determining the facts in this case is your duty and not mine, you are to draw no inferences, favorable or unfavorable, to any party because of anything that I, as the judge, may have said or done during the trial of this case. If somehow you think that during the course of the trial I made certain rulings that suggested how I felt the case was going in, or how any issue of fact should be resolved, or how you should find the facts, then you are to ignore it. Because this decision that you must make on what the facts are in this case must be made free from interference from anyone, including me. My role as the judge is to see that there is a fair, orderly, and efficient trial of this case. My role is also to rule on questions of evidence and matters of law, and to instruct you on the law as I am doing now. Your role in this case is the most important role in this trial, because you and you alone will determine what the facts are. In a sense, you are judges when you do that. You are the sole judges of the facts. Now, in deciding what the facts are, you all have certain tools available to you. The primary ones are your own common sense, good judgment, and general life experiences. Now, if in the course of opening statements or closing arguments or during the trial itself, the attorneys or even I as the judge call to your attention matters of evidence that you do not remember collectively as a jury, then you are free to ignore it, because it is your memory of what the testimony was and what the evidence is that controls your deliberations in this case. You alone will determine the weight and the effect and the value of the evidence and the believability of the witnesses. Once you make those determinations of fact, it is then your duty to apply them to the law as I now give it to you. In deciding whether the defendant is guilty or not guilty of the charges that have been brought against him, you must act without prejudice, without fear or favor, and make your judgment solely from a fair consideration of all of the evidence. Emotion or sympathy for one side or the other has no place in your deliberations, and you are not to decide this case on the basis of what you may have learned or heard outside of this courtroom. You may not speculate as to what might be or might not have been the facts, and you must not be influenced by the popularity or lack of popularity of the crimes that have been charged. Rather, you must confine your consideration to the evidence and nothing but the evidence, and your decision must be made based on common sense, good reasoning, and good judgment. Your decision must be made without partiality and without concern for the effects or the consequences of that decision. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, immigration status, language, religion, age, ability, gender, sexual orientation, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. We judges have the same problem, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all of the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you're actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you're focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you'll do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Let me talk about the respective roles of the assistant district attorneys and defense counsel. It is their role to present evidence in this case that is most helpful to their respective positions. It is also their duty to object when evidence is offered that they believe may be inadmissible under our rules of evidence. And the way those matters have been handled, as you've observed, is that I've either ruled on the objection from the bench and the case has proceeded, or we've had a discussion at the side of the bench, outside of your hearing, where I have addressed the matter of law at issue, made a decision, and the case has proceeded. Any such activity on the part of the assistant district attorneys or the defense attorney in this case in making an objection or requesting a sidebar conference is not to be held against either the Commonwealth or the defendant in your consideration of the evidence or in your deliberation of your verdict. Now, let me tell you what is evidence and what is not evidence in this case. Evidence is what you've heard from the witnesses who have testified here in court before you under oath and given answers to questions put to them by the assistant district attorneys and defense counsel. You've had a chance to listen to each witness, to observe each witness, to consider all of what he or she has said and how they've said it, and that is evidence. The quality or strength of the proof is not determined by the sheer volume of evidence or by the number of witnesses that have been presented at trial. Rather, it is the weight of the evidence, that is, its strength in proving or disproving the issues at stake, that is important. You should consider all of the facts and circumstances and evidence, and all of the witnesses that have been presented during the trial in determining whether the Commonwealth has proved each of the elements of the crime charged against the defendant in this case beyond a reasonable doubt. Now, some things that have occurred during the course of this trial are not evidence, and you may not consider these things in deciding the facts of this case. As I've already told you, the indictment in this case is not evidence. The fact that the defendant has been arrested or charged in this case is absolutely not evidence with respect to his guilt or innocence. A question put to a witness by an assistant district attorney or defense counsel, no matter how artfully phrased, is not evidence and is not to be considered by you unless and until the witness answers or adopts that question. Only the answers given by each witness are evidence. Also, you may not consider as evidence any questions, answers, or other matter that I've ordered stricken from the record and told you to disregard during the trial. You may not consider any item that was only marked for identification but never received in evidence at trial. The opening statements and closing arguments of counsel are important and helpful and appropriate, but they are not evidence in this case. The view is also not evidence in this case. Again, the view may have been important and helpful, but it is not evidence in this case. The personal beliefs of the court or counsel on any issue in this case or on what the evidence is not evidence. My instructions to you on the law and anything that I might have said to you in passing during the course of this trial is not evidence. Don't make up your minds about what the verdict should be until after you've retired to the jury room to decide this case and you and your fellow jurors have discussed all of the evidence thoroughly, thoughtfully, and carefully. Now, in the trial of this or any other case, there are two kinds of evidence, direct and circumstantial evidence. Direct evidence is proof of a fact, such as the testimony of an eyewitness, that is, someone who comes into the courtroom to tell you what he or she heard, saw, or felt. Generally, such testimony is based on the witness's 5 senses. Circumstantial evidence is proof of a chain of circumstances from which you may infer or conclude that a fact exists, even though it has not been proven directly. An inference is a permissible deduction that you may make from the evidence that you've accepted as believable. Inferences are things you do every day, little steps in reasoning in which you take some known information, apply your experience in life to it, and then draw a conclusion. You may draw an inference even if it is not necessary or inescapable, so long as it is reasonable and warranted by the evidence, and all the evidence and reasonable inferences in this case together prove the defendant's guilt beyond a reasonable doubt. Let me give you an example of an inference. If your mailbox was empty when you left home this morning, and you find mail in it when you get home tonight, you may infer that the mailman delivered the mail. Now, obviously, you didn't see the mailman deliver the mail, but from the fact that it was empty this morning and it is filled tonight, you can properly infer that the mailman came in the interim and delivered the mail. This is all that we mean by an inference. Whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant guilty beyond a reasonable doubt from all of the evidence in the case. Where the Commonwealth's case is based solely on circumstantial evidence, and that is for you to say, you may find the defendant guilty only if those circumstances are conclusive enough to leave you with a moral certainty that the defendant is guilty and that there is no other reasonable explanation of the facts as proven. Now, as I said, your function, among others, is to decide the credibility of the witnesses. In determining the credibility and the weight to be given to the testimony of each witness, you should consider such factors as the conduct and demeanor of the witness while testifying, the frankness or lack of frankness of that witness, the reasonableness or unreasonableness of the witness's testimony, the probability or improbability of that testimony, the opportunity or lack thereof to see or to know the facts concerning that to which the witness has testified, and the accuracy of the witness's memory as well as the degree of intelligence shown by the witness. You may also consider the witness's motive to testify for or against either party, and of course, the interest or lack of interest of the witness in the outcome of the case. You may also take into consideration the age and the character and the appearance of each witness at trial, as well as any bias that he or she may have shown in their testimony in determining the credit to be given to that testimony. In evaluating the evidence presented by a witness, you as jurors are free to believe everything that the witness says, some of what the witness says, or none of what the witness says. If there are any conflicts in the testimony, it is your function to resolve those conflicts and to determine where the truth lies. There is one more point about witnesses to address: expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge, that is, things that they have personally seen or heard or felt. However, in a variety of cases, issues arise that are beyond the experience of laypersons, and in those types of cases, we allow a person with specialized training or experience, called an expert witness, to testify, and to testify not only to facts, but also to opinions and the reasons for his or her opinions on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in his or her field does not put that witness on a higher level than any other witness, and you are to treat the so-called expert witness just like you would treat any other witness. In other words, as with any other witness, it is completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It is also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such a witness in whole or in part if you determine that the witness's opinion is not based on sufficient education and experience or that the testimony of the witness was motivated by some bias or interest in the case. You must
It is on 1.5 speed because I have to go to the bus stop soon. So we're trying to
also,
get through it.
has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember that expert witnesses do not decide cases, juries do. In the last analysis, an expert witness is like any other witness in the sense that you alone make the judgment about how much credibility and weight you give to the expert's testimony and what conclusions you draw from that testimony. Next, I'm going to instruct you with respect to matters that may have occurred or arisen during the trial, and generally about the evidence and what you may do with the evidence that you've heard in this case. The Commonwealth has introduced into evidence certain photographs showing Kathleen McLean. You will have those photographs with you during deliberations in connection with the testimony you've heard. The photographs are not pleasant. Indeed, they may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned from the photographs. Consider those photographs only as they may draw attention to a clinical medical status or to the nature of Kathleen McLean's injuries or to the nature of the incident itself. Now, you've heard testimony about statements by way of text messages and otherwise made by the decedent, Kathleen McLean. Those statements are to be considered by you for a limited purpose, that is, to show the state of mind of Kathleen McLean about her relationship with the defendant. You may only consider these statements as to Kathleen McLean's state of mind of the status of the relationship if you find that the defendant was aware of Kathleen McLean's state of mind regarding the relationship and only for the limited purpose of showing the defendant's motive. You may not consider any of Kathleen McLean's statements for the truth of the matters asserted in those statements. Now, you've heard testimony about a recorded statement allegedly made by the defendant concerning the offense which is charged in this case. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not. You may not consider any such statement in your deliberations unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that he is alleged to have made and that he made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may take into account the nature and duration of any conversations that the police officers had with the defendant. You may consider where and when the statement was made. You may consider any evidence you've heard about the defendant's physical and mental condition, his intelligence, age, education, and experience. If there is evidence that the defendant was under the influence of alcohol, you must take special care in determining whether any statement was the product of the defendant's rational intellect and free will. It is not enough that the statement was voluntary in the sense that it was not forced or tricked out of the defendant by physical intimidation or psychological pressure. It must also have been made freely and rationally. Obviously, a person cannot give up a valuable right freely if his brain is so clouded that he is not thinking straight. If you conclude that the defendant's level of intoxication from alcohol had rendered the defendant incapable of understanding the meaning and effect of his statement or incapable of withholding it, then you must exclude the defendant's statement from your deliberations as being involuntarily given. However, one's intoxication does not automatically make an otherwise voluntary act involuntary. You must look to all the circumstances to determine whether any statement was made freely and rationally. Each juror must determine whether the Commonwealth has proved beyond a reasonable doubt that any statement that the defendant made about the offense was made voluntarily, freely, and rationally. If any juror is not convinced beyond a reasonable doubt that the statement was voluntary, that juror may not use the statement as evidence in coming to his or her own conclusion about whether the Commonwealth has proved the charge beyond a reasonable doubt. If the Commonwealth has met that burden, then you may consider the defendant's statement and rely on it as much or as little as you think proper, along with all of the other evidence. There was evidence in this case that suggests the defendant was given Miranda warnings by the police prior to questioning. You may consider these Miranda warnings in your evaluation of voluntariness. Now, you've heard evidence suggesting that the defendant may have placed Kathleen McLean's body in a pond and weighed it down with rocks after the incident. If the Commonwealth has proven that the defendant placed Kathleen McLean's body in a pond and weighed it down with rocks after the incident, you may consider whether such action or actions indicate feelings of guilt by the defendant, and whether, in turn, such feelings of guilt reflect actual guilt on the charge in this case. You are not required to draw such inferences, and you may not do so unless they appear to be reasonable in light of all the circumstances of this case. If you decide that such inferences are reasonable, it will be up to you to decide how much importance to give them. However, you should always remember there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, for such feelings are sometimes found in innocent people. Finally, please be aware that standing alone, such evidence is not enough to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence. Let me now turn to the final part of my instructions. The first matter is that one of my functions is to appoint a foreperson for the jury, and in this case, I appoint the juror in seat number one, juror number one, as foreperson. Let me note that you are all equal in your voices and your votes as jurors in this case,
Juror
and
number
you should
one,
all discuss the matter
foreperson.
equally among yourselves. The reason we have a foreperson is twofold. First, the foreperson facilitates, if you will, or helps organize the discussions among the jurors during your deliberations. The foreperson has the responsibility of making sure that deliberations proceed in a fair and orderly manner, that every juror participates, and that you listen carefully and patiently to the views of each juror. Secondly, the foreperson will fill out the verdict slip speaking for the whole jury when you have reached a unanimous verdict, and will report it in open court on behalf of the jury. Your verdict when you are ready to return your verdict to the courtroom. The next matter is the law permits only 12 people to deliberate in a criminal case. Okay, so there are 16 of you here.
Let's see if they
So
show the
shortly, we will
tails.
by lot reduce your number to 12. Now, we chose 16 of you originally so that the process may properly go on to a conclusion if someone should get sick or have a personal loss in the family or some emergency. If you are chosen as an alternate, you'll be kept apart in another room from the deliberating jury, and although it may be frustrating, you may not discuss the case with one another or with anyone else. Like the deliberating jurors, you are under a continuing obligation not to have any contact whatsoever with the defendant, the lawyers, or any witness. If we get into a situation where we lose a deliberating juror because of some personal emergency or sickness, then I will send an alternate into the jury room. And so important is the role of the alternate that if I have to replace a juror, I'll tell the deliberating jury to start again, right from scratch as reconstituted, no matter how long the deliberations have gone. So if you're chosen as an alternate, please do not think that your contribution here is not valued, because it is. The verdict of the 12 of you who deliberate in this case must be unanimous. That is, all 12 of you must agree whether the verdict be not guilty or guilty. 12 people must be of one mind. Let me
Oh,
remind
there's
you
the
that with
sirens.
respect to the
First time all
indictment,
day.
you may find the defendant guilty only if you all unanimously agree, beyond a reasonable doubt, that the charge is proven beyond a reasonable doubt. And let me just say a few words about your deliberations in the jury room. You have been permitted to take notes, and some of you have chosen to do so. You may, of course, refer to your notes to remind you of what's gone on in the trial. But keep in mind that the memory of a juror who did not take notes may be just as good. Any notes that may have been taken necessarily will be incomplete and inadvertently may be inaccurate. They are not transcripts. In your deliberations, give no more and no less weight to the views of a fellow juror just because that juror did or did not take notes. Deliberate together, not 2 or 3 of you huddled off in a corner. The use of cell phones and any other personal wireless devices is not allowed under any circumstances at any time during jury deliberations. It is probably not a good idea to take a straw vote at the outset of your deliberations. If you do that, you might think that under your oath, you are bound to adhere to that initial impression,
Don't take
and
a
that is
straw
not
vote.
so. No member of this jury should ever attempt to communicate with the court by any means other than a signed writing. Any question you may have about this case should be in writing, signed by the foreperson. If you have a question, please state only the question and do not disclose any preliminary votes or views of the jurors. The foreperson will deliver the written communication to one of the court officers, who will see to it that is delivered to me. I will call in the lawyers, who will discuss the communication and get a response to you as soon as possible, but keep in mind there may be a delay. You may continue to deliberate while we are addressing your question, or you may stop your deliberations. It's entirely up to you, but you all must agree. And remember, because I am only the judge of the law and you are the judges of the facts, I cannot answer any questions you may have as to what the evidence was. You cannot seek an answer to any question you may have by consulting a dictionary or any other book or source of information, including the internet. The pace of your deliberations is entirely up to you. Your deliberations are to be conducted in secret. You are not to disclose to anyone outside the jury room, not even to the court, how you stand numerically or otherwise on the matters before you. You are not to discuss, even with the court officers who are looking after you, how things are going in deliberations, what people said, how you are feeling. Your communications with the court officers should have to do with matters of scheduling breaks, when you come back to the courtroom, and that kind of thing.
Doesn't mean they're
But do
taking her
not,
case.
even with the
It
court
doesn't mean
officers,
they're
discuss
taking her
what's going
case.
on in the jury room. You'll note shortly as well, from the oath taken by the court officers, that they too, as well as any other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching the merits of this case. When you are unanimous as to your verdict, the foreperson will check the appropriate box. The foreperson will sign and date the verdict slip. When you've arrived at your verdict, the foreperson should inform the court officers, and they will bring you back into the courtroom to receive your verdict.
No, no, no. Do
And
not
one
spread
last point before-
administration. The Supreme Court has said that they are having a conference to decide whether or not they're going to take Karen's case on April 25th, 2025. Doesn't mean they're going to take it. This is a little bit fast, so I got to get through this because I got to go to the bus stop.
Before you begin your deliberations, please have confidence in what you're about to do. You're all people of intelligence and common sense with many years of experience in the real world. And collectively, you bring to bear a very powerful force in determining the truth of matters in controversy.
Doesn't mean they're
Our
looking
system
at
of
it. They're
trial
just
by
having a
jury
conference.
began over 9 centuries ago in England and has lasted largely uninterrupted to the present. If it had not proved to be a very powerful institution in providing justice, it would not have lasted as long as it has. So have confidence that you, working together, will be able to arrive at a verdict in this case. I'm confident that you will discharge your duties faithfully and well. Can I see counsel at sidebar, please?
Let me see if they're gonna, I wanna watch them pick the alternates to see if they show the whole bingo things. Oh, come on, man.
So jurors,
Oh, wait, okay.
are you going to reduce the?
May I reduce the jury?
All right, so jurors.
Yeah, love her.
Ms. Sannel is
Margaret.
going to reduce the jury.
Court clerk.
I want to apologize in advance. This is our system. Our Constitution calls for a jury of 12.
No,
We
they're
have
not.
a jury of
Listen,
12
stop
plus-
with the misinformation in the chat. The Supreme Court of the United States has not said that they are going to hear Karen's case. It's going to be discussed at a conference on April 25th. Please, please, please do not spread misinformation in the chat. Thank you. This is procedure for the SCOTUS.
4 alternates. So 4 of you need to be alternates. The way we do it is with this contraption over here that's, I think, just as old as the courthouse is. And we put the numbers in with the exception of the 4-person.
They went to sidebar, and I
Ms.
think they
Sannel
all
will
looked
pull
at the
out,
numbers
4
to make sure
numbers,
everybody
and
was in
those
there,
jurors will be alternates. But I know it's frustrating if you're selected as an alternate. I just wanted to apologize.
which is a little more transparent than they did in Karen Reed's case.
The time having come for the final submission of the case to the jury and a panel of 16 members being present, I shall now place the numbers of all the jurors except the 4-person and draw 4 who shall be designated as alternate jurors.
Go, Margaret. Go, Margaret. See, they showed all the bingo tiles to all the attorneys, and then they're pulling in the thing. So they're doing it the right way.
Okay, juror in seat 16, juror in seat 14,
She's showing
juror in
everybody.
seat 5,
Interesting.
and juror in seat 6.
So
who have
different.
each been designated as alternate jurors to be kept separate and apart from the deliberating jury.
So different.
Okay. All right, thank you. So we'll swear the court officers. Okay.
If all court officers could please raise your right hand. Do each of you solemnly swear that you will take charge of this jury and keep them together in some convenient place until they have agreed that you will not speak to them yourselves nor suffer anyone to speak to them except to ask if they have agreed or by order of court, so help you God? Yes, I do. Thank you.
All right, so jurors, I'm going to send you out to begin your deliberations, obviously late in the day. I'll have the court officer check on you at 4:15, see if you want to stay a little bit later or if you want to suspend for the day and come back tomorrow.
Oh, he's going to check
You're
on them
gonna
at
get the
4:15.
evidence, brought into the deliberation room. You all have copies of the instructions that I just read. You're also going to get the verdict slip. And there's, with respect to the electronic evidence, there's a laptop in there that's been approved by both
Yes, Your Honor.
sides to play that evidence?
Yes.
Okay. All right, so I'm going to send you out, ask that you begin your deliberations.
Here's what's really going to interest me, right? They've got first-degree murder, second-degree murder, and manslaughter. They've got 3 counts. If they come back and say they're hung, is the judge going to say, were you able to reach a consensus on count 1? Were you able to reach a consensus on count 2 or count 3, or are you hung on all counts? Very, very curious. Thank you for Venmos. Donna, Marie, Colleen, thank you very much. I'm going to run to the bus. I'm going to let this play because at 4:15 they're going to call the jury back and see whether or not they're going to continue. So I'm going to leave the fan on for you guys. Just talk amongst yourselves for a couple minutes. I'll be right back, okay? All right. Thank you. I will be right back. Don't worry. I did not forget about you. If anybody comes in and they're worried, don't worry. I'll be right back.
Yes.
All right. You satisfied with the verdict slip?
Yes.
Satisfied with the
Okay.
verdict
And what
slip?
about the exhibits?
I'm looking at them right now.
Okay.
We did finish the redactions. I just think we need one more sleeve for the medical records. I have that.
Yeah, I went through the binders. I have not gone through the chalks. Might take a little.
Okay, so some of the chalks were actually introduced
Yes,
as
I agree.
numbered exhibits.
Mind if I step off?
No, I'm going to step off as well.
Thank you, Your Honor.
All right, thank you.
You need to come in.
Yeah, I'm gonna see you, Harry. Jesus Christ. I'll see you fucking.
My list, very big, but if you want to start, I don't know.
Evan, the woman that you made take a flight is the alternate juror.
Seriously?
Yes.
I cannot believe you didn't make her the fourth person. That's so
The woman that you made take a flight from a wedding, she's an alternate.
That's awful.
Spirit, no less.
Why didn't you make her the fourth person? She would have gotten to be the fourth person.
I completely forgot about that. It was like
Tell
very.
him I said that.
Actually, it was your client who goes, I heavily object.
Oh my God.
Her brain or her body?
Where are you putting? So I mixed them all up.
It's a black one.
Did they swear in the court
They
officers?
separate the
Okay, I
alternates
missed
from
that.
the deliberates, right?
Who did we lose? Huh?
Like waiting for stuff to happen.
And then one guy at the end. Lady that was sleeping. Oh, well, that's good. The what? Oh, the, yes. Yeah. Yeah. Which is like, how do you fall asleep during mine? I'm so loud and I was like screaming.
Put them in the chairs over.
54-year-old male, the male
We have two
carrier.
men.
And the nurse.
Margaret said I can do it.
All right. I cannot believe that poor woman.
I know.
is an alternate.
I wanted to jump up and say I object, but
He lies and he doesn't.
Well, you can go, maybe his next.
maybe number one will drop out and we get an alternate.
I knew that was gonna happen.
You knew she was gonna be there.
Yeah, because I assumed he picked the one in number one. Sometimes I just do that.
It's complete. Spirit.
Okay, we just, counsel to say on the record, your content needs to be
Kevin, come here for a second. Yeah, that's for me and Kevin. Yeah. All right. Closer.
When you're, counsel, when you're ready, could you just state for the record that you're content with the exhibits?
The Commonwealth is content.
Mr. Reddington?
Yeah, I'm content.
Yes.
Perfect.
Now I don't get to babysit him.
Hey.
This and then that box. Yes, the one.
He just wants to point out what I left out of the closing that I should have commented on.
I put money on with Beth that he was gonna jump up at the end and add some things. I really
You
thought
should
so.
have added, you should have been allowed to address the jury. You should have been allowed to question witnesses.
Really? Is that what he wants?
Oh, yeah, yeah. Did you remember when he asked the judge if he could be co-counsel?
Yes.
Right here, look at this.
Great job.
Witnesses.
You did excellent with what you could.
Witnesses.
A guy who confesses.
What's up?
The microphone's on right now? The microphone is on right now?
It's saying they can hear everything that's going on.
Gee, golly, I made a mistake.
Did you miss me? Did you miss me? I'm back. I'm back. Got a little more information on the Karen Reed Supreme Court thing, so hang tight and I'll share it with you. The foreman was just picked by the judge. The judge said, seat number 1, you're going to be the foreman, or foreperson. I'm not sure if it's a man or a woman. However, in New York, whoever is sitting in seat number 1 is always the foreperson. That's the way we do it here. So Massachusetts is a little bit different. I'm going to put my volume back to a normal. I had to lower it for the court volume, so now you can adjust your court volume. Now you can adjust your own volume. We noticed also that Margaret, the court clerk, also showed both sides all of the little bingo Scrabble tiles before she put them in the drum. They did that at sidebar. And then as she picked them out, she held them up and showed them to everyone, which was so different than the way Clerk Jim did it, right? The Reed foreman was in seat 1 as well. I don't know if that was a coincidence or what, but like I said, in New York, it's always seat number 1. So I don't know, Stephanie. Yes, you called in a wellness check for me? Thank you. I did not hear the hot mic. What were they saying? Oh, that's funny. Oh, I went to the bus stop, and then I got stuck behind a bus, and then I have to drive to the bus stop because it's kind of far away. And then I got stuck behind a bus on the bus, going to the bus stop that stopped every, like 15 minutes. I mean, every 15 feet. So, it's the thing. Let me see where that information is for you because, I'm here for you. Should we play a game? What should we do? Should we do some trivia or something? All right, let's see. Ted Daniel says, here it is. This over here. Move this over here. Ted Daniel on his Twitter posted this 29 minutes ago, new item on the Karen Reed SCOTUS docket. I've been told, he says, that this means the High Court will decide on April 25th if they want to take this case up. This is how, quote, distributed for conferences described. At the Supreme Court, petitions and other filings are distributed to justices for consideration at conferences, with the clerk's office distributing 2 main conference lists each week and the case distribution schedule available on the court's website. I think they publish it every Monday, what's going to be heard that week, but we have now learned that it is distributed for conference on April 25th, and that is dated today. So the thing is also this. Karen's team has filed a petition for a stay from the Supreme Court to stay her trial pending deciding whether or not they're going to hear that. So I do not know if the petition for the stay will be heard before the conference about whether or not they're going to take her case to the Supreme Court of the United States level. The odds of it being accepted to hear are 1%. 1%. There are approximately 8,000 writs of certiorari filed per year at the U.S. Supreme Court, and they pick about 80 of them. So the chances are slim that they will even hear it, but hey, it's something. Now, that's the other thing. Karen, I guess, told the press yesterday, because one of the reporters tweeted it, they're supposed to do openings next Tuesday, which would be on the 15th. If the Supreme Court is having a conference on whether or not they're taking her case 10 days later, will the judge agree to a stay until after that date? I don't know. What are the odds? That is right, Scott. Scott knows. Kindergarten cop is here. Growing up on Long Island, we walked to school uphill both ways in the snow with no shoes. We sure did. Yeah, this is vile, KDB. The case in Connecticut, stepmom Kimberly Sullivan kept her stepson locked away in a room for 20 years. He weighs 69 pounds and he's early 30s household. Yeah, revolting. Reminds me, not really, but like that Vander Ark case, I couldn't cover that either. I couldn't do it. And you know what? If I did, I probably would have gained 100,000 subs, but I didn't do it. Duty Ron's case blew up when he decided to cover Vander Ark, and that to me is completely revolting. No thanks. I choose cases to cover that I really feel passionate about. And I chose this one because it's in the Norfolk Superior Courthouse, and I wanted to see what a different judge would be like right next door. So I feel like the cases that I choose have purpose. They're not done for popularity reasons, clearly, but let me know what you think. I couldn't do Vander Ark at all. I found that completely revolting. Oops. I would like to do at some point like a whole recap on JonBenet Ramsey, because I lived in Boulder for many years, and so that is a story that is close to my heart. That Connecticut case, can't touch it. And the Vallow thing, you know what, Steph? I feel like everyone's covering it, and so many people covered it for so long. I'm just so tired of that woman. Like, I don't know. And plus, we were also already involved in this trial, so I mean, and there's, Koberger's there, but the Koberger thing is not. The trial's not even going to happen until August. So, like, there's time on that. Same. Oh, I'd like to see Boulder make a caller in the Ramsey case. That'd be a good start. Yeah. Wouldn't it? Yeah, wouldn't it? Same. Can PD's Orphanage for Wayward Methodology. That's a great name. That's such a great. Oh, thank you. Thank you, John Little, no relation. Says I have a big heart. That's why we love your platform. Oh, thank you. Do we know yet what Ms. Little's note to Bev was? Oh, yes. Somebody wrote me an email and said that somebody in Lawyer You Know's chat. All right. So just don't take this for what it's worth. Thank you, Donna, for your email. She said, someone said on Lawyer You Know's live show that a potential juror posted photos on Facebook and Instagram from inside jury selection in the courtroom. They sent those screenshots to Atty. This is why they met with the judge this morning. I cannot confirm or deny, but I do know that, was it yesterday, that I had some social media posts, and I don't know if it's the same post or it was something different, so I don't really know. So thank you for your super chat, M. Mange, but cannot confirm with the deny. Christy, a painter's daughter, said, Melanie, help us with this one, please. Evidence? I think you're talking about the 3 unknown contributors of DNA to the alleged red-brown stain on the comforter. I have to go back and watch that testimony again because that went right over my head. Was he trying to say that she had other men in the bed when he wasn't living there? Like, I don't even know where to go with that, Christy. Honey Bear gifted 10 memberships. Thank you again for that. I put that up earlier, but again, so generous. You're all so very generous. Tracy says, can you explain legally why she got to stay in the house? Well, they were married. And so marital property until such time as the divorce, because they didn't have a prenup, right? Not being fully familiar with the division of property laws in the state of Massachusetts with regard to divorce as such. She got a restraining order against him. He was served in the driveway with the restraining order and told that he had to stay away from the house. And so he couldn't come back in. And legally, that's why. She had 3 children there. Listen, we've seen a lot of judges in Massachusetts. Can you name one judge that would have thrown her out of the house with her 3 kids? And, considering she had a domestic violence restraining order against him? Hope that helps you understand it. Glamasu says that there was an MBTA train and tractor trailer collision in Canton. I hope they know how to secure the scene. Heavy snark. Whatever happened with that? You sent me that at 2:27. Does anybody know what's happening there? That was about an hour and a half ago. It's near the courthouse. I mean, Canton's, how big is Canton? I mean, Canton's, well, the courthouse is in Dedham, so forget it. Shannon says, he's a gross man. Do you think deliberations will be quick? Do we know how many women are on the jury? I don't know. But I will say this. The people who seem to be sympathetic with him, at least in this chat, are mostly men. A couple of women, strays here and there, but mostly men are just like, maybe they've been screwed over in the past by by someone they were in a relationship with. And so I think he might do better with men on the jury. What do you think, Shannon? What do you guys all think? Kaylee, Meanies asks, do you know the New York firm Martin Clearwater Bell? Yes, I do. I was a live-in nanny for a family in New York City during college 12 years ago. Boss was a senior partner in a Long Island office. Just curious. Yeah, they're a big firm though. They probably had hundreds of lawyers at the time. But yes, they're a defense firm. So yes, I had many cases with that firm. Good firm. Thank you, Kaylee, for your 10. What do you guys think? Peace and Christ says that is such a stark contrast between judges and the way that a court session is run. Yep. Well, what happened with the hot mic? What happened with the hot mic? I don't know. Should I go back? I mean, we're going to be here until 4:15.
On your own that you've heard in
I
this
think maybe the judge has a bad back, and that's why he was standing up, because he told the jurors they could do a 7th inning stretch too.
the alternates.
So we saw her pick the alternates.
You satisfied with the verdict slip?
Yes,
Satisfied with
And
it?
what about the
Everyone's
exhibits?
satisfied with the verdict slip.
I'm looking at them right now.
Okay.
We did finish the redactions. I just think we need one more sleeve for the medical records.
I have that. Have not gone through the chalks.
Chalks.
I'm going to step off as well.
Thank you, Your Honor.
All right, thank you.
All right, we'll let it play and listen to the hot mics. If you guys say it was fun, it's fun.
Yeah, I'm gonna see you, Harry. Jesus Christ.
Yeah, I'm gonna see you, Harry. Jesus Christ, what did he just say? Hold on a second. Hold on a minute. Let me take myself off this, or on the other side of the. I guess they're taking Harry back into custody while they await the jury. They're not gonna let him sit there without his shackles on. Hold on.
I'm going to step off as well.
Thank you, Your Honor.
All right, thank you.
All rise.
Yeah, I'm gonna see you, Harry. Jesus Christ.
I'm gonna see you in an effing minute. Jesus Christ, Harry gets better. Okay.
My list, very big, but if you want to start, I don't know where.
Oh, you guys are entertained while I was gone. I'm glad. Can a judge get a stand-up table? Not so much. Of course I'm gonna see you, Harry. Jesus Christ. Like, please, 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 Kev, don't leave me. Don't leave me, Kev. So gangsta. Listening to the hot mic moments. He's got way more money than me.
Do we have a laptop, Cindy? Yep, and it's already, Kevin's already fine with it.
I feel like we're eavesdropping.
That's over, right? With all of you, just thank you for that.
Thank you.
All right, so you have what number?
Well, even make it a night of it.
Okay, good. 283, 284. Nope. 285, 286, 287, 288.
I have 289 and 290.
We're listening to it now.
Okay, I have 291.
Did we miss it?
What's 306 and
Over
307?
here, 306, 307, 308 are in here.
Okay, 309, 310.
Kevin, the woman that you made take a flight is the alternate juror.
Seriously?
Yes.
I cannot believe you didn't make her the foreperson. That's so
The woman that you made take a flight from a wedding, she's an alternate.
That's awful.
Spirit, no less.
Why didn't you make her the foreperson? She would have gotten to be the foreperson.
I completely forgot about that. It was like
Tell him
3
I
weeks
said
ago.
that.
Well, actually, it was your client who goes, I heavily object.
Oh my God.
Her brain or her body?
Where are you putting it? Did they swear in the court officers?
They separate the
Okay, I
officers
missed
from
that.
the deliveries, right?
Who did we lose? Who did we lose?
Waiting for stuff to happen.
Who did we lose? And then one guy at the end. Lady that was sleeping. Oh, well, that's good. The what? Oh, the, yes. Yeah. Yeah. Which is like, how do you fall asleep during mine? I'm so loud and I was like screaming. 54-year-old male, the mail
We have two
carrier.
men.
Yep. And the nurse.
They're
All right.
they're talking about the jurors.
I cannot believe that poor woman. I know. Is an alternate.
I wanted to jump up and say I object, but
Well, you can go. Maybe his next.
maybe number one will drop out and we have an alternate.
I knew that was gonna happen.
You knew she was going to be there.
Yeah, because I assumed he picked the one in number one. Sometimes I don't know that, so I don't know.
It's complete.
Is there more?
Kevin, come here for a second. Yeah, come with me and Kevin. Yep. All right. Closer. When you're
content. Perfect. He just wants to point out what I left out in the closing that I should have commented on.
I put money on with Beth that he was gonna jump up at the end and add some things. I really
You
thought
should
so.
have added, you should have been allowed to address the jury, you should have been allowed to question witnesses.
Really? Is that what he wants?
Oh, yeah, yeah. Did you remember when he asked the judge if he could be co-counsel?
Yes.
Can you hear it?
Right here, look at this.
Great job.
Witnesses.
You did excellent with what you could.
Witnesses.
Guy who confesses.
He's saying that Harry said he wanted to be co-counsel, that he wanted to question some of the witnesses, and that he wanted to add some things to the closing. Oh my God, hilarious. Did you guys hear it? Harry wanted to be co-counsel. Yeah. Somebody says the microphone's on right now.
It's saying they can hear everything that's going on.
He goes, gee golly, I made a mistake. That's funny.
Right here, look at this.
Great job.
Witnesses.
You did excellent with what you could.
Witnesses.
Guy who confesses.
Yeah, he says, I'm like, Harry wanted to be co-counsel. He asked the judge if he could be co-counsel. The jury is out right now until 4:15, which it is now, and then the judge is going to ask them if they want to stay longer or if they want to go home and come back tomorrow. So now we're waiting. Yeah, let's not get Reddington in trouble. All right, well, we can get some more information from some other amazing people on Twitter, like Lana Del Turtle, and we'll read her tweet about Karen Reed's situation. Lana says, this afternoon, Karen Reed's petition for certiorari was distributed for conference by the U.S. Supreme Court. What does that mean? Every week, the Supreme Court Clerk's Office distributes petitions to the justices' chambers for a conference, which is usually held a couple weeks later. Supreme Court uses a pool system, so 8 of the justices consider 1/8 of the petitions distributed that week. A 9th justice, currently Justice Alito, is responsible for reviewing all petitions distributed. For the pool justices, the petitions are read by one of the 4 law clerks, typically found in each of the justices' chambers. Each of them writes a memorandum about each petition they read that summarizes the petition with a recommendation about whether or not it should be granted. The pool memoranda are then distributed to all of the justices. Prior to the conference, the Chief Justice circulates a discussion list containing any petitions he deems worthy of further discussion. Each justice can add to the list any petition they deem worthy. Very few petitions on the discuss list are granted. If a petition is granted, the process moves forward with a briefing schedule. The remaining petitions are automatically denied. Karen Reed's appellate team also filed a separate application for a stay of the Norfolk County trial. The application for the stay will be considered only by Justice Jackson. We're still waiting for Justice Jackson's decision about the stay. If Justice Jackson grants the stay, Norfolk County jury won't be sworn until the justices grant or deny the petition for certiorari. If the petition is granted, the stay will likely be extended. All right, well, that's interesting. That's interesting. Well, we are here. The jury is out. They said they're going to come back at 4:15 and let us know whether or not Oh, Ted Daniels 3 minutes ago. Stay has been denied. You guys, Kelly, you're on top of it. Let us see. That was quick anyway. Just can't keep up with all the breaking news. Breaking news. Karen Reed's emergency application to stay or postpone her trial has been denied by a single justice. So it has been denied by a single justice, according to SCOTUS PIO. My understanding is that the appeal could still be considered, but the trial will not be stopped or delayed. We're not wild about Harry. We're not wild about Harry. There's 8 men and 7 women. They need another woman. A stay would be like they halt the trial. They halt it. Like it's standing still, standing stone, 1776. A stay would be freeze in place. That is what it means. And so we wait. Today, he also says that there were 3 new candidates selected today for a total of 15 seats filled. 8 men, 7 women. A number of jury candidates were just sent home without being questioned due to time. All right, so I guess they're going to come back tomorrow. I think I read somewhere on my travels that they're going to keep adding more alternates, but they will not extend the days in which to pick the jury. So they're not going to go past Friday. Right. I think that was Justice Jackson who was in charge of deciding the stay, and she said no. She said, nope. We have an emoji for that. Nope. Disappointing, but not shocking. Wouldn't the defense be ready? Why delay? Because if they're going to throw out 2 of the counts, then they wouldn't try their case for murder and the 3rd count. So your prep would be different for trial if you were only prepping for manslaughter as opposed to prepping for the 2nd-degree murder charge. And so that is why. Watching the OnlyFans, they will do tomorrow to get 16. Well, they have 16. Wait, didn't they just say they have 16? Hold on. It's been a long day. No, they have 15. Sorry, they have 15. 8 men, 7 women. Thank you. 15, 15, 15. Oh, sweetie, no. Oh, sweetie, no. 8 men, 7 women. 8 men, 7 women. According to Ted Daniel, 37 minutes ago, done for the day. 15 seats are filled. 8 men, 7 women on the Karen Reed trial. Supreme Court of the United States has decided not to stay the trial, but they are having a conference to determine whether or not they will even hear the case at all, and that's not until April 25th, but there's no stay. So we're just going to keep plodding ahead. Karen Reed trial is supposed to start on Tuesday with openings, and it will still be going on by the time the Supreme Court decides on the 25th whether or not they're even going to hear the case. So I do not know. Yeah, it seems she ended the day early again, but this Judge Hallal, he's going till at least 4:15, and then he's going to let the jury decide if they want to even stay longer. So there's that. Well, the Tuerk jury can't find him guilty on all the counts, because if they find him guilty of count 1, which is 1st-degree murder, then they stop. They're done. If they find him not guilty of count 1, then they go on to murder in the 2nd degree. And if they find him not guilty on that, then they go on to manslaughter. See how that works? But the verdict slip should absolutely be clear about that. Hopefully. Karen was just interviewed coming out of the courthouse that she's pleased with the jurors picked thus far. That's good. Yes, thank you, Tom. We just went over that. The stay has been denied. So it's 4:24. You think they got a verdict? The issue is there anybody live tweeting from the Tuerk courtroom? I don't think so. Because, not even your local media in Boston is covering this. They didn't cover it until They didn't cover it until he took the stand. Then all of a sudden they said they were covering it. Right? No, not even is it not a Judge Cannoni verdict slip, Dorothy, but they actually showed all the attorneys, all the tiles, the little Scrabble tiles, before they put them in their bingo drum. And then when they rolled the bingo drum, they pulled them out one by one and they showed all of the attorneys the actual tiles. No, I did not hear him say not to fill out until unanimous on all counts because, well, they're actually murder 1, manslaughter. I'm imagining it's 3 separate sheets, right? So it's murder 1, murder 2, and then manslaughter. Similar to Karen, right? So there's that. Kelly O'Brien says, co-counsel Harry wannabe. I don't need any more information. Personality determined disordered, in my opinion. Strong first degree for me. Thanks, Kelly. The chat was split earlier. I was going with second degree. I thought it would be an easier conviction because it didn't require the premeditation part. Just that he knew or should have known that what he was doing would cause grievous bodily injury or death. And here's where the chat was earlier today. 30% first degree, 36% second degree, and 33% manslaughter. So a third, a third, a third. There was no clear winner in this chat, and that was only with 1,500 votes, even though there was at least double the amount of people in here at the time. So it is interesting. A poll lately of the outcome of Karen Reed? How can we do a poll? We haven't even heard the second trial yet. We don't even know what evidence there, what new stuff is coming out. I can't do a poll before I hear the evidence. No, Burning Queen. That would be bad luck. What should we ask the Magic 8 Ball? We don't know the breakdown of this jury. You know why? Because nobody's covering it. Nobody's reporting on it. Nobody's live tweeting on it. It's the 8 Ball time. Kelly says second degree. How old is Harry? Harry is 63, I think now. So he was 58 at the time. This happened in 2020, 5 years ago. Or maybe, I think somebody said his birthday is in September, so he might be 62. Turning 63? Oh, look at that. Massachusetts State Police orphanage for wayward methodology. All right, come on, Dr. Judge Stanley Tucci. Melanie's getting tired. Melanie's getting tired. Exactly. Given his age, it won't matter. Any sentence is likely a life sentence for Tuerk. 62. Yeah, so even at 25 years, 20 years, he's still going to be 82. Let's see. Will there be a verdict today? Thanks, Shelly. Will there be a verdict today? We're going to ask the Magic 8 Ball. I mean, the Magic 8 Ball is like just as good as sometimes. Oh, it says don't count on it. Well, don't count on it. Okay. Here's another question for the Magic 8 Ball. From Trooper Paul's School of Dance. Ask the 8 Ball if Trooper Paul will actually show us the pirouette this time. You may rely on it. You may rely on that. So maybe the Trooper Paul, will they even call Trooper Paul? I don't know. I feel like they're going to sideline him maybe and call their own expert. Maybe not even let him testify at all. Now on their case in chief, I don't know. What is the minimum he's looking at? Well, if they find him not guilty, he gets to go home. He's been in jail for 5 years. We looked at manslaughter, was up to 20 years. He's going to get credit for time served. He's already been in for 5. So if he gets convicted of first degree, it's murder. Murder. Murder in the first degree is life without possibility of parole. Murder in the second degree is life with possibility of parole after a certain period of time that the judge will determine, and then manslaughter is up to 20 years. Kelly says, in my opinion, verdict tomorrow. Tomorrow's not good for me. I have a conflict tomorrow. I have a big day with one of my kids. It's a day that I have obligations, full day obligations with a child. So thank you, Sherilyn, for your cash app to get a snack. I appreciate you. Thank you. I mean, we've been here this long with Harry. I don't know. I haven't heard it. You've heard confirmation that Alessia is closing. I heard Jackson was opening. My hope is that Yannetti does the closing after I heard his closing for the Jeffrey Curley case. He's got the velvet hammer. Has there been confirmation of that? I don't like to spread misinformation. But if you just say, I think it should be this and this, then I'll allow it. In my opinion, verdict on Tuesday? But it's only Wednesday. You think it's going to take that long? Big old dog says if he gets manslaughter, he's going to be out another 5 years. Oh, they're back. Or he said, can I see counsel, please? I don't know. Do you think they have a verdict? I mean, he said, can I see counsel, please? I don't know, you guys. Wait, fan, why did you stop? Somebody needs to spackle that ceiling. It's really upsetting me greatly. All right. What do you think? Anybody local to Dedham? Could you like volunteer your services maybe? Or maybe they'll actually give you a maybe they'll actually pay you to spackle that ceiling because it's a historical courthouse. Like that's unacceptable. Patty, they may have gone back there and done like, okay, who thinks he's guilty of first degree? Go around the table. Okay, who can settle for second degree? Okay, who can settle for manslaughter? And they'd be like, maybe. Could it have been that easy? They got their free lunch, right? We don't know. The judge just said something about, can I see the attorneys? We don't know. Are they just super hung? Are they just hangry and want dinner? Oh. Okay, hang on. I agree with you, San Fran Joe. That's one thing we agree on today. They're like, now they know about the hot mics. They're like, okay, shh. I'm going to turn my mic down again for you because I'm so accommodating that way. Ooh, he's chatting with the clerk. They're just having a little, one of the court officers. Hi, Michelle. Yeah, they need to deliberate for a very long time and be hung for a very long time before they will agree on a mistrial, or which would be a hung jury. As such in the Karen Reed case. But I bet this judge would actually poll the jury and say, oh, well, have you come to a consensus on any of the counts? And then perhaps he would be acquitted of first degree and during, what?
And so without any evidence and apparently sidestepping the clear explanation, he makes those. And so that doesn't make me happy.
We love you, but why did they just stop? They cut the camera in the, really? How are we going to know what's going to happen? How are we supposed to know? Nobody's, oh, and here's Lori Vallow cross-examining somebody. How are we supposed to know what's going on? Court TV has it? I don't think they have Turk, do they? All right, I'll look. That was not me. That was not Melanie Little's left swipe and streamer. That was Law and Crime cutting off their camera. No, they're doing a premiere right now, which means it's old testimony. How are we supposed to know? The only person reporting on this is me. That's fantastic. Not. Did they start a new stream over there? Hang on. Did they have to cut that camera off because they needed it for another trial? They got one of the hot mics, so the judge ordered them to shut it all down. That's my bet. Court TV has the deliberation clock. Oh, is it on their website, though? Maybe it's not on their YouTube. Is that what you're saying? All right, hang on a second. Because if we have to watch it on their website, that means we have to suffer through the damn commercials. We don't like that. They did it again to us. They're going home for the day? How do you guys know? How do you know, Kidada? How do you know they're going home for the day? Broken Baker got cut off too. It's on the web. Is it on their live feed? Yeah, it's got the deliberation clock counting down at 57 minutes and 50 seconds. How do we know he's going home for the day? Oh man, this is more than annoying. Why would law and crime do that unless the judge did it? I mean, see, they've got the clock here, 58 minutes and 23 seconds. Boo, 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 boo. Camera person probably needed to pack up. He's a union. All done. Resumes tomorrow. Alan, are you being straight with me? Okay, yeah, they just took the verdict clock down. Okay. All right, well, you know what? I will, Broken Baker actually interviewed Kevin Yellow Cottage Cheese the other day about his book, and boy, what a train wreck that was. What a train wreck that was. Best courtroom, jury, movie, or series. Oh, that's great. I mean, what a great question that is. And I'm a big fan of, what was the one? I mean, who doesn't like Aaron Brockovich? I like that. I mean, who doesn't like A Few Good Men? Who doesn't like, what was the one with Tom Cruise? It was a John Grisham novel that they made into Runaway Jury, one of those John Grisham ones. Let me think about that. But you guys can in the chat and put your votes in. And Mange, nothing to see here. I have a great idea. You should use bingo balls to pick members that could do a Zoom with you to talk about the county retrial on off days for like an hour. That's a great idea. We could do like we could do as like a StreamYard has a thing that we do when we do like giveaways for merch and stuff. They do have a way where we could spin the wheel and people could be like entered into it. We could do that. That's a nice idea. But we're not going to have like off days very much. I am going to be on Friday night with AV to the Seventh Power. I'm going to go on her show on Friday night, so look forward to that. Apparently, Lori kicked off in court. They got in trouble for the hot mics. Law and crime is down, yeah. But we heard they're coming back tomorrow. Go follow Kathy from Gossip Rumor and Innuendo. I have her linked below in the show notes. Tomorrow's a big day for me with one of my kids, so I'll be in and out. If I do anything, it might be from my car. So that is the thing. But, it's a big day, so I got to do what I got to do. I'm a mom first, and I'm a YouTuber second. So that's the deal. Thank you to the moderators for keeping it classy today. You guys are awesome. Love you with all of my heart. If I don't see you soon, I'm going to die. We'll see what happens tomorrow. And do all the YouTube-ish things, would you please? Hit the like button, comment respectfully, share the stream out. I would call Kevin. Maybe Kevin Reddington would have a show. Like I have a show. I mean, maybe he'd come on the show after the verdict. Maybe he would. Although Jennifer McCabe might get really mad at him if he came on my show, but it's worth a shot. All right, my friends, stay cool, stay kind, stay classy until I see you again real soon. If I don't see you soon, I'm gonna die. Peace. Hopefully we'll have a verdict tomorrow, but if it's not tomorrow, then I'll be here Friday, so we'll make it happen. Peace. Have a great rest of your evening.